time no see. I'm Yuval of Innovate AI, and it's my very great pleasure to welcome you to this second day of conversations about the work and legacy of the late Justice Antonin Scalia. We started yesterday with some fantastic conversations about the justice's work and views, about the separation of powers and the presidency, about his personal influence, including on a number of his clerks who have gone on to be judges themselves. We continue today by taking up Justice Scalia's legacy in a number of further areas, as a champion of originalism and textualism, as an interpreter of the religion clauses. We'll think about his influence on administrative law, and we'll think about Justice Scalia as a writer, which was, of course, always such an important source of his influence. But we start this morning, as we did yesterday, by hearing from one of Justice Scalia's former clerks who has gone on to do enormously important and significant work in the service of the law and of the country. Danielle Sassoon will be in conversation with AI's president, Robert Doar. Let me just say a word about Robert, and he'll introduce Danielle. Robert Doar has been AI's president since 2019. He was a scholar here for about 5 years before that, launching a lot of AI's work on opportunity and mobility and fighting poverty. He had a long career in public service before that, driving important and challenging reforms at leading public service agencies in New York at the city and the state level. His leadership here at AI has really emphasized the necessity to defend and revitalize core American institutions. I certainly came here because of him, and a lot of other scholars that he brought here have been people who have worked on the questions that are exactly those that we're taking up today. The condition of core American institutions and how we might think about strengthening our constitutional system. That kind of focus is a lot of the reason why AI has, I think, become a center of conversation about how to revitalize the American system of government. And we're all very grateful to him for putting those back at the center of the action. With that, Robert, I'm going to turn it over to you and Danielle. Thank you all very much.
Thank you, Yuval, and thank you all for being here. I was here for a lot of yesterday, and thank you, Ed, and all of the people that have put this on, the federal judges and our AI staff and the law experts. I really enjoyed it, and it was just so inspiring to be in a room where we were celebrating and talking about a great leader who really had intellectual firepower and whose ideas have had such tremendous influence on our country in a positive way, and whose example of public service and being a good judge, being a good Supreme Court justice is so exemplary and so positive. I really loved every minute of it. I have to say, I come to this as an amateur. I'm neither a lawyer nor a political scientist, but I am among those who was referenced yesterday about his desire to communicate outside to the country. And I'm one of those people that follows the opinion of some who've said, if you want to understand the court, you have to read the opinions. And I read the opinions and have been influenced by the opinions. And of course, Justice Scalia wrote marvelous opinions. And so I hope you'll forgive me if, as I go through these questions, I have kind of an aw shucks, I'm not a lawyer, but what about this type questions. And with us today is Danielle Sassoon, who's someone who we've admired so greatly over the past few years. She's a Harvard Law School graduate, Harvard undergraduate, Yale Law School graduate, clerk for Justice Scalia, worked in private practice, then went to the U.S. Attorney's Office in the Southern District, briefly was in charge of the Southern District, prosecuted some important cases, and is now a partner with Clement and Murphy. Danielle, thank you for being here.
Thank you.
It's a great pleasure to have you. Now,
my privilege to be here.
Yeah, what I'd like to do is to get into your sense of working with the justice and his behavior, his practices, his leadership through cases that you worked on while you were a clerk. And the three that I've selected are Windsor, Fisher, and Shelby. And I'm going to just start with the Windsor case, which was a Defense of Marriage Act case where he wrote a very strong dissent to Justice Kennedy's majority opinion. And the question I have for that one is just, if you read that, this is where there's a sentence where he refers to Justice Kennedy's reasoning, and he says, that is jaw-dropping, period. Later, he refers to something that Justice Kennedy had written, He says the majority must have in mind one of the foreign constitutions, and he refers to the German constitution that would be more applicable in this case.
And don't forget Argle Bargle, I think is from that dissent.
And another point he says, he refers to the majority opinion, he says that is incomprehensible. And so what I want to know, in the atmosphere of the court, in the atmosphere, how do you communicate these writings to the clerks and the justice in the other chamber? Do you slide it under the door and say, or do you send it over with an email that says, boy, your boss is really going to love this? What's happening there? How does that happen?
The judges yesterday got the softball questions, and I'll take this one. So I clerked for the justice towards the end of his time on the court, which had a lot of benefits, including that by then certain dynamics were well understood and well established. So Justice Scalia and Justice Kennedy had a very nice interpersonal relationship, but it was no secret that Justice Scalia was not going to pull any punches in his writing, and that his judicial style was different from Justice Kennedy's in terms of their writing style, and also, of course, in terms of their judicial philosophies and their interpretive methods. And that dissent showcased a lot of those things. I think the dissent walks through, is this a federalism opinion? Is this an equal protection opinion? Is this a dignity opinion? And in the writing expressed some of his frustrations in terms of interpretive methods. But interpersonally, it was always amiable and respectful, and they had a nice friendship, as he did with the others on the court.
Who gets the last word? Sometimes the majority refers to the dissent, and then does the dissent get to refer to the referral to the dissent? I mean, when does it stop?
It can go many rounds, but it ultimately reaches an endpoint. What I think is interesting, if you look at that dissent, it shows kind of two themes about Justice Scalia that actually might seem to be in tension, but are not. So it's a very fiery dissent. But at the end, one of his points about why this decision should not have been rendered by the court was that this is a judgment for the people. And he talks about how the majority opinion shortchanges the political process, and in the process overlooked that when you have these highly charged debates, there are good people on both sides. And he says, it's hard for the majority to admit that one's political opponents are not necessarily monsters. And when looking back, that really resonated for this particular moment, that the fact that he was extremely pugnacious in his dissent is not inconsistent with the fact that he actually was a model for how to have disagreements about highly charged issues.
At the end of the dissent, he does have that kind of reference to the broader culture, and there's a little bit of sort of sense that Justice Kennedy's opinion will be popular in fashionable circles. This will go over well at the New York Times. Did he have a little sense of sort of wearing that out-of-fashion aspect of his jurisprudence as a badge of honor? Was there a little, or not, or am I imagining that?
Absolutely, and I think that is a value that was passed on to the clerks. So when I joined the Scalia clerk family, I did not necessarily see myself as fitting in with what I saw as the model of the Scalia clerk, which was in the model of the justice, intellectually fearless, combative, ready to go to the mats on issues, punchy and witty writing, logically extremely consistent. And when you're in that environment and with those co-clerks and with the justice, you imbibe that intellectual courage and the view that, I'm here to serve the law without regard to what is fashionable, popular, what is going to get me plaudits in the New York Times.
And a marvelous quality, because if you stand your ground, the world eventually comes around to you.
Sometimes.
And that's the way it looks to me. And that relates to the next case I wanted to ask you about. And again, he wrote a one-paragraph concurrence in the Fisher case because it reached the outcome that was satisfactory to him, but it didn't go far enough. This was a college admissions, racial preferences in college admissions case. Tell me a little bit about your memory of that, and also your sense of, ultimately he prevailed. Isn't that correct?
So in that case, the court did not go all the way in revisiting whether affirmative action was constitutional, in part because it had not been properly preserved by the parties. So my recollection of the concurrence is that he said, I joined Justice Kennedy's opinion, which said, the court below didn't apply the proper standard of review, but I reiterate my view that this is unconstitutional, kind of signaling it's not preserved here, but this is something that we should revisit down the road. And this is just one example where one of his dissenting views was vindicated over time. And people often ask, why did he always feel the need to dissent? Why put these things in writing when it's not the prevailing view of the day? And one rationale was, I'm putting this into writing for the future generations of lawyers so that they have memorialized the correct articulation of what the legal principle should be, in the hopes that maybe it is vindicated down the road. And I think that model is important, not just on the particular legal issues, but again, as a model for the kind of discourse we should be having in the law. I think, yes, affirmative action was overturned, but I think he would be dismayed by some of what has been going on campuses, not just in terms of treating people by racial categories and thinking about people in terms of their groups and oppressor and oppressed and that sort of thing, but also in terms of the deterioration of debate on campuses and even among faculty. I was reading something recently that was describing the phenomenon of pluralistic ignorance, which is the idea that if you hold a dissenting view and people are not vocalizing it, you can come away with the misimpression that you are the only one who holds this idea. And over time, that means that people silence their dissenting viewpoint or misrepresent it publicly for fear of social ostracization or social repercussions. And what then happens is you have an illusion of consensus on what are actually contentious issues, and you also raise the social cost of expressing dissent. And I think he would be horrified by that, and so much of his work was counteracting that in terms of his own actions, but also setting a model for his clerks and students about how to express disagreement.
And again, this is one of the aw shucks questions, which is maybe I shouldn't ask, but in that case, the justices go in and they discuss a case themselves without clerks present. Justice Thomas and he must have tried to carry the day in that case. How do you find out that he lost?
So in the affirmative action case,
or
he
any case,
didn't lose. Sure. So after conference, you learn the votes and you get your assignments.
Yeah.
So we're in the majority here, but it's going to be written by Justice Kagan. Yeah. We're in dissent. We're going to actually write something. Often in dissent, he would write no matter what, even if someone else was writing, because he had his own particular perspective.
So he just comes back. But there isn't a sort of come storming out. I tried really hard. Those sons of guns didn't go along with me.
I think this was said yesterday, but I think the clerks often took it harder than he did, especially at that phase where he had suffered a lot of losses and gotten used to the rhythm of the work, and the clerks took it really hard on his behalf. There were times when he would be momentarily very frustrated. There was an occasion where we were actually joining someone's dissent, and we received a copy of the opinion, and he came storming out of his office, and there were, pages crossed out of this draft, and he had no gripes with the content or the principle, but he said, this is way too long. I can't join an opinion that is this long, because he valued being succinct, and he said, tell this justice that we're not joining the opinion unless it's cut down by half. But then he would kind of cool off and he'd say, okay, you could join the opinion. Or other instances where he would, write an extremely fiery letter, and we'd say, why don't we put that in the drawer for the afternoon, and come back to it, and he would inevitably cool off and be back to his very upbeat, cheery disposition that was his usual resting state.
Very intellectual fire, but a lot of very exciting chambers.
Yeah.
Okay, last case of the ones that you were on is the Shelby case, big case. the chief wrote the opinion. He doesn't write it all. I'm curious about the relationship between the Chief Justice and him. He came on after the justice had been on the court for some years. He's senior to him, but Justice Roberts, younger man, is now kind of his boss. How did he accept that? How did he accept a new chief who wasn't himself?
I saw no indication that he had any difficulty at all accepting that. And I think he was well suited to the role of an associate justice because he could do his thing. It wasn't his job to be building consensus. He got to write what he wanted. In a way, he was happiest in dissent because he didn't have to get the sign-on of other people, and he flourished in that role. And he also, I never got the sense that he was attached to being the person to write a particular opinion, perhaps also because he so often was able to fully express himself in some form or another on the important cases because he had a particular interpretive approach.
Well, you raise a question there that is interesting. Was he ever in a position where he was trying to achieve consensus and had to make concessions when he had the majority opinion?
Sure. When you're the majority opinion author, you will get comments, and as long as you feel you can accommodate them while staying true to the rule you're articulating, that's a very common practice.
All right. So he wasn't it wasn't like he couldn't do it if he had to.
No.
All right. Okay. All right. So now I want to bring up a case you were not on, but was a lot of discussion of yesterday in the various panels, and that's the Morrison case and the dissent in that case, which was early in his term. One of the things I was struck by yesterday in all the emphasis on the importance in that case for establishing the president's authority over the executive branch and over the Justice Department, which he felt very strongly about, was there wasn't much discussion of why he felt so strongly about that. And the reason he felt so strongly about it was because he felt that federal prosecutors working for the president could be held accountable by the political branches in the political process. And so he has these words: if federal prosecutors pick people that they think they should get rather than cases that need to be prosecuted, if they amass many more resources against a particular prominent individual or against a particular class of political protesters or against members of a particular political party, then the gravity of the alleged offenses or the record of successful prosecutions seems to warrant, the unfairness will come home to roost in the Oval Office. And I just wondered, does that sound familiar to you?
So absolutely, especially in terms of just articulating some of the principles that should guide righteous prosecutorial discretion. And I don't know if he's quoting Robert Jackson in that entire paragraph.
A little bit of Jackson, but a lot of his own language.
The coming home to roost is his own. But he does quote Robert Jackson extensively in that opinion about the enormous power wielded by a prosecutor and the principles that should guide it in terms of targeting crimes and not people, not abusing the power to target political opponents. But let's just stick with that again. I have another point on that section in this opinion, which I want to get to. But before that, just so we're clear, the solution for that kind of prosecutorial behavior is what? So in his opinion, he outlines the reason that he has an issue with the independent counsel statute is that the prosecutor is not operating at the direction of the executive branch and cannot just be removed by the executive. And he says it's important for that power to reside within the executive branch so that the president can remove U.S. attorneys, and also so that if the president is exercising prosecutorial authority in a way that is ultimately not fair or is not operating non-selectively or is out of proportion, that it will be the executive who pays the political price rather than that accountability not residing in the branch where it's supposed to reside.
Right, so that the solution is the political price, whether through Congress acting in some way, I suppose ultimately impeachment, or a next election. That's really what he's talking about. They are accountable to the people, and if you want that to be addressed or resolved, turning to the court necessarily or hoping it'll just go away is not the answer. It's a political It's a political act.
Yes, and I don't want to presume to say what he would have thought about this or that issue today.
Yeah.
But what I will say is that portions of this opinion were quoted back to me in the course of my leaving government. And I can speak from my personal experiences for the justice that the unitary executive theory is not incompatible with individual public servants still exercising their own judgments about what their professional and ethical duties are and whether they can continue in their role. So looking back, Ryan Walsh, who was a fellow Scalia clerk, in his remembrances about the justice after Justice Scalia passed away, recounted how Justice Scalia told him and his fellow clerks that you should never take a job that you will not be prepared to resign from based on your principles. And you should always have a plan B. And that is something more broadly that was a big part of the clerkship, that this was a person with incredible power and accomplishment at the height of the legal profession, but who lived a very principled and moral life, which was kind of his overriding value beyond being a Supreme Court justice. And that manifested in terms of his family life, his relationship with God, his love of people and friendships and food and wine and opera. You know, his life was much richer than just the job. And I remember he had hanging in his chambers a portrait of Sir Thomas More. And that idea was definitely relayed throughout our clerkship, that worse to lose your morals than to lose your position of power. And so I think invoking Justice Scalia to say the unitary executive theory means that you have to do what you're told and have no prerogative to walk away, I feel confident that that does not represent his views.
I would also add, just for the fun of it, that yesterday in the conversations about this case, there was a lot of discussion of the overreach of Congress post-Watergate in infringing on the powers of the executive that need to be redressed. And when it's said that way, there's kind of a condemnation of all that took place with regard to Watergate. But I would note that right after Justice Scalia says the unfairness of that excessive prosecutorial behavior, that use of executive power in a way that infringes on liberties and that crosses and abuses power, he says, right after he says, the unfairness will come home to roost in the Oval Office. And then he says, I leave it to the reader to recall the examples of this in recent years. That result, of course, was precisely what the founders had in mind. Now, I read that as, well, Congress may have overreached post-Watergate, but what happened with regard to the response to the offenses of the Nixon administration was what he thought the founders had in mind. Now, this is, I'm stretching a little here on your ability, I mean, not your abilities, but maybe I'm putting you on the spot, but is that a fair reading?
I think he had tremendous respect for the political process. And so whether or not that would be his preferred outcome of the political process, he had respect for the political consequences that were consistent with the structure.
And then just one more question on this, or I may have more, but this didn't come up yesterday. Maybe it did when I was outside the room, but we have a scholar who's affiliated with AEI, Jack Goldsmith, who, in commenting on some of these things that are going on now, is using a phrase, lawful but awful. How do you respond to that?
Without having read exactly what he was talking about, I'll go back to talking about Justice Scalia.
Okay. Okay. Well, I don't think that phrase that Jack uses was quoted yesterday, and I felt it was necessary that it get into the record of this conference. So I've accomplished that.
Great.
Okay. Anything more on this issue? You know, let's just put it out there on the table. Is there anything more about your experience? You're very, you know, I think brave and strong experience in the way you handled your leaving the U.S. Attorney's Office. that you want to say about that in relation to what you learned from Justice Scalia, both how to be a public person, how to be a lawyer, how to be a U.S. attorney?
So many things. One, from day one, there was a real lesson about reverence for our governmental institutions. So he never yelled at us, but on our first day, he called us into his office, and we all sat on the couch, and we thought it was going to be, a warm welcome to the clerkship. And the first thing he said was, "If you betray the confidences of this court, I will destroy your careers." And that was kind of the harshest thing he said the entire year. And then he pivoted back to, "And welcome to the court, and we're going to have a great year." But that was something that needed to be said, and that was something that he really exhibited, just a love of the court and the institution and his colleagues, even when he didn't agree with them. Another was modeling how to have disagreements, to vocalize dissent, while also having really warm professional relationships. So it's been talked about, his relationship with Justice Ginsburg and the friendship that they had. I remember when we went to her chambers for tea, and we said, "Can you explain this to us?" She said something along the lines of, "In short, he makes me laugh." And she said, "I've had times when I've had to pinch myself to stop from laughing in contexts where that would have been an appropriate thing to do." And that was him. He made people laugh, and he respected the person even where they had their disagreements. And then, like I mentioned before, there was a real intellectual courage to him and to being in that environment with the alumni clerk and the fellow clerks who, didn't fear the judgment of others if they felt like they were doing what the law required and following the methodology that was demanded. And that had a very lasting impact.
What about, he was a former official, a high-level official in the Justice Department. What about that as a path for a career and a respect for that institution? Did he have a great sense of pride in having been in the Department of Justice and the role of lawyers in the department?
Definitely, and I think he was very proud of all his clerks, but he had clerks who had become judges and who were serving at various times in the White House, and he took a lot of pride in that in the same way that it was spoken about yesterday, how important it was to him to connect with law students across the country.
I once was in a conversation with someone who was like you, an assistant attorney in the Southern District, and he said to me that the power of the U.S. attorneys in these large federal prosecuting offices is so overwhelming against whoever they decide to go after. And in this opinion, there's a reference to the power. Did he have in his sort of champion of the little guy, did he have a sense of that and a concern about that?
Well, one manifestation of that was his criminal procedure jurisprudence. He had a lot of Fourth Amendment decisions that cut back on the power of law enforcement to conduct searches without a warrant. And
you had the swab case.
We had the swab case where he had a very vigorous dissent in favor of criminal defendants. And so you definitely see that strain in his jurisprudence that restrained the power of law enforcement in one respect.
Okay, so we maybe haven't done enough of the fun character of the justice stuff that everyone loves, but do you have something about that some good story, some memory that you're particularly close to you?
Many, none, a lot of little vignettes. Every clerk would go out to pizza with the justice, but by the time I clerked, his favorite pizza spot had closed, and we would go to this place called Red Rocks, which is probably unfamiliar to the more senior law clerks. But those were really special moments where we got to just talk to the justice about all aspects of life, and he would order his pizza and his wine, and I remember he would take the red pepper chili flakes and pour them into his hand and lick his finger, and he would be, licking the chili flakes one by one and expounding, on a variety of things, including grammar, which is a favorite topic. If we ordered a tiramisu for dessert, he would say, tiramisu, and he would say, that means pick me up in Italian, and, there was always something like that, or he would pick a phrase, tickle my fancy, that's falling out of use, let's put it in an opinion. Or he would say, like, duplicative, and he would, roll it off his tongue like Sylvester the cat, and, he was just very funny, very larger than life in that way. He would tell us that we were fungible, which we definitely were, but he would make that joke, that we were all fungible, and he definitely could do the job without us.
What does that mean?
Like
I don't need you.
replaceable, I don't need
Yeah.
you, but he would say it jokingly, but we'd kind of look at each other and say, it's kind of true, but does he really think that? And one day, Charlie Rose came to interview him about his treatise, and they had a whole conversation, and then he made a joke to Charlie Rose, these are my law clerks, they're all fungible. And later in chambers, he said, I wish I hadn't said that. He said, I'm joking, but I don't know if Charlie Rose knows I'm joking, and I'm sorry that I said that, which was a very kind of tender moment.
I've just read the other day the Justice Barrett's book about the law, and she's got a lot in there. She's a former Scalia clerk as well, and I can't recall what she said, but I want to ask you this. Who writes the first draft?
So the law clerks helped draft, but you can tell from reading his opinion that
it's him.
That
well,
it's him.
It's clearly him. But,
it's him, and the law clerks, would try to imitate his style, and
okay.
it inevitably fell short. And
Yes.
then you would see he would take it, and I wrote about this when he passed away, but he would sit at his desk, sometimes with a cigarette, and he would just spin gold out of these clunky sentences that we had given him, and it would be really exciting and fun to get the draft back and see how it had been transformed by him.
There was
I will say, though, that he never faulted us. He was never condescending about it. He was so brilliant, but after every oral argument, we would go and sit on his couch and talk about the cases and debate with him. And even though he was on a totally other level, he didn't engage with us in that way. It was very like, let's have a discussion, let's have a debate. I'm going to decide what I think is the right outcome, but I'm going to hear you out. I'm going to take what you're saying into account. I'm going to debate with you. And that experience as a young 20-something lawyer, to then go from there to appearing in front of judges, to having disputes with opposing counsel, to speaking up to other bosses down the road, was incredibly formative.
Well, did you ever have a real, I mean, there was a lot of discussion. One of the judges said that, he expected you to disagree with him and to fight with him. How about you? Did you go toe-to-toe with him on something, and what was the outcome?
I did. It was later in the term. We had a discussion where we thought there was kind of consensus about how he was going to vote on a particular case, and that position would have put him in the dissent. And he came back from conference and said, it's unanimous, and I joined the majority. And we were beside ourselves, and we thought, how can we change his mind, not because we prefer this other outcome, but because we think this other outcome follows most coherently from other things he has written on this topic. And when we were clerks, we had the benefit of, he had written about everything. So on any case, you had the benefit of, okay, what does he think about the Fourth Amendment, the First Amendment, this issue, that issue? So went in there, pushed him on it, and eventually he said, okay, I'm gonna write a dissent. And we worked on the dissent, and there were multiple points along the road where we continued to butt heads a little bit. Mm-hmm. And at one point, he kind of threw up his hands, and he was like, "You're impossible to please." And he was kind of frustrated.
Someone else has said
me.
that about you,
Yeah.
Danielle.
And I left work that day, and I was with another clerk, and I actually cried. I said, I think I went too far. I think I upset the justice. I think he's annoyed with me. And I came back the next day, and he was business as usual, and we continued to work on the opinion, and he was very good-natured about it. And learned from that that's just part of the process, and you sometimes go through these disagreements to get to the best result. And I think he was very happy with the ultimate dissent, and someone else actually joined it, and so that was very gratifying that view ended up memorialized.
Chris Scalia told me yesterday that at the end of the term for clerks, they would take over their favorite opinion or the opinion they're most proud of and have him sign that, and he would he encouraged that. And you confirmed that earlier. What was that about? What did you bring over, and why? And why were you? What was? Can you give us a little sense of that?
So the opinion that he signed for me was a case called Smith, and it was a criminal law opinion about the law of conspiracy and statute of limitations. And so it's probably a case none of you have heard of, but it was, I believe, a 9-0 opinion, very tight, with the justices rewriting, in my view, a very elegant opinion. Mm-hmm. And I had this interest in criminal law. But in a way, we've talked about Windsor and Shelby and Fisher. Working for Justice Scalia, in a way, those were the easy projects to work on because the justice had expressed a view in those areas. Yeah. It was easy to anticipate what his interpretive approach would require in those cases. But most of the cases we worked on were more challenging in that, okay, you have this textualist methodology, but you're interpreting the Indian Child Welfare Act, and what does this complicated statute mean if you're interpreting the plain text? And cases like that, which maybe were less headline grabbing, but were a little bit trickier to work on.
As you know, here at AEI, we view all individuals as individuals and not representatives of any class or race or gender. Everybody's different. But so I'm going to ask a question that goes against that a little bit. The community of clerks for Justice Scalia is quite wonderful. It's a lovely thing. And there were very prominent women clerks, Justice Barrett, there were judges from yesterday, Judge Kovner, yourself. Would you say that the men and women clerks had a different relationship with him in any way, or was it all individual?
So he treated me like everybody else in terms of the expectations of rigor and how he talked about cases, but he also would say, Danielle, you have a civilizing influence on this chambers.
And you thought that came from your yes, femininity?
Yes, it was very clear that that's what he meant, and I appreciated that. Okay. I also, he has a nice cohort of former clerks who are Jewish, and we had a very meaningful relationship on that level too, as two people of religion. And he's given a lot of speeches, and one of the speeches that is most meaningful to me and is in his book, Scalia Speaks, is a speech he gave in the 90s on Holocaust Remembrance Day, where he talked about how one of the important lessons from the Holocaust is, if you look at Germany at that time, it was one of the most sophisticated, erudite, cultured, intellectual countries at the height of science and the arts and higher education, and yet it was capable of this incredible depravity. And so one of his themes that he echoed in other talks too, and quoting his father, was, you can hire brains by the hour, but character is not for sale. And in the context of the Holocaust, he said, what's our obligation now? It's to make sure that we are conveying to our children that there are certain kind of absolute, uncompromisable standards of conduct that have nothing to do with how accomplished you are, how powerful or successful you are, but that are what is necessary to preserve a good society.
That reminds me of our chairman, Dan Daniello. We were in the Daniello building as a prominent Washington resident and citizen, and he likes to tell a story about he was, had a little extra time one night, and he was an opera lover, and he went over to the Kennedy Center because there was a good opera playing, and he got there, and the people knew who he was and recognized him and said, Mr. Daniello, we want to take you to a special box. He said, no, we want to take you to the special box. And they go up and they open the door. There's only one person in there, and it's Justice Scalia. And they watched the opera together. It was really
So nice.
a great moment. So, okay, let's open it up for questions from the crowd. I don't know that I've asked all the best questions, but maybe there's some good ones out there for Danielle. Oh,
Sounds like you've asked
Adam
them all.
White.
Thanks, Danielle, for joining us today. You already remarked on Justice Scalia's appreciation of the power of a prosecutor, the famous speech from Attorney General Jackson. I'm curious, when you were in that office, not even in major cases, but in the more relatively mundane cases, you're making enormously significant consequential judgment calls. And I'm curious how working with Justice Scalia what it taught you about thinking through those kind of difficult judgment calls.
Sure. I mean, one is the benefits of a collaborative approach to major decisions. So one thing about the U.S. Attorney's Office, at least at SDNY, is that you get kind of thrown in right away and you're handling cases off the bat. But someone is accompanying you the first few times you do something. And then you have supervisors who you have to approach about kind of significant decisions, including swearing out search warrants or charging a case. And so the decision-making environment is very collaborative, where you're thinking through complicated issues with other people. And that was an exercise that had been such a big part of the clerkship, kind of thinking through difficult issues, first with the clerks, and then having an opportunity to do that with Justice Scalia. And so up until my last days at that office, I benefited from kind of crowdsourcing ideas and information. And then when you're in a supervisory role, you ultimately have to make the judgment call. But I do think it's helpful to have other people you're working with whose judgment you respect and who have experience with complicated cases to discuss things with.
I'm reminded of a question I had from yesterday, as I see Akil there. Yesterday, we had that remarkable remark by the federal judge who was with him early in his term, where the justice acknowledged that he did prefer to hire clerks from the really great law schools in our land. That was then, but time has evolved, law schools have changed, and you're a Yale Law School graduate, and there's some chatter among you lawyers that a Yale Law School education is not the same as a Harvard Law School education. Did he have a sense of that? Did he?
Oh yeah, he didn't. He was very clear that he disfavored Yale, and that was because Yale doesn't have grades in the same way that Harvard Law School does. Okay. I don't know if those grades are as meaningful now, given the grade inflation that has taken over so many of our schools. But that's why I don't think anyone applies to the Supreme Court confident that they're going to get a clerkship. I certainly wasn't. But in particular, getting hired by Justice Scalia seemed very out of reach for me because I had gone to Yale and because I didn't see myself as confident as some of these other clerks who preceded me. But I was lucky that Judge Tableson paved the way and was Justice Scalia's first Yale hire in many, many years. And, then I was able to slip in.
Okay, all right. Yes, sir, here. Wait for the mic.
Thank you. Gerald Chandler. Would you elaborate on your statement that prosecutors have enormous power and can ruin a person's life? And would you give an example, for example, if a prosecutor went after Antonin Scalia, would he be able to resist?
Well, he was unimpeachable, so I would like to say yes. But, even the specter of charges or the publicity of an investigation obviously has enormous consequences for somebody's life, and so those steps should not be taken lightly. And the function of the job certainly depends on people of good judgment and good faith exercising those powers.
Have one more? Yes, sir. This will be the last one.
Keith Whittington. So I feel burdened. It's the last one. So just about the clerkship experience itself. So as you noted, Scalia did a lot of speaking engagements, wrote books, as well as obviously the core work of the court of drafting opinions and the like. How much were the clerks involved in that kind of material, and how did your office and the clerks think about the relationship between working on opinions and the like versus the other activities Scalia was involved in?
Sure. So the majority of the job was working on the cases before the court, including also reviewing the cert petitions and making recommendations to the justice pool about whether to grant or deny a cert petition. Justice Scalia, the year I was there, did do some speeches. One of my co-clerks helped him with an initial draft of a speech and was so good at it that he kind of took up that mantle for the rest of the year. So I never assisted with preparing any of his speeches, but what we did do was try to go to his events when they were in DC. We would say, hey, can we come watch your Charlie Rose interview? Can we come to, I think he had an event with Nina Totenberg that year that we went to watch, because in our view, part of the benefit of the year was just spending time with the justice and seeing how he approached the cases, but also public speaking, public responsibility, how he lived his life. I remember, this isn't really an answer to your question, but when I think about my first interactions with the justice, you start the clerkship in the summer, and the justices are usually traveling during that time, and some of them go to teach abroad. He had some fishing and hunting trips that summer, and I remember he was going to be traveling, and I had kind of my first substantive matter with him, and he said, okay, I'm going to be traveling, but I'm going to call you on Saturday to discuss this. And I said, okay, do you have a sense of what time on Saturday so I can make sure that I'm available? And he said, I don't live my life that way. If I call you and you answer, great. If you don't pick up, that's also fine, and we'll find another time to talk, which is a very different vibe than some of the workplace environments today. And my recollection is that he didn't call that Saturday, and that I had hung around the phone just in case he did. And when he did call, I picked up, and he said, it's your nickel. And I said, what? He said, it's your nickel. And it took me a minute to get my bearings and realize that meant I should just start talking about the case. And then we were off to the races.
Well, thank you very much, Danielle. It's been a great way to start the day.
You all take your seats. We'll be ready to start with our next panel. Thank you all. I'm Ed Whalen with the Ethics and Public Policy Center. Welcome to this second day of this symposium on Justice Scalia's legacy. I'm delighted to have with us a great panel on originalism and textualism. I will introduce our moderator, who will take it from there. Jeffrey Sutton is Chief Judge of the U.S. Court of Appeals for the Sixth Circuit. He's been an outstanding judge in that court since 2003. Judge Sutton and I clerked together for Justice Scalia in the court's 1991-1992 term, along with Judge Dan Collins of the Ninth Circuit, who was with us yesterday, and I'm sure will be here soon. Jeff and I actually arrived at the court for our first day as clerks on the very same day. I think Jeff was the first person I met. It must have been a few days later that Jeff indicated to me that he was interested in doing a second clerkship in Justice Scalia's chambers. He actually had been hired by Justice Lewis Powell. I'm very glad I did not blow him off. And Jeff has kindly put up with me ever since then. So, Jeff.
Thank you, Ed. I'm glad you didn't blow me off. You have given me a lot of hard times ever since, however. But thank you to AEI, Ed, EPPC for bringing this great group of scholars together. I think the Justice would be thrilled with this. He'd be in the front row and interrupting us constantly, I'm quite confident. So this panel's on originalism and textualism. It's a tricky business to aspire to be a government of laws and men, a government of laws and not of men and women, but then to delegate power over the meaning of all federal law to 9 men and women. That's particularly challenging when it comes to federal constitutional law. No country in world history, to my knowledge, has combined these 3 features of federal constitutional law: frequent exercise of judicial review, the power to make democratically enacted statutes or executive branch orders unenforceable, a power exercised by 9 life-tenured and unelected justices with respect to a constitution that, practically speaking, cannot be amended. When Justice Scalia joined the court in 1986, he thought that textualism and originalism were the only answers to this conundrum. Now, we have an audience of a lot of generalists. Textualism is usually referred to as a method of interpreting statutes. Originalism, usually referred to as a method for interpreting constitutions. But they both come to the same idea. Words have meaning, and judges have authority only to enforce the publicly understood meaning of that language, and that meaning is fixed. I think Justice Scalia also thought that that was the only way to properly exercise the judicial power. That's what lawyers and judges do, and that separation of powers reinforced that idea. Now, the principles of originalism and textualism are easily stated, but can be quite complicated in practice. And one way to illustrate that is to imagine asking a PhD student to assess how federal judges interpret the federal Constitution, and the only body of evidence they're given for that project is confirmation hearings of U.S. Supreme Court justices over the last 40 years. If all they could look at was what future justices said at their confirmation hearings, that PhD student would write a paper that said, well, this fellow Scalia clearly triumphed. All anyone is talking about is a form of textualism and originalism. These words are fixed, and judges do not have authority to go beyond the publicly understood meaning of these words. Now ask a second PhD student to do a project on how federal constitutional interpretation works, but this time, the only body of evidence they have, we'll say again, over the last 40 years, is decisions in the US reports. Very different story. That student would say, well, yeah, this fellow Scalia seemed to be on top in a lot of cases, but I have to acknowledge there were plenty where he wasn't on top. We have 4 terrific speakers to try to deal with these problems and related problems, whether it's statutory or constitutional interpretation. And here they are in the order in which they're going to appear. John McGinnis from Northwestern Law School, Joel Alicea from Catholic University, Keith Whittington from Yale, and Akil Amar from Yale. Each one's going to have about 10 to 12 minutes to speak. We'll have time for Q&A afterwards, and why don't we start it off? John, you can go first.
Very grateful to be invited here today to speak about a trailblazer in originalism. I think Justice Scalia reoriented the entire originalist enterprise in a speech 40 years ago when he moved it from the original intent espoused originally by Attorney General Meese to the original public meaning now dominant today, the meaning that is understood at the time the Constitution was enacted. Today I want to focus on the prime reason Scalia gave for this change and argue that it remains the most important foundation for originalism today, one that resolves confusion, and sometimes perhaps some confusion even in Scalia's own work. I'll make three claims. First, Scalia's turn from intent to public meaning rests on a deeper methodological insight into authoritative sources. Second, that insight helps resolve uncertainty about whether constitutional meaning is lay or legal. And third, it answers a common objection that the Constitution lacks any required interpretive method, and that originalism is just one of many methods that has to be evaluated, that must be made on some normative ground of interpretation. Scalia made a variety of arguments against original intent in that speech, but one, he said, was the trump. Reference to substantive intent was not, quote, an authoritative source for interpretation at the time of enactment. Since intent was not deemed the appropriate way to determine the constitutional meaning then, it should not be used today, he said. Let me generalize Scalia's key methodological point. Constitutional meaning is empirical and interpretive all the way down. It is fixed by the interpretive practices that existed at the time of enactment, not by our present views about what methods would be best. Meaning is wholly positive, not normative. This proposition has large implications for important debates that still roil originalism, and on which Scalia himself touched. Begin with the question of whether the meaning of the Constitution is lay or popular meaning or legal meaning. Scalia is often thought to favor legal meaning, but this claim is based on a single passage in D.C. versus Heller, where he says, quote, in interpreting this text, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary as distinguished from their technical meaning. Normal meaning excludes technical meanings that would not have been known to ordinary citizens. But this language creates something of a puzzle, because Scalia also favors applying a long list of interpretive rules to fix meaning, including interpretive rules like the absurdity rule and the rule of lenity, rules that are cast out in law and whose scope and indeed whose existence may not well be understood by the lay public. Indeed, in Heller itself, he applies a legal rule that says a preamble does not change the meaning of an operative clause to interpret the relation of the preamble of the Second Amendment to its operative clause. Moreover, in Crawford versus Washington, he pinpoints the application of the confrontation clause by reference to the common law of England, something that laypersons wouldn't recognize. And he gives a justification for this approach in his book, his treatise, Reading Law. Here he says, sometimes context indicates that a technical meaning applies. Where the text is addressed a scientific or technical subject, a specialized meaning is to be expected. And here's the key passage. And when the law is the subject, ordinary legal meaning is to be expected, which often differs from common meaning. In my view, we need to take Scalia's reference to authoritative sources seriously to resolve the question. We can determine whether the Constitution is written in lay language or the language of the law only by looking at the sources of the time. And the most important source, of course, is the Constitution itself. The evidence that the Constitution is written in the language of the law seems to me overwhelming. First, the vocabulary of the Constitution is saturated with scores, and possibly hundreds of legal terms and phrases that would be unfamiliar or perhaps misunderstood by a layperson, far beyond just a few isolated examples. Second, the Constitution embeds legal interpretive rules within its framework. For instance, consider the phrase, notwithstanding any other law in the Supremacy Clause. That's a so-called non-obstante clause that was familiar from the common law. That clause told judges to ignore the ordinary rules that required them to harmonize different laws. The Constitution, thus, in this case, requires them to give federal law priority, the Constitution, and not try to harmonize it with state law. The Constitution thus presupposes the operation of applicable legal rules at the time because it displaces one of them. And finally, jurists and legislators alike applied legal interpretive rules to clarify the meaning of the Constitution in early debates, like that over the Bank of the United States. Of course, that doesn't mean that every word in the Constitution has a distinctively legal sense. Plenty of words make full sense in lay terms, but the rules that directed interpreters to consider context when deciding whether to use lay or legal terms were themselves legal. I think the same empirical interpretive approach also helps address a lacuna in his great treatise, Reading Law. Reading Law is a wonderful book that suggests what interpretive rules to apply, but it doesn't exactly tell us why to apply these rules rather than others. Moreover, at times, as in Scalia's rejection of using spirit or purpose to aid interpretation of a statute or the Constitution, Scalia relies on normative claims, such as that reliance on such a rule would lead to uncertain results. And I think these normative claims sit uneasily with Scalia's positivism. But again, referring to his key move, that is authoritative source comment, I think it follows that we should apply all the rules and only the rules deemed applicable at the time of the Constitution's enactment. To interpret the Constitution against the background of some other set of rules is to impose a meaning different from that which was understood at the time. Thus, one cannot reject spirit on normative grounds, even on the basis that it may lead to less clear results. I think the most important contemporary implication of this analysis, and I think it's enormously important, is that it rejects claims that are now often advanced by originalist opponents, such as Cass Sunstein, that originalism isn't required by the Constitution because it doesn't expressly state its interpretive method. It's also a claim made by the late Richard Fallon. That silence is hardly surprising. Most documents don't specify their interpretive method. My wife, for instance, has yet to so annotate her grocery lists. Instead, meaning is determined by the language, the conventions that people follow at the time of an utterance. These conventions don't merely include word meanings and grammatical rules, but also interpretive conventions and rules. And these interpretive rules are often tied to particular situations or documents. Thus, for the Constitution, it's interpretive rules that would apply to a document of this type. Calling the Constitution a constitution rather than something else, such as the Articles of Confederation or a treaty, indicates that it should be treated as a constitution. Thus, the Constitution itself appears to provide that it will be interpreted in accordance with the established rules for interpreting a constitution, a claim that Mike Rappaport and I are going to make in a new paper. The argument resembles, I think, the famous one that Chief Justice Marshall used in Marbury versus Madison to establish judicial review itself. In Marbury, the court noted that the principles established in the Constitution are deemed fundamental. Thus, it is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or the legislature may alter the Constitution by an ordinary act. So these crucial principles, the crucial principle of judicial review, flowed from an attribute of the Constitution, that was well accepted at the time of the document's enactment. So too are interpretive rules. They too are aspects associated with constitutions, and therefore they're derivable from the constitutional text just in the same way that judicial review is. Thus, I think Scalia's 40-year-old insight was absolutely fundamental, and it remains fundamental today. And it's that the centrality of authoritative sources for constitutional interpretation continue to yield important dividends today in the debate about originalism. It yields, in fact, I think, the most important last point. The most important authoritative source of the Constitution is the Constitution itself. And properly understood, that Constitution provides its own interpretive method and vindicates Justice Scalia's move to public original meaning, and it's written it's implicated in the document itself, and that Scalia had even a greater insight than I think he understood at the time of that great speech 40 years ago.
Well, thanks to Ed Whalen, EPPC, and AEI for inviting me to be part of this conference. I was born around the time that Justice Scalia was appointed to the Supreme Court. So because he was a towering figure in our intellectual life during my entire formation in the law, no one played a greater role in my intellectual formation than Justice Scalia. So it's a great honor for me to be on this stage to mark the 10th anniversary of his passing and reflect on his legacy. The focus of my remarks will be the last public lecture that Justice Scalia gave, a lecture on the relationship between originalism on the one hand and the natural law tradition on the other. During his lifetime, Justice Scalia was arguably the preeminent American jurist who engaged regularly with the Catholic intellectual tradition, including the natural law tradition. His writings demonstrate a deep interest in and love of the Catholic intellectual tradition. In his last lecture, Justice Scalia had been invited to deliver remarks on the 800th Jubilee of the founding of the Order of Preachers, commonly known as the Dominican Order. The setting for the lecture was the Dominican House of Studies in Northeast DC, right across the street from my institution, the Catholic University of America. In his lecture, Justice Scalia did something bold. Before an audience of Dominican friars, he argued that St. Thomas Aquinas, perhaps the most revered and beloved Dominican besides St. Dominic himself, was wrong. Specifically, that Aquinas was wrong in the Summa Theologica in his description of the proper approach to legal adjudication. I had the privilege of being present at that lecture. Following Justice Scalia's bold example a decade ago, I will argue at this event, celebrating his legacy, that he was wrong. Specifically, that he was wrong in perceiving an incompatibility between originalism and Aquinas' articulation of aspects of the natural law tradition. I'll begin by very briefly outlining why natural law actually requires originalism in the American context. I'll then turn to Justice Scalia's critique of Aquinas' views on legal adjudication and show that originalism is actually consistent with what Aquinas said. And I'll conclude by pointing to one way in which Justice Scalia's approach to originalism is indeed in tension with a natural law-grounded understanding of constitutional theory. The natural law justification for originalism proceeds from three questions. What is the moral justification for political authority? In whom is that political authority vested? And what are the implications for legal adjudication that flow from the answers to questions 1 and 2? Starting with the first question, the political authority justification. Political authority is the power to make laws and enforce them and resolve legal disputes. The need for political authority arises from the fact that we are social animals, that we flourish as the type of beings that we are by being in community with others. But being in community with others poses challenges for us, for social coordination. So there have to be conditions in place for us to flourish in society, and we might call those conditions the common good of society. Some of those conditions are directly deducible from the natural law, such as the prohibition against the intentional taking of an innocent human life. But the vast majority of conditions of our flourishing in society are not required as a matter of reason and are instead matters of determination. The well-known example are traffic laws. Natural law does not tell you which side of the road to drive on, but we need to know which side of the road to drive on as a condition for flourishing in society. Political authority is the only way to make that determination. Someone just has to decide what side of the road we're going to drive on. So political authority is necessary to secure the common good, which is necessary for our own good. and we therefore have a moral obligation to obey political authority insofar as it seeks the common good. But in whom is that authority vested? Aquinas argues that since authority is simply a means to securing the common good, it must be vested as an original matter in those who have responsibility for securing the common good. And since every member of the society has a duty to secure the common good, political authority is vested in every member of a society as an original matter. Members of society then transmit a portion of their authority to some subgroup within the society to govern in their name. What implications does all this have for legal adjudication? Well, if the people's legitimate political authority is necessary for the common good, then we have a moral obligation to preserve their legitimate political authority. And preserving the people's authority requires understanding their commands as the people themselves understood them. To do otherwise would be to make those commands less efficacious, which would be to undermine their authority. And since undermining legitimate political authority can never be in furtherance of the common good, departing from originalism is contrary to the natural law. There are obviously many counterarguments to what I just said here, and I've addressed them in my scholarship. This is just a sketch for purposes of setting up my remarks. Let's turn now to Justice Scalia's criticisms of Aquinas on legal adjudication. He began by criticizing Aquinas' contention that, quote, if the written law contains anything contrary to the natural right, it is unjust and has no binding force. Wherefore such documents are to be called not laws, but rather corruptions of law, and consequently judgment should not be delivered according to them. Upon reading this aloud at the Dominican House of Studies, Justice Scalia exclaimed, horrors, a sentiment worthy of Chief Justice Earl Warren. He asked rhetorically, quote, do you really want human judges setting aside positive law because they believe it contradicts natural law? Rather, in cases where, quote, positive law places a judge in the position of being the instrument of evil, Justice Scalia argued, quote, the judge must recuse from the case, or if there are many such cases, resign from the bench, unquote. Now notice that Justice Scalia did not deny that a judge cannot, in good conscience, render judgment according to a positive law that is contrary to the natural law. That's why Scalia thought judges must recuse or resign in such circumstances. Rather, Scalia disagreed with what he thought was Aquinas' prescription that where there's a conflict between the positive law and the natural law, the judge ought, in Scalia's words, to, quote, set aside positive law, unquote. But as Professor Russell Hittinger pointed out more than 2 decades before Scalia's lecture, quote, Thomas says that no judgment should be rendered according to the flawed measure. He does not say that one is entitled to make a new rule and measure, for that would imply legislative authority, unquote. In other words, all that Aquinas said was that a judge cannot issue a judgment according to the unjust law. He was not saying the judge should therefore issue a judgment according to the judge's understanding of the natural law. The scope of the judge's authority is itself a matter of positive law. Nothing in the natural law tradition requires that federal judges in particular have the authority to set aside positive law in light of the natural law. So if Article 3 withholds that authority from judges, as Justice Scalia rightly thought that it did, then it would be just as much an assault on the common good for a judge to usurp the authority as it would for the judge to render judgment according to an unjust law. Rather, the logical implication of Aquinas' statement is precisely what Scalia prescribed. The judge must recuse or resign if there's no other source of positive law that would allow the judge to avoid rendering judgment according to the unjust law. The other passage Justice Scalia highlighted is Aquinas' statement that where a law that is generally just would result in an unjust application in a particular unforeseen circumstance, quote, judgment should be delivered not according to the letter of the law, but according to equity which the lawgiver has in view, unquote. Double horrors, Justice Scalia exclaimed. Quote, a sentiment worthy of Justice William Brennan. But here again, Justice Scalia overlooked important considerations. To begin with, Aquinas did not say that the judge can supersede the positive law using the natural law. Rather, equitable interpretation is only permissible where the positive law allows the judge to reasonably assume that the lawmaker did not intend to violate the natural law. American positive law reflects this assumption as a general matter. It generally assumes that the lawmaker acted reasonably, and many traditional canons of judicial interpretation legitimately authorize judges to avoid the unjust application of an otherwise just law. Moreover, Aquinas does not assume that judges will be the primary actors in reconciling the natural law and the positive law. It's a fundamental natural law principle that the allocation of powers within a constitution is generally not dictated by the natural law and is therefore a matter of determination by the people in the exercise of their legitimate authority. That's why no one thinks the bailiff or prison guard must have the power to set a wrongfully convicted prisoner free. Positive law can legitimately limit the powers of actors within a constitutional system. But if a constitutional system required the executive to enforce every single positive law to the hilt, provided no judicial equitable authority, and forbade remedial measures on the back end, like pardon or clemency, that truly would be an unjust system, contrary to the natural law, precisely as Aquinas argues. Fortunately, ours is not such a system. Our law recognizes many pathways outside the judiciary to avoid the unjust application of an otherwise just law. The executive's law enforcement discretion is the foremost example, as is the executive's pardon and clemency powers on the back end. Excuse me. None of these ways of ameliorating the unjust application of otherwise just laws requires departing from the original meaning of our law, since all the features I just mentioned are just as much a part of our original law as the hypothetical law under consideration. There is therefore no contradiction between the passages that Scalia cited from Aquinas in his lecture and Scalia's own approach to constitutional adjudication. But there's one respect in which Justice Scalia's way of thinking about constitutional theory really was a departure from the natural law tradition, and it is at least partly the cause of the mistakes he makes in that final lecture. The natural law tradition recognizes that the point of the law is ultimately to serve the common good. Law is emphatically a moral endeavor. How a judge goes about adjudicating cases under the law is, therefore, also a moral question, since the only way to know how to adjudicate cases, how we ought to adjudicate cases under the law, is to ask what the point of legal adjudication, and therefore of law, is. Far too often, Justice Scalia's justified concern for avoiding the usurpation of authority through the imposition of judicial moral views made him wary of moral arguments in general, as if originalism could be justified without a moral foundation. But originalism, like any other constitutional theory, requires a moral justification. The natural law tradition articulated by Aquinas provides just such an argument. Justice Scalia may have been skeptical of what Aquinas said about legal adjudication, but it was Justice Scalia's project of promoting originalism that actually best implemented Aquinas' moral framework. Thank you.
So thank you. It's my pleasure to be here at this event, and a particular pleasure to be able to talk about the legacy of Justice Scalia and the kinds of issues and puzzles that he was worried about. He's certainly, both in his work on the court and his work off the court, unlike many, has a substantial legacy, and one that not only is still very much with us 10 years later, but will, I suspect, be with us for quite some time. But part of what I want to talk about in my remarks today is this question of how much more time might that legacy still be around, and how should we think about it. So my talk wants to focus on issues of the politics and history surrounding originalism. I am slightly older than Joel, and so I came of age politically during the Reagan era, which shaped my views about a wide variety of things, but including how to think about constitutional interpretation and judicial review specifically. One consequence of that is I was starting to come to these issues in the first place in a period in which they were highly contested. It was very uncertain what the future of originalism might mean, and whether or not there was even going to be much of a future there at all. I began to work on my dissertation, which was partially a defense of originalism as a method of constitutional interpretation in the early 90s. And one of the concerns I had at that point was, on the one hand, intellectually, it felt like it was an important project and needed to be done. On the other hand, I very much worried that I was working on a dead theory, one that no one would care about moving forward, that had no political salience, no academic salience, and as a consequence, interesting, important for me, but not one that would have any relevance in the outside world. And I think that was not an unfair assessment in the early 90s to worry that that might be true. At this stage, I think looking back, we would think, no, originalism has proven remarkably durable and significant. But that was a highly contingent set of events, and turned in part on how some presidential elections and judicial appointments wound up turning out, and what the court winds up looking like. So I want to take that contingency into account in thinking about sort of how we came to this originalist moment that we're continue to be in, and what the significance of it is, and how fragile it might be moving forward. At one level, I think originalism as a broad approach to thinking about constitutional interpretation in the United States is a very old set of commitments. In some ways, you might think it's the oldest commitment, the most traditional way of thinking about constitutionalism. Of course, the constitutional text does not say how we ought to interpret the Constitution, but I think a very natural reading, and a natural reading from those early on who were engaged in the process of constitutional interpretation, was to assume that the goal of interpreting a fundamental law like the Constitution is to, as was often the case in the context of statutes and other kinds of legal documents, capture the will of the lawmaker. What kinds of rules and principles were they articulating and laying down that then a subsequent set of government officials, including judges charged with interpreting and applying those principles in the cases before them, ought to articulate and elaborate and apply in the situations where that might be appropriate. So the vision of what the purpose of constitutional interpretation was by its nature fairly originalist in its core orientation. What there was not was much agreement about how you did that in practice. Certainly not a lot of superstructure of techniques and methodologies that are elaborately designed in order to develop out how that might play. And moreover, the key arguments at play through much of American history were not over whether or not you ought to do that, but rather subsidiary questions. Should you be a strict constructionist about how you go about doing that, or should you take a more broad approach to thinking about how to interpret particular constitutional provisions, for example? That begins to change in the late 19th and early 20th century when, for the first time, you really get serious intellectual and ultimately political and judicial challenges and a set of alternatives to thinking about originalism as the primary goal and understanding about what it meant to be a judge and what it meant to live with a constitutional text, in which you get the rise of theories of living constitutionalism that really argued that we should not be stuck with a constitution that was written many decades ago at that point, and particularly we shouldn't be stuck with the way people thought about that constitution written many decades ago. Instead, we all think about the Constitution as a living, evolving document in which the actual document itself was largely of secondary interest and concern, but rather what we ought to focus our attention on were a set of practices and customs and goals and purposes and policies that we think would make sense for the current era. And what we ought to conceptualize our constitutional enterprise as being is one of trying to make the Constitution work as well as possible for the needs and understandings and preferences of those who are living today. That was a radical vision of what the Constitution ought to be and what it ought to become, but one that was extraordinarily influential in some scholarly circles and ultimately some political circles and eventually in some judicial circles as well. I wouldn't go so far as to say it was ever the mainstream view or necessarily the consensus view, certainly among judges and some in the legal profession more generally, but it was a real and serious view among many. And as a consequence, by time you get to the 1970s and into the 1980s, there was a real challenge about how do you revitalize this much older tradition and put it on firmer footing and make it more secure and important going forward? How do you restructure constitutional interpretation, the role of judging, so that it recognizes once again the central purpose of what constitutional interpretation ought to be, which is to recover the will of the authoritative lawmaker and implement that in practice against these alternatives. And so you get a modern originalist movement that begins to emerge in the 1970s and into the 1980s that really has to re-articulate those fundamental expectations. What's the core theory about how constitutionalism ought to work? What's the authoritative grounding of judicial review more generally? What's the job of judges more generally? And then begin to focus on developing a set of methods and concerns about how do you deal with this in detailed practice so that you can make originalism not just a set of sort of background maxims, but actually a meaningful practice that judges can be expected to pursue in some level of detail. unsurprisingly, since a lot of that originalist enterprise as it's initially being developed is developing out of unhappiness with what judges are doing, and certainly some unhappiness with some about what some judges and some advocates around the judiciary are advocating that judges ought to be doing. And so not only is there a goal of pushing back against a mistaken method and mistaken understanding of purposes to the constitutional enterprise, but also a question of judicial role. To what degree should judges be deferential, maybe extremely deferential to political branches, and to what degree should judges be so-called more activist, willing to strike down laws in various ways, setting aside activism, which might be understood as making up new rules in their entirety. And so it's no surprise, I think, that the original articulation of originalism, as it's being developed in the 70s and 80s, often winds up combining these two kinds of concerns. One is, what do you recover as being the central aspect of constitutional interpretation, the constitutional enterprise on the one hand, and also what is the judicial role, and to what degree should the judicial role be one being fairly deferential going forward. And one thing we've seen subsequently is a division of those two lines of thought. And a recognition that these are separate kinds of arguments with separate theoretical groundings and separate justifications as to why you might want to be an originalist on the one hand and why you might want to be relatively deferential as a judge on the other hand. That has been, though, a remarkably successful movement. Primarily remarkably successful, I think, because it influenced the appointment of judges and the development of a legal movement that was centrally committed to these kinds of ideas as being central ideas. And that's a fairly unique political project. This idea that what we ought to do in cabining and constraining judges and pushing back against mistaken views of the Constitution was not simply point out where individual decisions were getting the law wrong in particular circumstances, but articulating a broader theory about how you go about interpreting the Constitution that would apply across a wide range of issues and concerns that requires a fundamental shift in judicial philosophies and constitutional philosophy more generally. That's a political project that was critically important to reining in the courts in various ways and putting them on a different kind of path, but a quite unusual kind of project to engage in historically. And one that was, I think, fully embraced by the Republican Party for an extended period of time, and as a consequence had lots of consequences in political practice, but not one that was never really fully embraced by the Democrats and the other political party. And as a consequence, I think it makes more sense to imagine that these alternative traditions of understanding how the Constitution works are more in hibernation rather than simply being banished. It's easy to imagine them fully recovering, and we find ourselves back in the kinds of debates we were having in the 1960s and 1970s if the composition of the courts themselves work, that are changed. So to the extent that the courts are currently committed to originalism, that encourages and incentivizes lots of attention to originalism in law schools and elsewhere. But if courts were no longer equally committed, instead they pursued other interests, other ideas about how we ought to interpret the Constitution, whether they come out of the Democratic Party or perhaps even future visions out of the Republican Party, then likewise we're going to see very different debates emerging about what the future of constitutional interpretation ought to look like. And originalism might be one of the players in that debate, but it certainly won't be the kind of dominant player that we might think it is right now. Thank you.
Well, it's a great honor to be with you today. Thanks very much for this invitation. It's a very special anniversary day in connection with the greatest originalist in American history. And I don't mean Justice Scalia. He is a very important originalist and very much has influenced me. And we meet on the 10th anniversary of his passing. But of course, we also meet on the 217th anniversary of the birth of Abraham Lincoln, February 12th, 1809. And I've already told you something that may be news to you, that the greatest originalist of all time was Abraham Lincoln. And now I've also just told you Originalism is not unique to the political right. Lincoln, in his day, was on the political left. I've also told you that originalism isn't just a theory of judging. It's actually ultimately a theory of constitutional interpretation. It's not just about the Supreme Court or all courts. It's about presidents. It's about ultimately all of us as citizens. And Lincoln was the greatest of them all, and he took seriously the Constitution, and he was going to enforce it even when it didn't align with his personal preferences. He was going to enforce the Fugitive Slave Act, even though he didn't like the Fugitive Slave Act. And actually, when you read his first inaugural address, and I encourage you to do that, he actually says, yeah, it doesn't say slave, but we all know that they meant slave, and the intention of the lawgiver is the law, okay, which is in slight tension, so to speak, with what we've heard about Justice Scalia on objective intent versus subjective intent. There are different ways of doing originalism, and we are very much in the debt of Justice Scalia for reminding us, ultimately, that ours should be an originalist project, and especially, you've heard that from, especially, I would say, John. And there are different ways of being an originalist. Let me identify some of the distinctions. Justice Scalia's approach tended to be clause-bound rather than holistic. It tended to focus more on the founding than the entire document, including the amendments and Lincoln's amendments. It tended to be judge-focused because he was a judge and a justice. It tended to be faint-hearted. He said, oh, I'm an originalist but not a nut. And he tended to focus on originalism on certain open cases, but he often didn't ask questions about originalism where there wasn't perhaps a current debate. Is that really originalism? If you decide you're not going to apply originalism in certain situations prudentially, well, maybe then you're a prudentialist all the way down. And Justice Scalia loved words. We've heard that before, but he tended to turn the Constitution into a little bit of a word game, focus more on letter than spirit. He liked rules, and he tended to reduce the Constitution to sentences and words and rules. But the Constitution isn't just about rules and words. It's about principles as well as rules. It's about spirit as well as letter. Let's take Lincoln's great role model, John Marshall in McCulloch versus Maryland, paragraph 37. He talks about the letter and spirit of the Constitution. And he says we must never forget it is a constitution we are expounding. And he didn't mean that it evolved. He didn't believe in evolution. Darwin hadn't, done the voyage of the Beagle yet, written The Origin of Species. John Marshall thinks the animals entered the ark 2 by 2 in 1819. And so when he says it's the Constitution we expounded, we should never forget that. He's not saying it changes. He's saying it's a thing. It's a whole. We have to understand the whole instrument. And indeed, he does not rely on the necessary and proper clause for any strong result that he derives. He actually looks at the whole thing. Justice Scalia misread McCulloch, as do most people in Gonzalez versus Raich, when he said Marshall is actually relying on the necessary and proper clause affirmatively. It's not so. A textualist might do that, a narrow textualist, because you're looking for a sentence rather than the whole thing, a fair construction of the whole instrument. So there are different ways of doing originalism. I'm very much influenced by Justice Scalia, and I want to salute his memory today on the 10th anniversary of his passing. But I actually think Lincoln did it better, and it was more holistic and not connected merely to the judiciary. Let me just give you a few examples, and then I'll sit down. So let's take Justice Scalia on guns. He, in Heller, talks a lot about the Second Amendment, but he doesn't bring the 14th Amendment into the frame of analysis. And actually, the 14th Amendment is quite important in thinking about guns in America, but he's not quite intergenerational. And later Supreme Court opinions are taking the 14th Amendment seriously alongside the Second. I think of City of Chicago versus McDonald and Bruin. So that's an example. Let's take a question that unenumerated rights, because he liked words and rules and constraint, and he was worried about unenumerated rights, but there is a Ninth Amendment, you see. And so Justice Scalia, I would say, here's a question. You never asked it because it never became politically controversial, but is there a right of a criminal defendant to take the stand in his own defense? That's 9-0 in the Supreme Court, and none of you have even thought about it unless you read my book, America's Unwritten Constitution, because people don't think about it, but there is a right, but where did that come from? Because the Constitution doesn't say that. It says you can't be forced to take the stand in your own defense. It doesn't say you have an affirmative right to. You can say, well, it's background, common law, understands all the rest. No defendant at the time of the Constitution had such a right in federal court, nor in any state court. And not only did they not have a right, no defendant was allowed in any state in America, in a state court or a federal court, to take the stand in his own defense. So how did that change? Oh, you'll have to read the book to find out why. But he didn't ask that question quite because it wasn't kind of in political contention. Let's take the Fourth Amendment. He and I had lots of agreements on the Fourth Amendment, and he was very kind to cite some of my opinions from time to time about that. But where the heck does the exclusionary rule come from? It's totally made up. And he never quite said that because it wasn't in play politically. Oh, Justice Thomas is asking that question, because Justice Thomas is, in Justice Scalia's terminology, more of a nut. And so am I. I'm going to just take the Constitution seriously, and where does the exclusionary rule come from? And he never quite asked that question, Justice Scalia. Now, here's what he does say about the Fourth Amendment. And he writes some great Fourth Amendment opinions, and some of them are to my right, okay? And I'm a liberal, not a progressive. Don't call me a progressive. Don't like that word so much. So here's a dissent that he writes in Maryland versus King. It's a cheek swab case about people who have been arrested. And here's what he says in a dissent. Quote, "The Fourth Amendment forbids searching a person for evidence of a crime when there's no basis for believing the person is guilty of a crime or in possession of incriminating evidence. That prohibition is categorical and without exception. It lies at the very heart of the Fourth Amendment." Here's the problem. Fourth Amendment doesn't say that. No founder ever said that. He never had a single quotation of anyone who said that, and yet he said it's categorical. And here's why, because he doesn't like the word reasonable, because it's too balancy for him. He loved rules and words. He thought rules were rules, and he thought principles were rules, but principles aren't rules, they're principles. Now, sometimes you might cash them out with sub-rules. So, and we don't actually have this categorical rule, and it wouldn't make sense for metal detectors at airports and border searches and a whole bunch of other things. I'll leave you with one other example. And here's where we overlap and here's where we diverge. So, and it's a classic example. President has to be 35 years old. And here's what he would say. He would look at dictionaries, and I would look more at history. And he would say, 35. What does it mean? It means 35. Yes, you're right. It means base 10 and not base 12 or base 8. Yes, you're right. It's a solar year and not a lunar year or something. Yes, of course, but fine, doesn't tell us very much. Here's, I think, what's interesting, Justice Scalia. Why did they have that rule? And maybe it actually doesn't influence any particular judicial application, because 35 means 35. Doesn't matter if people become more or less mature over the years. And he was less interested in that now. But if you're a full originalist and you're thinking about not just judges, but other citizens generally, we might want to ask, why did they have that rule? And it turns out to have remarkable implications. Maybe in the Q&A we can talk about it for birth equality more generally, outside the domain of presidential eligibility. Here's why we had the rule. But you're not going to find it by looking at dictionaries, Justice Scalia said. He loved words. He was a snoot. And he was such a wordsmith, and you heard that earlier today. Here's why we have it. We have it because everyone at the time understood that the Prime Minister of England, when they're adopting that rule, is named William Pitt the Younger. And he might be good and he might be bad, but he's a PM, Prime Minister at age 24 and an MP at 21, and he's getting it because he has the same first and last name as his daddy. And this was actually an anti-dynastic provision. Who in the heck would have the name recognition to get himself elected president at the age of 34 or 33? It's going to be a famous son of a famous father, and they're trying to warn us about dynasty in all sorts of ways. That's a different kind of originalism than Justice Scalia's. I think it's more Lincolnian kind of originalism, and maybe we can talk about that in the Q&A. But today, just to conclude, we do mark the memory of two very, very important and special originalists in American history, Justice Scalia in the modern era and President Abraham Lincoln. Thank you.
Thanks to all four of you. He would have loved all four remarks. He would have had something to say about all four of them, but he would have enjoyed listening to them. I mean, one thing I just want to start with, which is a slightly political point, but I think it may have a big impact on the future of originalism, which I do think is equally vulnerable to attacks or dilution from the left and right, if you think 30, 40 years from now. He said the one point that's the single defect that he would love to cure in the US Constitution is Article 5 and the 3/4 requirement for amendment, because it's that difficulty of amendment, the disappearance of a culture of amendment, that puts so much pressure on originalism. And I think if you talk to people that aren't originalists, it would probably be that problem, practically speaking, which led them not to be originalist. You know, there was a time in our country where the political parties saw some political advantage to trying to amend the Constitution. Like you won even by losing, because you had to win in 38 states. You had, you could elect legislatures of your liking, governors of your liking, and potentially get this amendment a little further, towards getting ratified by the whole country. Is there any chance? I mean, I want to start with you, Keith, on this one. Is there any chance? I mean, the progressive era thrived on this. They succeeded a couple times. They failed a lot. And to me, I feel like the ERA movement, I was too young to care about it. But of course, that came up, I think, two states short ultimately. And then you get US versus Virginia, which makes the ERA irrelevant. So the lesson doesn't seem to be lost on people. If you have a court that can do what you're looking for, why would you go through the hassle of getting 3/4 of the states to amend the Constitution? And I think that's what Scalia realized. I think he thought that was the greatest threat to originalism, that everyone understood, of course, this is what judges should do. The problem was, what do we do about the Depression? What do we do about Jim Crow, et cetera? Any chance we can return to that culture politically of amending? Or maybe move it to 2/3. The First Amendment is to lower the threshold to 2/3.
Yeah, I don't think it's very easy to shift back. I think it would be extremely valuable for our constitutional culture and how our Constitution works if we could more easily amend the Constitution, although I'm sure I would not be terribly happy with some of the substantive rules that we would likely adopt under those circumstances. But if we think about the Constitution as partially about a system of hydraulics, right? If you design a system in which it is easier to get the court to adopt the constitutional rules that you want than it is to go through an Article 5 amendment process to get those constitutional rules, we're going to go through the court rather than go through the Article 5 amendment process. And so we have found ourselves with a system in which the court's the easier one to manipulate and the easier one to go through in order to accomplish what we want to accomplish. And that's going to be our natural path unless we make it easier to go through Article 5. I think the other challenge, though, is one that's a feature of our political system more generally at this moment, and this moment has now extended over many years, is we are just a very divided society. And so it's just the constitutional amendment process is designed to work on consensus, and that we have broad agreement on a new set of constitutional rules. And we don't have broad agreement on much of anything right now. And so even if it was relatively easier to amend the Constitution through text, hard to imagine how we get very broad agreement to make much in the way of fundamental constitutional changes.
And John, yeah?
So I was just underscore one of the points that Keith suggested, which is that there's a relation between originalism and the constitutional amendment process. The reason the ERA failed, I think, was a consequence of non-originalism in two ways. One, the court had moved ahead, perhaps, of what the original meaning was, and so there seemed to be less need for the ERA. But it was also against the background of perhaps a court that was thought to be quite extravagant, and people were easily able to say, well, you give them another blank check, who knows what they're going to do? And so there's a relation, and if that's true, one might hope if a real culture of originalism dominates, that will lead to a revival of the amendment process. And when we say, well, it's too hard, we did have, even in a divided polity, we had very important amendments. The income tax amendment really changed America, having the federal government have so much money. The direct election of senators, these were huge amendments. And I think one could imagine that happening again. It's also not so obvious that a lower amendment process, we get great things. What has come closest to getting an amendment? Of the flag burning amendment, right? And is that actually, would that solve any problem? It would be, I think, symbolically very problematic, and it doesn't address any of our real problems. So color me a little skeptical that's our essential problem, given that we have been able to do some very important amendments in the past.
So I used to think the Constitution was maybe too hard to amend. I've changed my views on that. Remember, right at the beginning, there are 12 amendments in the early era. So if we don't have amendments, and the amendments that we've had have added to liberty and equality, very few have taken away from liberty and equality. So I used to think as a young person, oh, things could be so much better. Now as an old guy, I think, oh yeah, they could be a lot worse. And state constitutions have had many good amendments and many bad amendments, and most Americans actually have more of a fondness for the federal than their state amendments. But I want to push back a little bit. I'm glad you mentioned his dissent in the Virginia case, because I think it actually was wrong, and it will not age well, because we had an important amendment in America. It was called the 14th Amendment. You may have heard of it. And actually, you see, I said certain kinds of originalists aren't paying enough attention to Lincoln and his generation and what they did. Gandhi was once asked, what he thought of Western civilization. He paused, he said, I think it might be a good idea. We actually already have an ERA. It's actually the 14th Amendment. It doesn't say race, and there's a reason it doesn't say race. It says we're all born citizens, born equal citizens. This goes back to born free and equal clauses that are part of 15 of the 19 free states at the time that Abraham Lincoln is elected. Oh, you can read all.
Was the 19th Amendment irrelevant?
Well, so you're pushing my button, so I'm going to tell you, actually, I've written...
Well, you pushed a few to start.
Because the 14th Amendment was not about political rights, it was about civil rights. And civil rights didn't include voting, and that's why you needed the 15th Amendment, Jeff, because it surely was about race. But you needed an amendment about voting rights for blacks and an amendment for voting rights for women, and you should read Minor versus Happersett, which says all of this. But I promise you, if they had meant to say race, oh, they knew that word, and it was in the 15th Amendment. And Scalia didn't know any of this because he didn't study history. He looked at dictionaries. I promise you, Justice Thomas studies history more. So I will stand or fall on 8 books that I've written, and they're big, fat, this is what originalism is. It's not looking at dictionaries. It's actually knowing your history, and the 14th Amendment was emphatically about sex equality as well as race equality. We are born equal, male or female, black or white, and the language of the 14th Amendment actually comes from, believe it or not, and there is evidence in the book, Elizabeth Cady Stanton. It's first in the Seneca Falls Declaration, and then she actually publishes something in 1866, and they're picking up her language that the citizens are entitled to the privileges and immunities of citizens, but that doesn't include voting, because a 2-year-old is a citizen but doesn't get to vote, and yes, a woman is a citizen, and she can sue and be sued in diversity jurisdiction, and she doesn't get to vote, and even when blacks are citizens, that doesn't guarantee their voting rights in the North, which is why you're going to need a 15th Amendment for political rights for blacks and a 19th Amendment for political rights for women. But yeah, since you mentioned the 19th, 14A plus 19A functionally equals ERA. We already have it. The 10th Amendment is declaratory. So I think actually the Income Tax Amendment was declaratory too. But you can't decide whether I'm full of it or whether actually I have the evidence unless you read history. You won't find the answer to these things in dictionaries.
So, Joel, I'm going to shift a little bit. I didn't want too much consensus to break out. But I love that your punchline was that Aquinas and Scalia were both right. I'm curious, what role, if any, is there for natural law in constitutional interpretation today?
So I think the primary role is in properly orienting the judge's understanding of their role within our system as a moral matter, right? The primary role of natural law is for them to understand that to go outside of the original meaning is not just to violate what the words say, but it's actually to commit a moral wrong. It's to grab authority that is not yours. And that, I think, is the primary role. In terms of the application of natural law principles to concrete cases, that's itself a question of positive law. To what extent does the positive law give judges the authority to do that, either generally or in a particular case? And there are some traditional canons of interpretation that are rooted in natural law principles where you would be effectively implementing natural law principles in the adjudication of a case, but precisely because those are picked up by positive law and therefore authorize that.
So like background context, historical context principles.
Historical context principles, but I mean, there are just some specific canons of interpretation, right, that seem to only make sense if you're assuming a legislator who is acting reasonably against a backdrop of a natural law tradition, and those are part of our positive law just as much as the amendment provision of the Constitution, anything like that.
So last question, then questions from the audience. Unenumerated rights. So Justice Scalia clearly was not a fan of substantive due process. That's not necessarily the only way you can think of unenumerated rights. How should originalists think about unenumerated rights? So, John, go ahead.
I think one insight into one problematic aspect of Justice Scalia was revealed sort of in the McDonald case, when there was an attempt to found the Second Amendment on privileges and immunities. And a lawyer got up and Scalia said, oh, we're not going down that route. And yet, I think almost to be consensus among originalists that the place to find rights, enumerate, or at least not individually enumerated rights in the Constitution, is the Privileges and Immunities Clause, and that's a way, to pick up on Keel's point, that we actually can look at the historical context, because there's a rich historical context of what privileges and immunities were, not such a rich historical context of what substantive rights coming out of the Due Process Clause are. And yet he, at the end of his life, seemed so unwilling to go down that route, and I think that was because of his great allegiance to precedent, or at least precedent that he found very well established. And that, of course, is a huge issue for originalists going forward. In fact, I think it is the most, in some sense, important issue, because there are a lot of non-originalist precedents. The Supreme Court is full of them, and yet, of course, Scalia has something to say that the Supreme Court just can't do a spring cleaning of them. And so how do we go about that, I think, is central. And yet he seemed even unwilling even to start considering it in the McDonald case. So I thought that was, even justices, one argument for justices at times, even great justices, to retire, to become kind of set in their ways. And he may not be thinking through what I think was the most, in some sense, important opportunity to perhaps reorient substantive rights in a more originalist and I think ultimately more principled way.
Yeah, Joel, go ahead.
Just very briefly, I would say that I think another reason for his hesitation that I think he expressed that oral argument in McDonald, if I remember correctly, is that there's just no real agreement among originalist scholars about the original meaning of the Privileges or Immunities Clause. You have very different interpretations of what it could mean. And so I think that probably made him kind of nervous about going down this path when the scholars who have dedicated so much work to this come to such very different views. And so it might have been just prudent to hold off until there was more scholarship on the topic, which there now has been a lot more since MacDonald on the topic.
I'm not sure that's true. There was pretty great consensus that privileges or immunities, for example, is the proper basis for incorporation.
Sure, but for unenumerated rights.
And if we look at the Constitution as a whole, it's actually an answer to an earlier question, Jeff, that you asked. Privileges and immunities appears actually in Article 4 as well as the 14th Amendment. And so we know, for example, here's what it doesn't mean. It doesn't mean voting rights, because interstate privileges or immunities mean that when I come to Maryland, I get all sorts of rights, just as Marylanders do, but I don't get to vote in a Maryland election. And this is mentioned in Minor versus Halperson. The 14th Amendment is not about political rights, it's about civil rights. Now, just exactly what it is, but this is not unique to the Privileges or Immunities Clause. If you're an originalist, the scholars are always going to disagree. The historians are always going to disagree, at least at the margins. So if that's your basis for hesitation about originalism, wow, that wouldn't be unique to the Privileges or Immunities Clause. It would be applicable just much, much more broadly.
That's true.
You lay all the historians end to end, they won't reach a conclusion.
That's right, but this is an area where we have seen particular abuses of judicial authority, is in the area of unenumerated rights. So for there to be such contestation and disagreement about how to identify such rights, what the content of such rights are among scholars, I think that is a greater cause for concern than there is disagreement about the recess appointment power, for example.
And so I ask one more time, whence the right of a criminal defendant to take the stand in his own defense, a right that no one had at the founding, that only Mainers had at the time of the 14th Amendment? How did that come about? Because we do have lots of unenumerated rights that are not remotely controversial.
Sure.
And then we have to think about how that happened.
John, just one quick thing. I'm just curious. I thought initially it was a missed opportunity as well. I will say, though, as a judge, I sympathized with the point that he believes in stare decisis. So he's been pretty consistent on that, and he's thinking to himself, okay, so I'm simultaneously wiping out all these incorporation decisions, and now what am I gonna do? Am I gonna say this Privileges and Immunity Clause? It's great, it's textual, I love that, but it somehow magically just preserves those. Is your view, John, that it would have gone beyond the Bill of Rights? Would it have gone to other unidentified rights? In other words, if he'd done what you think he should have done at MacDonald, and I appreciate the point, I could have seen it. I certainly could have seen it without incorporation going on for 80 years. But would you have said it just stops with the provisions of the Bill of Rights, or would you have said it's an open, it's a delegation, unlimited delegation to judges to identify new rights?
So I don't think it's an unlimited to identify new rights. My own view is you have to find some indication of the rights at the time. I'm not a scholar of the Privileges and Immunities Clause, so I'm cautious about opining on it. I think there probably is some, as Coriel suggests, some kinds of limited economic rights of self-control of your own, to follow a profession, some other rights probably like that within it. Let me just talk one point about precedent. So Scalia also had a view which I think made it very hard for him to overrule cases. He did not think you could overrule cases prospectively. And if you can't overrule cases prospectively, that does mean you're going to upset the apple cart, right? If you're going to change the delegation rule, suddenly the administrative state might disappear as opposed to forcing Congress to change in the future. And that was a view of his, and so one could discuss that as an originalist matter. It was an originalist view. He said it was an original matter. You can't have prospective overruling. So that, I think, made him think that precedent was perhaps even more essential than someone who didn't agree with that view would.
All right, well, I've dominated the questions enough. There's one over here, and then Brian, you're next.
Hello, Alicia Marmon. I'm from Georgetown Law. I just wanted to ask, someone asked something similar yesterday, but it was lawyers, and I think academics have a better perspective on this. There's a widespread perception among certainly liberals and even some conservatives, which I think is part of the origin of the common good conservatism argument, that originalism is a facade covering up, you just peel it back and you just find Republican policy statements all over the place. And I just wanted to not whether that's true. I understand that none of you think that's true, but whether or not there's a better way to make the argument for the public that the job of the judiciary is to say what the law is and not what it ought to be, and that it's not just trying to make policy when we do originalist understanding.
Thank you. Okay, Keel.
So there are at least two things that you said that I already pushed back against. First is originalism about judges? No, it's about all of us, okay? And that's why even if there can't be prospective overrulings or something, that's actually a point maybe about the judicial role, and Joel has talked about there may be some limits on the judicial role. Maybe there's natural law that's not fully judicially enforceable in every way. Maybe a judge can't do certain things, but that's not the same thing as originalism, which is about the meaning of the Constitution. So it's not just about judges, and just my answer to everything is going to be Lincoln, okay? And it's not just, so he wasn't a judge, okay, and it's not just about conservatives, because, to repeat, the greatest originalist in American history is someone who was born on February 12th, 217 years ago today, okay? So it's not just about, and on the court in the last century, I'm sorry, I apologize, I know we're here to mark Justice Scalia's passing, the greatest originalist on the court in the last 100 years is Hugo Lafayette Black, far and away, who took the privileges or immunities clause seriously and was a scholar of it. John, you don't claim to be, but Black actually did tons of scholarship on his own, which is heroic. I claim to be. I claim to have written 3 books on just this topic. And Black got it right, and Scalia mocked it when Alan Gura, I think, in oral argument mentioned it, and it was a laugh line, and I didn't love that. Truthfully. And he was a showman, and he was so fun to be with, and he had such a delicious sense of humor. But it does have a core meaning, application of the Bill of Rights against the states. There might be questions about the periphery. What beyond that? But if they had just meant Bill of Rights, wow, they could have said that much more easily, and they didn't. So I do think it includes more. I gave you one example. The right of a defendant to take a stand in a criminal case. And that's 9-0 in the Supreme Court. Scalia never questioned that. Justice Alito's maiden opinion actually presupposed that, his maiden opinion on the Supreme Court. So privileges and immunities is a very interesting issue. But to repeat one more time, it's not just about judges, and it's not just about conservatives.
Keith, go ahead.
Yeah, I would just note 2 things, I guess, briefly. One is I think it's critically important that those who report to be originalists try to be as consistent as possible. And so to the extent that there are particular policy outcomes you might be tempted to pursue, then nonetheless, you got to follow the evidence where it leads. And sometimes those are going to lead you to inconvenient conclusions, and you got to be willing to make that call and stick with it. And that's hard, but I think it's essential to establishing that this is actually a principled commitment and not just a guise by which you advance policy outcomes. Not only to convince the public and have the public be confident in it, but also to be true to what you purportedly think are actually the real principles that ought to be guiding you in these contexts. The other point I made briefly is the one thing I appreciate, maybe the only thing I appreciate, about the rise of the common good constitutionalism stuff is it does highlight what a conservatism that's detached from any commitment to originalism might look like. And so if you are a progressive or a liberal who is skeptical about originalism, think it's just a cloak for conservative policy outcomes, welcome, now you get to see what that actually looks like, and maybe it will lead you to a greater appreciation of originalism.
I mean, the only other thing I might say is Justice Scalia used to love to say it takes a theory to beat a theory, and so the only way to fairly answer that question is to ask yourself, how are the originalists doing with neutral decisions that cut across political agendas, and how are the non-originalists doing, and how often are they issuing decisions in high-profile cases that go against their political worldview? So if you do that, you might get an interesting answer. Brian.
Thank you. Two questions. One for you, Joel. Did I hear you say that some of the canons of interpretation presuppose natural law? And if I heard that correctly, could you give me some examples? And the other question's for Akil. I'm sorry I have not read your books, but I find...
You and everyone else.
I find very perplexing your invocation of history here in defense of your view that the Equal Protection Clause protects women, given that women were discriminated against pervasively before the clause was ratified, and they were discriminated against pervasively after the clause was ratified for decades and decades thereafter. How can you square those things?
First one.
Okay. So I was not claiming that our positive law canons pick up the kind of substantive principle you might have in mind, like pro-life, positions of the natural law. I meant that the way the natural law tradition thinks about law itself and legislating presupposes, for example, a reasonable lawmaker who would not do something that leads to a manifestly absurd outcome. The absurdity canon, for example, is hard to understand apart from an intuition about what a reasonable legislator would have been attempting to do in this circumstance. And actually, the example Aquinas gives in the Summa for equitable interpretation is a sort of absurdity canon example. I would also say that the canon against derogation of the common law is rooted in understanding what the common law was. And the common law was thought to be a manifestation of popular practices and traditions that were themselves rooted in natural law principles. And so even the respect for the common law in our positive law reflects kind of a background understanding of the common laws as reflecting true moral principles. So those are just a couple of examples I would give.
Gil, you get the last word, but you've got 30 seconds. No seconds, but go ahead.
So if you want to read something short, go on to the National Constitution Center, Interactive Constitution. Each of us, various scholars were given clauses. I got to pick, since I founded the National Constitution Center, and I picked one clause. It was the Birthright Citizenship Clause. It's going to be at the heart of the first sentence of the 14th Amendment. It's going to be at the heart of this case, and we'll see if conservative justices go against a conservative president and prove their originalist bona fides. I didn't actually mention the Equal Protection Clause. I actually said the Birth Equality Clause. It's the first sentence. We're all born citizens. We're all born equal citizens, black and white, male and female. That's what it meant. I wrote a whole book. It's called Born Equal. It's 800 pages, but if you just want a short thing, read National Constitution Center interactive website, a little posting on what it means to be created equal. I see my friend Hadley Arkis there. What it means in 14th Amendment talk and state constitutional talk to be born free and equal. They could have used the word race. They didn't. There's tons of evidence. After I've already gone to a minute, I'm happy a break to give you lots and lots of short things to read by yours truly and others.
Thanks to all four of you for thoughtful, provocative comments. Justice Scalia, there's no really better way to honor him than doing this kind of thing. His first book that he's known for is a matter of interpretation, and it's so revealing that the way he does it is he says, I'm going to lay out my theories here, and I'm going to find some experts to comment on them. In other words, he invited the criticism. He then wanted to take it on, and I honestly think, for me, it's his greatest legacy. So you guys followed that perfectly. Thank you very much. Really appreciate it.
We will resume in about 15 minutes with the panel on the religion clauses. Thank you.
Thank you,
guys.
Jeff.
That was great.
That was
I think we might.
All right, if everybody will settle back in, we'll get started in just a moment. That's great. I wish we would have been able to have the judges that yesterday. I don't know. It's not going to come up on. If everybody will take their seats, we'll settle in for the next panel. I mean you, Hadley Arcus. All right. Well, our next conversation will be about Justice Scalia and the Constitution's religion clauses. We'll be joined by Professor Stephanie Barclay of Georgetown, Professor Philip Munoz of Notre Dame, and Professor Mark Rienzi of the Catholic University of America and Beckett. They'll be introduced by our moderator, and I will introduce the moderator. We're joined by Judge Patrick Schultz. He was appointed to the U.S. District Court for the District of Minnesota in 2006, and he has served as the court's chief judge since 2022. Before his appointment to the court, he was a professor of law at Notre Dame, and then dean of the University of St. Thomas School of Law. Before that, he was in private practice, where I learned his clients included, am I right about this? The National Football League, the Minnesota Vikings, and the Minnesota Timberwolves.
One professional sports organization and the two others.
That, that's right. I gotta say, that sounds like a lot of fun. Now, I have, from what I hear, serving as on the district court for Minnesota is a little bit hectic these days, and so we are very, very grateful that you're here with us.
A wee bit, yeah.
I have to say, if you ever get stressed, I have something you should read. Years ago, I read an article titled, "On Being a Happy, Healthy, and Ethical Member of an Unhappy, Unhealthy, and Unethical Profession." I have it here with me. The title is, oh, what do you know? Patrick J. Schultz, Professor of Law at Notre Dame. Now, one way to be a happy lawyer is to clerk for Justice Scalia, as we've seen the last 2 days. And one way to be especially happy is to clerk for him twice. And of course, as we heard yesterday, Judge Schultz clerked for Justice Scalia first on the DC Circuit and then on the Supreme Court from 1986 to 1987. Thanks, Judge, for joining us today.
Thank you, Adam. So as Adam said, we're here to talk about the religion clauses, the very first words of the very first amendment to the United States Constitution. Provide that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The meaning of those two protections and the relationship, arguably tension between them, has been hotly contested throughout the 20th and 21st centuries, and Justice Scalia was part of that contest. He grappled with the meaning of the clauses throughout his time on the court. And today we're going to look back at his jurisprudence 10 years after his death and ask, what did he get right? And, well, we don't say wrong. What did he get less right? What did he get more right? What did he get less right? What might be worth reconsidering or recalibrating? Our panelist, just very briefly, Stephanie Barclay is a professor of law at Georgetown, where she co-directs Georgetown's Center for the Constitution. Before joining Georgetown's faculty, she was a law professor at Notre Dame, and she clerked for Justice Gorsuch. Philip Munoz is Notre Dame's Tocqueville Professor of Political Science and founding director of Notre Dame's Center for Citizenship and Constitutional Government. His books include 2022's Religious Liberty and the American Founding, Natural Rights and the Original Meanings of the First Amendment Religion Clauses. And Mark Rienzi is a professor at Catholic University of America's Columbus School of Law. He's also the president and CEO of the Becket Fund, where he leads the institution's litigation on questions of religion and the Constitution. And so let's begin with just kind of the big picture. When you are describing to an audience of non-experts on the religion clauses, like your students or like trial judges, what was Justice Scalia's views on the religion clauses? And looking back after now 10 years after his death, do you think he was more right or less right on his views? Stephanie?
So Justice Scalia is a jurist that I admire very much. When I was clerking on the Supreme Court, we were in the chambers that he used to inhabit in Justice Gorsuch's now chambers. And I think it's a moose, not an elk, that he shot, was right behind me. And it felt a little bit like Justice Scalia was watching over us and how we did our work at the court. But there's an awful lot, the vast majority of his work that I deeply admire and respect, and an awful lot that he got right when it comes to the religion clauses. Particularly on the Establishment Clause. We're going to jump into this more, sort of a deeper dive on that discussion, but I think his views were right. His concern about lemon, which he described famously as like the ghoul that continues to rise again and again. And I think that Leroy, looking down on me, was happy when we finally killed lemon, I think, in the case that Justice Gorsuch wrote called Kennedy versus Bremerton School District. And rerouted the Establishment Clause in a much more historical founding era approach to the meaning of that aspect of the First Amendment. I think he was right in his view of the importance of church autonomy. He joined the court's unanimous decision in Hosanna Tabor. We'll talk more about that as well. That's an area where the Establishment Clause and the Religious Exercise Clause are speaking with one voice, and there's a particularly important protection that we offer for religious institutions and religious leaders in that context. And I think he was right about some things and less right about other things in the free exercise context. So we'll talk about that more later. But I will say that the concerns Justice Scalia had that I think animated some of the decisions he made in the free exercise context were fair. Where I think he went off the rails a little bit was wanting to throw out the baby with the bathwater in terms of ways to protect religious exercise. I also think, fairly and understandably, he was a little bit allergic to anything that had happened under the Warren or Burger Court. And so things like strict scrutiny fell in that bucket for him. But my dad likes to say that even broken clocks are right twice a day. And that was an area where some of that Burger Court, Warren era jurisprudence, I think, stumbled into things that were largely historically rooted and supported in original meaning. So we'll talk more about that as well.
Mark?
First, I'm honored to get to be here and talk about Justice Scalia, who from before I went to law school has been a hero of mine. As an Italian Catholic kid from New York, as somebody who, long before I went to law school, knew about Roe v. Wade and the fights about it and was reading Justice Scalia about it. Justice Scalia has long been a hero of mine, and I think he's mostly right about most things. In the religion area, I think he was absolutely right about his view of the Establishment Clause, his view about Lemon and the idea that the court's jurisprudence had just really gone off the rails. It's funny, as preparation for this, I went back and reread Lemon, which is a case I've read 50 times in my life. But every time I reread it, the same thing strikes me, which is in Lemon versus Kurtzman, the court doesn't even pretend to be trying all that hard to figure out what the words mean, like what is an establishment of religion. They just say, like it's kind of opaque, it's kind of hard to figure it out, and so we have to glean rules by looking at our own cases. So it's like, I can't really figure it out from the Constitution, so I'm just going to think about what we think.
And do navel gazing.
And we're just going to come up with like one rule to rule them all, a bunch of different balancing things, and Justice Scalia was absolutely right to rail against that repeatedly and say that that is not law. It is not constitutional law. And when you look back at from around the time of his death, some very good scholars are looking at it saying, on the religion clauses, particularly on the Establishment Clause, he kind of failed. Like he kept waving his hands and saying there's this problem, but he just couldn't get the court to go with him. By a decade later, he's an absolute success on that front. And the court went exactly, I think, where he was saying they should go. And they have thrown out Lemon, they have killed that ghoul, and they have replaced it by saying, we care about what was an establishment. What was an establishment when the people agreed to ban establishments? And that wasn't just some fuzzy thing that was up to judges, how much they think is too much religion. Actually, establishments were things, and they had characteristics. And the court now quite rightly relies on some of Michael McConnell's excellent scholarship in this area to say that we know what an establishment is, and it's not just anything a judge wants to strike down. So that's a place where I think he was exactly right, and the court has since done a great job, I think, of following his lead in the years since his death. A place he was, to me, less right, or I'll be so bold as to say wrong, was his decision in Employment Division versus Smith, which really at least seemed to restrict free exercise protections to something like an equality right. And Justice Scalia said that as long as the law is neutral and generally applicable, you don't really have much of a free exercise claim about that. And we can talk about it more as we go, but at a really high level, that's a very bad way to protect the right to freely exercise different religions. If we all had the same religion, the same religious beliefs that we were trying to exercise, then saying it's got to be the same rules for everybody, that'd be a great way to protect that right. But if we're going to be free and in a pluralistic society where we're allowed to exercise different religions, we're going to need to allow for different treatment of people who, the Jew needs to do something different from the Catholic, the Muslim, the Native American. If we're going to be serious about that, Smith is a bad rule. And I will just say that Justice Scalia, I think toward the end of his career, actually started to lay down some markers about ways maybe Smith wasn't supposed to cover quite as much as people thought it did. And in the years since then, I think the court has dramatically improved how Smith functions. I still think the court needs to and should get rid of it, but I don't think it's nearly as damaging as it may have looked a decade ago.
Thank you. And Philip?
Well, thank you, and it's a pleasure to be here. Thank you especially to Ed and to Yuval and to Adam for including me in this conversation. Look, I'm here to say Scalia was right about Smith, which he was, which he was right about Smith, and I'll say a little bit more about that later. Ironically, maybe where I dissent here is where I think, let me start where I should. Scalia was a devastating critic on why no one else on the Supreme Court got anything else right about the religion clauses. And his criticisms, often in dissent, but not always, of the court's wall of separation jurisprudence in the Establishment Clause context, it was just, it's delightful to go back and read it because he is at the same time polite and scholarly, but those opinions are so devastating. And it's so clear, he makes so clear how the court was just making things up and not seriously trying to understand the Constitution. Where he was less good on the Establishment Clauses, to my mind, he never actually explained what the Establishment Clause prohibited. Which brings us to today, where the current court is trying to figure out, what does the Establishment Clause actually prohibit? Scalia was masterful at saying why it allowed all these things, but what work did the clause actually do? Ironically, on this point, he left things too vague. He didn't lay down a clear rule. His principle or his standard was no legal coercion. But no legal coercion of what exactly? All laws coerce. So to my mind, he never actually adequately understood what an establishment of religion actually is. Now, that's not a criticism because he wasn't writing a majority opinion on these matters. His job at the time was not to lay out a full understanding of the Establishment Clause. He was often writing in dissent and trying to show why what the court was doing was wrong. I wish he was with us today so he could finish what he had started. Just one thing on the free exercise clause for now, and I'm sure we'll come back to it. Here, I think you see his instincts on why free exercise couldn't mean exemptions, for the most part, for religious believers from burdensome laws. Here, too, he never fully articulated why that conclusion was correct. But we'll develop, or at least I'll try to develop why I think his instincts brought him to that conclusion. In going back and reading Scalia, I was reminded of my 7th grade teacher at St. Bernadette Elementary School. In math class, she always used to tell me, look, you got to show your work, even if your conclusions are right. And going back and looking at Scalia's opinions again afresh, I often had that feeling. His conclusions were right, but he didn't always show all the work on how he got there. I suppose that just leaves work for us to do.
Okay, well, let's do some of that work. Before we do that, let me just encourage the panelists. When I used to be a law professor and then I became a judge, and I like to say, when I was a law professor, I knew everything about nothing, and then I became a judge, and now I know nothing about everything. And just remember, most of us know nothing about everything. And so especially on case names, if you could just do a sentence or so to remind us what that case is. Justice Scalia was terrible about case names, and he would, when we talked to him, he would say, there was a case 15 years ago, and a lady was pushing a carriage across an intersection, and like a fire truck came by and hit them, and the thing is, he'd remember 5 things, and 2 would be wrong, and 3 would be right. And so it was really hard to research. You had to keep trying different combinations because he just, and likewise, it's hard for some of us to connect the case to, give us that sentence or 2 so we can remember what the case is. So we're going to turn to the Establishment Clause. Philip, why don't we start with you? I thought your point was interesting that Justice Scalia mostly was firing away in dissent on Establishment Clauses. Maybe you could give us a little more detailed background on that, and are there hints in those dissents as to, if he had written that majority opinion, what it would have looked like?
Yeah, if you don't mind, I want to. This is my favorite sentence from Scalia, not the one about the ghoul, but this is I think how he began his opinion in a case called Van Orden v. Perry, which is about the posting of the 10 Commandments. In this context was in a courthouse. Something similar is being litigated right now. He writes, I join the opinion of the Chief Justice, Justice Rehnquist, I join the opinion of the Chief Justice because I think it accurately reflects our current Establishment Clause jurisprudence, or at least the Establishment Clause jurisprudence we currently apply some of the time. And that was very much him. So the wall of separation, which was a doctrine or a standard that was laid down by the court in 1947 in a case called Everson versus Board of Education. And the court, and this was an important case because it was the first major Establishment Clause case that the modern court heard. And it said the First Amendment erects a wall of separation, or strict separation between church and state. In the 60s, the court would use that doctrine to eliminate prayer in public schools, Bible reading in public schools, cases that got a lot of headlines about removing religious displays in the courthouse or the town squares. That was all from the wall of separation. And Mark made a reference to the Lemon test. That comes from a case in the 1970s, Lemon v. Kurtzman, where the Supreme Court puts a 3-part test to make the rules to build the wall of separation. Maybe I can put it that way. And Scalia thought all this was wrong. And it was wrong because it did not accord with our nation's traditions. And he was so good about just invoking examples. George Washington, in his first inaugural address, if you read the inaugural address, it's a prayer. The Supreme Court begins its sessions with a prayer, and the 10 Commandments are posted right there. The legislature, the same week it adopted the Congress, the same week it adopted the First Amendment, approved an appropriation to hire a legislative chaplain. And what he was so good at showing was, in our nation's practices, especially at the time of the founding, the founders took actions that could not be read to be consistent with the modern court's wall of separation jurisprudence. And his conclusion, therefore, that can't be the meaning, at least the original meaning of the Establishment Clause. And no separationist judge could meet him on those terms. His history was just too good, and he wrote it so well. Right? He picked it. He was a master craftsman at how to present historical evidence.
So, so he can shoot down the opinions of the majority by saying that can't be the original meaning because these things happen. Yeah. So, what did he think was the original meaning? Did he ever tell us?
Just one more thought on this, and then okay. Please, Stephanie, go ahead. You go.
Well, you go ahead. You finish.
Well, he would say the doctrine. He would say all establishments at the time of the founding were coercive, and so he tied it to the idea of legal coercion. So like displaying the Ten Commandments or voluntary prayer in the school, there's nothing coercive about it. That's true, but it's too general, it's too vague. What exactly were establishments? And he never teased out, because he never wanted to go behind. Why do we have an Establishment Clause? What was the purpose? But he didn't like doing that type of jurisprudence. He didn't like going beyond the text to try to find the underlying purpose for having the text. And his methodology, I think, prevented him. It made him a very good critic, but when it came time to construct the meaning of the text, here he was weaker. And examples from history, tradition, can show what is allowed, but there's not a lot of examples from history to show what is not allowed. And so he was never able to articulate a framework on this is what's not allowed.
So, I mean, I think he did give some concrete thoughts about what he meant by coercion in terms of laws that were coercing particular types of religious observance at the founding. And I agree with you that he wasn't giving like his fully fleshed out theory of everything that an establishment of religion meant, but also, to be fair to Justice Scalia, this is a fun, turnabout fair play in terms of who's defending Scalia more. The scholars weren't writing a lot of amicus briefs to help them out. There's a division of labor here, and so where everybody was focused on Lemon, his right goal, I think, his important goal was let's take that down first, and then we can think more about the history. But he was correct, I think, that generally one of the ways in which there were establishments of religion at the founding and colonial establishments and also the Church of England was when there were ways in which the government would do things to coerce individuals to participate in religious observances by force of law or threat of penalty. And so he was making an important distinction here. The fight he was having with Kennedy and other justices is that's different than peer pressure. They did not recognize at the founding that, like, if you felt a little nervous because you had to stand up or maybe leave a room, like that was an establishment. That's not what was going on at the founding, and I think he was right about that. So with the division of labor of others who have also thought harder about what does an establishment mean, I think Michael McConnell has done really important work in this space. He wrote an article that the Supreme Court cited in Kennedy where they made clear that Lemon is really dead now, and in their footnote where they talked about how this type of coercion of participation in religious observance, is among the historical hallmarks of established religion, but that's not the extent of it. That's not the end of the story. And they also cited to Justice Gorsuch's concurrence where he talked about those 6 hallmarks of established religion. Those include, number 1, government exerting control over doctrine and personnel of established church. Number 2, government mandating attendance in the established church and punishing people for failing to participate or participating in religious exercise. 3rd, government punishing dissenting churches and individuals for their religious exercise. 4th, restricting political participation only to those who are part of the established church. Fifth, providing financial support for the established church in preferential ways, so not providing funding in neutral and even-handed ways. And sixth, using the established church to carry out certain civil functions by giving the established church a monopoly over a specific function. So maybe one area where you and I diverge on this, Phil, is I think what the court is doing, sort of drawing on and building on Justice Scalia's approach that was looking hard at what were the actual laws at the founding that constituted an established religion. There's a concrete body we can draw from. We don't have to go to a high-level abstract purpose to think, well, what were they trying to do? What was motivating them? Finis would say that there are multiple and infinite purposes that government has for advancing a law, so would Aquinas. So like to try and pick one, I think, is a faulty endeavor that we learned our lesson from with Lemon when the court was trying to do that, like the one purpose to rule them all. Let's look more concretely at a lower level of abstraction about what was actually prohibited. That leads to a much more modest approach to Establishment Clause, one that is less likely to strike down government action, one that is certainly less likely to make the Supreme Court the interior designers of every creche and Christmas display and menorah, which they're not very good at, and to step back from policing every religious display, which is one reason why I think under this hallmark approach, the Establishment Clause, for example, the recent laws passed by Texas and Louisiana that would allow display of the Ten Commandments probably ought to be upheld constitutionally. And it was these hallmarks and Justice Scalia's approach to a more concrete understanding of coercion that were being discussed by the en banc Fifth Circuit. And I think that's a compliment to the legacy that Justice Scalia has left us in this area.
Mark? And let me add like one other place where we do, like, I think Phil's got a good point, which is that for the most part, Justice Scalia on the Establishment Clause side was in the tear down a bad thing mode rather than the build up some other way to do it mode. One place he was able to do that related to the Establishment Clause, though, was in church autonomy, the Hosanna Tabor versus EEOC case back in 2012. So Hosanna Tabor is a case about a teacher in a Lutheran school who gets into a fight with the church. And the question is over what's called the ministerial exception, whether the government can have discrimination rules and other rules that will tell the church, no, you need to put this person in the classroom teaching religion to the children. And there, the court did something that, it had at least rarely previously done, I think sort of out of character for the last 50 years, where it basically said, look, the Establishment Clause and the Free Exercise Clause are both working here. And they're not working at opposite cross purposes, which is how they're sometimes thought of and taught, particularly in the Lemon era. But in fact, the Establishment Clause also keeps the government out of certain things, like picking the ministers, picking who's going to teach religion to the children. And so that's a place where Justice Scalia, I think, started to be able to be in builder mode, started to be able to be in the mode of saying, here is what the Establishment Clause forbids the government from doing. And I think if you look at what's happened since then, both at the Supreme Court with Hosanna Tabor and then the later case, Our Lady of Guadalupe, which is about a Catholic school teacher a few years ago, both at the Supreme Court and in the lower courts, that church autonomy line has been built out quite a bit over the last decade. And that's a place where Justice Scalia's ideas about the Establishment Clause are working in tandem with the Free Exercise Clause. And there's more I'd say about that when we get back to the Free Exercise Clause, because Justice Scalia had interesting ideas in that oral argument, too.
Oh, one other thing about the Establishment Clause, I think Scalia and Thomas and Gorsuch now are right that it's really questionable whether the Establishment Clause should even be incorporated at all against state and local governments, which is another reason for us to be particularly modest about how we interpret it to the extent we are going to incorporate it against state and local governments. But I think Scalia would have had the better of the argument that that should have just been a federalism, federal government sort of limit. You, federal government, keep your hands off the establishments. We don't want you to make your own. We don't want you to muck up the state establishments. That was the understanding when that provision was added to the Constitution, and it's a particularly important reason why I think it's a bad fit for incorporation.
Well, that would clean up the Establishment Clause jurisprudence.
Clean up the docket of district court judges nationwide.
Yes, people talk about the political preferences of district judges or how their own their own views. Whatever creates less work for me, good. Whatever creates more work, bad. So they could unincorporate all that stuff. That would really clean things up. Philip, did you want to respond to what you heard from your colleagues?
Well, I agreed with almost everything that was said. I would just say that maybe one of the sort of bad to come here and criticize Scalia, but one of the difficulties or challenges maybe of his approach to free exercise is, I think Stephanie is exactly right to focus on coercion, but everything that Scalia said about the Establishment Clause, he also said about the Free Exercise Clause. He made the Establishment Clause redundant because free exercise prohibits coercion of all these things.
Which is why he wasn't quite right on free exercise.
So he I think he knew this. And maybe an example will help. So he points to, in colonial Virginia, the Anglican Church was the established church. And one of the things, and he gives this example, is that you could only be married by a licensed minister, an Anglican minister, right? So that's an establishment, all right? It's kind of like you can only teach in a public school if you have a teaching license. Is coercion the central element of that problem? Is the problem with state licensing of ministers, is it coercion? I mean, there is a coercive element, but that's incidental. The real problem is the monopolistic relationship between the state and the church. But Scalia never wanted to develop that out because it would be hard, I think he thought, to get clear rules out of that. And who knows where those judges will go once they start going beyond something simple. But this made him basically erase the Establishment Clause and put everything that he already said was unconstitutional in free exercise into establishment. Now, there's an advantage to some people that allows them, if what should be prohibited under the Establishment Clause is now, if what should be prohibited under the free exercise is prohibited under an establishment, then you can do something else with the free exercise clause. But Scalia didn't want to go that way either.
Can I just add, I guess I think of it less as erasing the Establishment Clause. Like another way to think about it is just that the Establishment Clause actually is wildly successful because to the extent we're thinking like the government saying this one church can be the only church that can marry people, no government tries to do that, right? It's like no quartering of troops in your house under the Third Amendment. We don't get any cases on that, like darn, right? But like actually the right way to think about it is, oh, that one works really well, right? The government just doesn't try to do that to you. And I think on things like the government giving one church a monopoly, which very much, Phil's absolutely right. That was like a defining characteristic of what establishments were like at the founding. And it's totally foreign to anything people think about even beginning to complain about as an establishment today or throughout the whole era that Justice Scalia was complaining about. None of those things, maybe Larkin versus Grendel's Den, where some church had the ability to veto a liquor license, but almost nothing actually looked like that kind of monopoly. Mm-hmm. And I think that probably just means the Establishment Clause works really well. And it doesn't necessarily need to be sort of hauled into service to do a lot of other stuff.
May I develop a point just to explain something that Stephanie pointed to already on church autonomy? So an example of what an establishment was at the time of the founding, and this is not something Scalia himself said, but he pointed to in his opinions, is the 1778 Constitution of South Carolina established the Protestant church. It's actually the one state that had a clear establishment. And in that Constitution, it did two things. It prescribed how ministers were to be selected. Right? So it said, this is how you select ministers, right? And this gets to church autonomy doctrine. It's a concrete example of what Stephanie's talking about. So the state told churches how those ministers must be selected. The state also, every church to be incorporated, there were no general incorporation law. So if the church wanted to own property, it had to get an act of incorporation from the state legislature. In that act of incorporation, the state would tell the church how much money they could raise in any given year. That's what an establishment of religion looked like. Also in that state constitution of 1778, South Carolina, there was an oath in office that ministers had to take, kind of like the oath of office of governor or president. Those were all prescribed in the state constitution. Again, coercion is not the central element of those. It's the government controlling or regulating the church, right? And I think all that's there, and Scalia actually points us to that direction by talking about tradition and the importance of tradition. He himself just didn't do that work, exactly for the reason Stephanie said, that the task before him was not to do that work, and the scholars hadn't done that work yet. You could say the court is able to do that work now because of all the clearing of tearing down the wall of separation that had to be done first, and that's really Scalia's legacy in the Establishment Clause arena.
Yeah.
Well, the history doesn't matter unless the justices thinks it's matter. Are we to the point now where it's firmly entrenched that the history matters?
I think so.
I think so too.
Yeah.
So is that an impact of Scalia on the religion clauses, even though on the Establishment Clause, even though he mostly wrote in dissent?
Yeah, there's no question that his legacy is one of the most important reasons why the court is looking so much to history for the religion clauses generally, certainly the Establishment Clause, and I know you're going to get to it next, but the Free Exercise Clause increasingly as well, I think.
Let's wrap up the Establishment Clause. If you could just briefly explain for us non-experts in the room, and you've already touched on some of this, how has Establishment Clause jurisprudence moved since the justice's death, and how do you see it moving in the next 10 to 20 years? And to what extent can that be, is there a Scalia influence on what has happened and what you expect to happen?
Yeah,
Mark?
Yeah, I think the quote Phil read before from Justice Scalia in 2005 in the Van Orden Ten Commandments case saying, well, I agree with this because it's the way the court does Establishment Clause, like at least some of the time when it chooses to, right? What the Establishment Clause looked like, say for the 50 years from the early 70s to 10-ish years ago. That's 40-something years. What it looked like for a long time was very intermittently applied rules, right? They would say Lemon gives us this 3-part test, and all the lower courts in the country would try their best to fumble through applying it, and the Supreme Court would apply it like once in a while, but they'd skip it the next 3 cases. So we had a very haphazard, a very wall of separation-y, a very judicial Rorschach test kind of Establishment Clause, where judges would just kind of figure out what seems like too much religion. Justice Scalia was the voice crying out for a very long time, with others joining him over time, saying, like, that's obviously wrong. That is not constitutional law. That is not an attempt to understand what the people actually banned with the Establishment Clause. And we should care about what those words mean because that's the only thing the people banned. And we should care about history when we're figuring that out. So Scalia pushed the court to do that. In the years since his death, the court has just, finished that part of the story and said, Lemon is clearly no longer the rule. What counted as a historical establishment is the new standard by which we're going to judge it. That's very much a legacy of Justice Scalia. I think everybody would agree to that. And in terms of what the future holds, I think there's really 2 things that seem likely to me. One is we'll get a little bit more build out of which cases tripped those wires of hitting the hallmarks of what looked like an establishment at the founding, right? Because for a long time we were fighting about, well, if you let somebody put up a Christmas or a Hanukkah display, you've now established something, right? As if Pittsburgh was suddenly a Jewish town when they put up a menorah. Or as if the town of Greece, New York became a Wiccan town when a Wiccan said a prayer. Like it was all nonsense. And the nonsense idea of the Establishment Clause, I think, is gone. And we're going to hammer out now, okay, under the new historical view, what actually counts as an establishment. But if I can do a little predicting, what I think we're going to find is just that the Establishment Clause largely does its work by making sure states, local governments, and the feds don't have established churches. They don't give monopolies to religious groups. And it does its work, frankly, and this goes to something Professor Amar said, mostly not in the courtroom, mostly in the realm of legislators who don't even bother trying to have established churches.
one friendly amendment I will add to that, and I agree with everything Mark said. So I think we will see build out of some of those particular hallmarks. What does this mean? You know, in the Ten Commandments context, I wouldn't be surprised if the Fifth Circuit says having the Ten Commandments in a classroom does not equate to coercing school children to participate in a religious exercise. Those are not the same thing, and a lot of the historical evidence at the founding of religious displays in government buildings or prayers in government contexts, I think supports that sort of view. So you could imagine like those sorts of doctrinal developments. If the Fifth Circuit gets it right, I think there's like the need is not going to be high for the court to grant cert in that case. And so to Mark's point, we probably won't see a lot of churn on those Establishment Clause issues, which I think a lot of that work will be done if we're interpreting the Establishment Clause more modestly. Where we will see more action on the horizon is where the Establishment Clause and the Free Exercise Clause overlap with church autonomy. Justice Thomas just wrote a great concurrence in the Catholic Charities Benefit case. This last term, Judge Oldham and Judge Bumate have just written church autonomy decisions. So I think that's where action will happen in a positive way as we continue to develop how those protections operate, where those religion clauses speak with one voice. And that was, again, an area that Justice Scalia was part of that legacy in Hosanna Tabor. And one other thing I'll say about that case is an example of how I don't think Justice Scalia thought the Establishment Clause was limited to coercion. It included some types of coercion, but it did more than that, is the opinion in Hosanna Tabor talks about a time where a church asked the government at the founding to give advice about how it should run its internal operations. And Madison said, that's not an appropriate province of government. So that's an example where there was no coercion, and the Establishment Clause was still saying, this is a separate sphere of government and religion. I think that's right, and I think that's a reason why we'll see doctrinal development beyond just treating coercion as the sine qua non of the Establishment Clause.
And Philippine, you want to have a last word?
We should move to free exercise.
We're running out of time.
These folks are all, they're all itching to talk about free exercise, and they are because of employment division versus Smith. And so my understanding is from Adam's notes that we have two critics of Smith and one defender. So maybe we should hear the criticisms first. Maybe we should hear what Smith is, just to remind us all. And then maybe, Stephanie, you could just start by an overview of Smith and why you think it's less right.
If it's okay with you, Mark and I chatted. I think he'll go first.
Okay, well, that's fine.
That's okay.
Sure.
Sure. So employment division versus Smith is a case Justice Scalia decided for the court in 1990. And it was over a Native American who, as part of a religious sacramental ritual in his church, wanted to smoke peyote, a hallucinogenic drug. And the question in the case is, does a law that would punish him for smoking peyote, has that denied him, has that prohibited his free exercise of religion? And Justice Scalia, writing for the court, said, no, it doesn't. And he said the reason it doesn't is that a neutral and generally applicable law that restricts your exercise of religion doesn't give you any constitutional rights. In other words, if a neutral and generally applicable law is what stops you from exercising your religion, you're out of luck. And that decision set forth the standard that's often been used going forward, although again, it's been, with the modern court, it's been trimmed, and I think Justice Scalia led us to some of that trimming before he left the court. But that's the basic rule from Smith. And the alternative to that rule is a rule from a couple of earlier cases that applied what's called strict scrutiny when there was a burden on your religion. And what the strict scrutiny type of approach says is that if the government prohibits your exercise of religion, if it stops you from doing something you're religiously required to do, or it forces you to do something you're religiously prohibited from doing, the government needs a really good reason to do that, right? The government's got to have a compelling interest to do that to you, and it's got to be using the least restrictive means. And so the prior way of thinking about it was more protective of religion, at least in terms of the tests that were applied. But Justice Scalia said that we need to have this neutral and generally applicable standard instead. And his reasoning for that, he had several reasons. The opinion on its own is, I would say, utterly non-originalist and doesn't pretend to be originalist. Justice Scalia doesn't break out the dictionary and do the other things that we expect. If you put Smith next to something like DC versus Heller, the gun case, they look like different people wrote them. So Smith doesn't really pretend to be doing originalism, although I know there are originalist arguments in defense of Smith, but on its terms, it doesn't pretend to be doing it. The court talks a lot about the effects that would happen if we had a regime that allowed people to not get punished where the law prohibited their exercise of religion. Justice Scalia said that would be anarchy. We would be courting anarchy. We'd make every man a law unto himself if we had that rule. He also said that it was bad for the judicial role, that judges shouldn't be in the business of balancing the government interest against the centrality of somebody's religion. And so Justice Scalia, for those kinds of reasons, at least on the face of Smith, said we need this rule. And I'll just briefly say, as I mentioned before, I think that's exactly wrong. I don't think that actually protects the free exercise of somebody's religion. I understand the instinct toward equality-based rules. They often make a lot of sense, but I don't think they make sense for diverse people with different religious beliefs. And I actually think we've learned quite a lot since 1990, and I think Justice Scalia may have signaled he was seeing some of this too before his passing. But we've learned quite a lot about whether it's anarchy or not. And it's frankly just, it's not anarchy. That's the system we live with under many statutes, under the Federal Religious Freedom Restoration Act, under many state Religious Freedom Restoration Acts. So we actually have run the experiment in the 35 years since Smith to find out that it's actually not anarchy, that judges can do this just fine. I think strict scrutiny has been improved by those statutes, which maybe we can circle back to.
Okay. Yeah, and Stephanie, oh wait, I thought you were going to follow.
Go ahead, Stephanie. Yeah.
Okay. So I agree with what Mark said. Let me just address some concerns that Justice Scalia had about strict scrutiny that I think are fair. And so I can understand why, if he's imagining this is the only way we can do strict scrutiny around here, why he might be hesitant about that. He was worried about courts judging the centrality of religious belief and asking questions like, how important is this really to this religious community? And I think we can understand, right? That's not the type of question courts should ask. Like, how much do they really have to repent if they do this? Like, how many Hail Marys are we talking? Right? Like, that's not the type of question courts should be asking. He was also worried about courts engaging in loosey-goosey balancing, where they were deciding, do I think this religious exercise matters more than this government interest? And I agree with him that that's not the type of endeavor that I think judges are particularly good at. I just don't think that strict scrutiny requires us to do both of those things. And I think Congress's enactment of RFRA shows us that. Congress in RFRA says that we shouldn't look to centrality of religion. We just look more at objective, substantial burdens on religious exercise. And I think that strict scrutiny is operating both under RFRA and also the court's modified approach to religious exercise in cases like Fulton or elsewhere isn't doing balancing. It's really doing an exclusionary norm where it's saying some government justifications are off the table, and then those that are allowed has the government demonstrated with a heavy evidentiary burden that its actions are necessary to advance those sorts of justifications. I think that if we think about like why else did Justice Scalia arrive at the decision that he did in Employment Division versus Smith, to be fair to him, that was a position being pushed by the Solicitor General's office in a number of administrations, but particularly the Reagan administration. There was a DOJ report written by Attorney General Edwin Meese's office, where it focused on the word prohibit. It was really heavy on that term in terms of like, we read the First Amendment, we know what prohibit means. That seems to be a more targeted sort of discriminatory approach to religion. And I'll come back to this, but Justice Scalia's opinion in Smith is really envisioning like a legislature just going about its role, doing its work, accidentally butting up against religious exercise. So a couple of things about that. Ultimately, Attorney General Edwin Meese wrote an amicus brief in Fulton saying, mea culpa, I think I got it wrong in that report, focusing too much on a textual interpretation of prohibit that actually other textual evidence undercuts. And the historical evidence that Michael McConnell marshaled in an article that came out just a few months after Smith was decided is more persuasive. I'm persuaded I got it wrong. And so if Meese has said mea culpa on that, maybe more of us can too. The other thing is that Justice Scalia's focus on the legislature, while fair, hasn't turned out to be the source of most of the threats to religious liberty. And that's why people like Phil Hamburger, who support Smith in the context of legislative action, do not support Smith in the context of administrative action. And it turns out the vast majority of threats that we've seen to religious exercise in recent decades are coming from administrative action. Often an administrative official who knows exactly how their action is going to burden the religious person could grant an exemption or change the rule in 5 minutes, and they choose not to. And that's not the world that Justice Scalia was writing about when he wrote about incidental burdens on religion. Justice Scalia did double down in Bernie. I agree he didn't do any sort of, as far as we could tell, historical originalist or textualist work in Smith. And in fact, Justice O'Connor's papers show, in an article I just recently published with my co-author Matthew Crowder, that the court wasn't really discussing text and history at all in their internal deliberations leading up to Smith. It just wasn't a focus. They were worried about consequential things like, would the government be able to get its work done? But Justice Scalia does have more historical arguments in Bernie, where he doubles down on Smith. And he points that the absence of founding-era judicial enforcement of religious exemptions proves, he says, that the Religious Exercise Clause wouldn't require them today. But by those lights, there's a lot of other important cases that I think we would also have to say are wrongly decided, including Heller. So there's not a single reported case enforcing an individual right to bear arms that I'm aware of before a case called Bliss in 1822. There's no federal court substantively addressing the Second Amendment before the Civil War. The record of judicial enforcement is actually thinner for the Second Amendment than for religious exercise. We have earlier cases granting religious exemptions, including cases like People versus Phillips, where the court is asking questions like, what is the government interest? Reducing crime, that seems permissible. Has the government actually demonstrated that it has to take away a Catholic priest's ability to keep a confessional private in order to advance this interest here? Color us skeptical. You have exemptions in the law, and we don't think you've demonstrated that this is the only way to get it done. Should sound familiar. Those are the same sorts of questions we ask today under strict scrutiny. So we have that sort of evidence for religious exercise earlier on than we do for the Second Amendment. Part of this is we just didn't record judicial decisions with any sort of regularity or predictability at the founding. And so if we have a thinner record for rights like the Second Amendment, then either this methodology of Smith has to say they're both wrong, or that's not the right way, that we should decide whether rights are entitled to protection in our constitutional framework. And I would say it's the second one that we should focus on. That cases like People versus Phillips and other historical evidence that Michael McConnell marshals about Madison and Washington show that something like strict scrutiny is a permissible way of implementing the promise of the Free Exercise Clause.
Let me just ask before turning to Philip for the defense. So when I was in law school, we were taught that strict scrutiny means it's unconstitutional, that almost nothing survives strict scrutiny. You say our experience under RFRA and the other statutes since then shows that that's not the truth, not necessarily true. Is that really strict scrutiny that's being applied under those statutes?
I think it's real strict scrutiny that's being applied under things like RFRA and RLUIPA. That doesn't mean every prisoner wins the case against the prison, right? Very often things like prison security are true compelling interests. But it does mean that most of the time, when you think of like our big public fights over religious liberty, like the right answer really is, oh, the government can do that a different way, right? So like the Little Sisters of the Poor are fighting with the government over whether they should be forced to provide contraception. Like, it's the United States government. Like the idea that the United States government doesn't have some other way to get people contraception without the help of Catholic nuns, like that's a crazy idea, right? And that's actually true of many things that the government does, right? Most of the time in a pluralistic society, the government really can work around somebody's religious objection. Not all the time, right? You could have cases, like right when COVID started, for example. If somebody had a strict scrutiny case in March of 2020, yeah, there's a good chance the government could win that case, right? Because all of society got shut down. When you get a few months later and you're opening up the blackjack tables and the George Floyd protests, but you're still saying, nope, you can't have mass outside, then the government should lose. So, I guess I think it is real strict scrutiny. I think the government should almost always lose under strict scrutiny because I think it's very rare that there's a legitimate need to force somebody to violate her religion. But I think the test allows it to happen when it's really necessary.
Prisoners are, I have some experience with this. Prisoners are very, very creative at deciding what's part of their religion.
And
and I can't decide whether that's sincere or not. We had a series of cases in Minnesota a few years ago brought by prisoners who were members of the Sutra religion who said they had a constitutional right to a Thor's hammer in their cells, which seemed, I was thinking the one in the movie, and I was thinking that would be bad
They can't have that.
in a prison. And fire pots, and fire seemed like a bad idea inside a cell too, and we had those cases. But they're very, very clever about what they say as part of the religion. And isn't there something to Scalia's concern that if every prisoner is a religion unto himself, it's just going to become impossible?
No, right? We have that as the federal law, is that we have precisely that test, and we have smart judges who can apply the test, and it actually ends up working. And so sometimes the claims are so absurd that you know it's insincere, and I actually think judges are allowed to say it's insincere. Judges judge people's sincerity all the time. And two,
and have since the founding, C.E.G. Lord Mansfield.
Yeah, and have for a long time. And two, I mean, you're absolutely right. Like, of course, prison security is a compelling enough answer that no, the guy can't either have the magical Thor's hammer or even a pretty serious pretend Thor's hammer, or a bowl of fire in the prison. Like, I actually think it's pretty straightforward to say, yeah, the prison should win those cases. Like, those things are dangerous. If the prisoner wants communion once a week, if the prisoner wants a copy of the Quran, if the prisoner wants to grow a half-inch beard, then the prisoners should win those cases. And I think the truth is, like, they do, right? So I actually think prisons are an example of a place where, of course, you'll get fake claims, right? Of course, you'll get people making stuff up. Of course, you'll get requests for dangerous things. But I think the test can and does handle them, and has for 25 years under RLUIPA.
Which is why I think you've seen the Solicitor General's office have an about face on this. So under the Reagan administration, it was like, I don't know if we can run government that way. And then Congress passes RFRA and RLUIPA, and we have decades of history showing it works really well. And the Trump administration just this last month filed an unsolicited amicus brief in the St. Mary case pending, saying we need stronger religious exercise protections, more exemptions from these sorts of laws. And they've done that in numerous cases, including Fulton, because it's a really workable rule and the sky hasn't fallen under RFRA or RLUIPA.
Philip, you're here, as you said at the beginning, to defend Smith. Let's hear your defense.
Oh, I think we're out of time. Let me set a little bit more context here. As far as I can tell, I might be wrong about this, but as far as I can tell, none of the supposed conservatives on the Supreme Court agree with Smith. I don't know that anyone on the Supreme Court right now agrees with Smith. It might be 9-0. As far as I can tell, no conservative legal thinkers agree with Smith, except for me. So this is not a popular opinion. Hadley's with me. Hadley's with me. So Michael McConnell wrote an article, I might get the title wrong, but about Smith. I think the title of his article was Justice Scalia's Worst Opinion. And I think that's the common understanding of Smith. Maybe one other interesting thing about it, when you go back and read Smith, I read it for the first time last night in probably 20 years. It's a very thin opinion. He says very, very little. In fact, the key passage, though all of his reasoning is just really in 2 sentences, right? He does a lot of lawyerly work trying to explain why, the precedents actually support me, when they clearly don't. I mean, it's a masterful rhetorical job. What might he say, or what might he be thinking if he just heard this discussion? He would be saying the danger of your approach is it equips judges to think their job is to dispense justice as they see fit. It's a recipe for the rule of men and not the rule of law. If you go back and read his famous law review article, The Rule of Law as a Law of Rules, it actually begins with these examples of the wise man who the people bring disputes before him and he adjudicates justice eloquently and beautifully on a case-by-case basis. And everyone's happy with him. And that is the danger of judges in our system of government. That they will think their job is to do justice. Individually, case by case. In his critique of the exemption granting approach is that it undermines the rule of law. You can say, what's so great about the rule of law when it leads to unjust results? Right? And it does. That's why it's so tempting not to have the rule of men, or the rule of the wise man, which of course we all know means federal judges, and the people who make arguments before them. Right? And that's so what's wrong with that approach? It will do justice in individual cases. Fundamental problem is an essential component of the rule of law is that all are equal before the law, and not equal results. Remember, the law is blind. Whatever the law is, you are subject to it. Now I'm going to say something, one more sentence, and I know Justice Scalia would disagree with this. This is me, not him. The ultimate grounding for Justice Scalia's opinion in the Smith case is the proposition that all men are created equal. It is the fundamental precept beneath the Constitution, underlying the Constitution, that we are all equal, and when we join the social compact, we all are subject to the same law. The law must apply to us equally. The solution for laws that have unjust outcomes is either change the law or rescind the law. Scalia would say, I think, not to equip justices and the lawyers that influence them to do justice as they see fit.
Is the choice between the Smith equality approach and strict scrutiny, are those the two options that scholars and judges consider when they're considering where to go with free exercise?
If you can find another approach, Justice Barrett is looking for it.
Well,
I think the truth is that's a lot of it, but that's not all of it, right? And Justice Scalia started building some of this out with Hosanna Tabor, saying there's some things that just sit outside the rule of Smith. He built it out a little bit. Church autonomy. Yeah. He built it out a little bit in a case called Locke v. Davey about a scholarship program in Washington, where he said, essentially, well, this has to get treated to strict scrutiny too. So Justice Scalia, I think, was, before he passed, I think he already built some of that out. I think the answer to replacing Smith is not, one rule to rule them all. That was what was wrong with Lemon. I think that is what's wrong with Smith, and I don't think that's like the right way to go. I think different types of cases would get different types of rules, but I do think often it would be the case that the rule would be that the government shouldn't force somebody to violate her religion absent a really good reason. And that is the rule that we've had at the federal level for 30 years. That's the rule that we have in about 2/3 of the states. And it just it simply doesn't create anarchy, and it's not lawlessness. It is the law. The law says there's certain things you can't make somebody do. And sure, a Jew is not the same as a Native American, it's not the same as a Muslim or a Catholic, but that's not anarchy, right? No one has ever driven over the state line between Maryland and Virginia, going from a RFRA state to a non-RFRA state and been like, whew, I'm out of that anarchy, right? Like, that doesn't happen because these systems work fine. And we may not have known that in 1990, but we know it crystal clear with the experience of all of our lives over the last 30 years.
If I could just add to that, so the approach that myself, Michael McConnell, Doug Laycock, Mark Storsley, Chris Lund, a lot of scholars who care about original meaning and the religious exercise protections, think that strict scrutiny, something like what operated before Smith, but probably a more RFRA, more historically bounded version of strict scrutiny, should be a default. So if you imagine the walls of a castle, you're at least going to get that, but then the turrets of the castle coming up where you get things like church autonomy, where you'll have categorical, deeper protection in some context. I think both are true, and both are an important edifice of religious exercise. If I could just also respond to this point that you made, Phil. By the way, I highly recommend Philip Munoz's book. If it wasn't for part 3, we might agree on just about everything. And I think that part 3 does a good job of saying there's not just one test that's required by the original meaning. We have to do some constitutional construction or implementing doctrines, whatever you want to call it. So how do we do that in a way that's faithful to the original meaning and the understanding? And so here's why I would say your approach of saying we should either just strike down the law. This is on page 232, where he says basically we shouldn't grant exemptions. The proper remedy is just to strike down a law as null and void because it exceeds Congress's constitutional authority. That's what we ought to do. Here's the problem I have with that approach. First of all, Sam Bray's work in multiple chancellors and elsewhere makes clear that actually the judicial remedy of facial invalidation was rare and is historically disfavored, and that the much more appropriate judicial remedy is a surgical, targeted to the parties, as applied remedy. We see the Supreme Court going that direction in a lot of areas like CASA. They're getting it right. We would be going the wrong direction if we said here, the only game in town for protecting religious exercise is facial invalidation, something that is not consistent with Article III powers, or at least much more disfavored under Article III powers of the types of remedies the judiciary can enforce. And so we can act like exemptions are a get out of the law free card, or we can call it what the Supreme Court calls it, which is its modest bread and butter default approach to constitutional adjudication, just an as-applied challenge, the type of remedies that were most common at the founding. And this is something that Mark and I have written about together. And do we see Madison or Washington saying, we just need to make sure that religion is treated equally, that's all we got to do? No. Madison says that when it comes to religious exercise and memorial and remonstrance, this duty is precedent, both in order of time and degree of obligation to the claims of civil society. Washington, in his letter to the Society of the Quakers, says, he doesn't say, I assure you, your rights will be treated equally under the law. He says, I assure you very explicitly that in my opinion, the conscientious scruples of all men should be treated with the greatest delicacy and tenderness, and it is my wish and desire that the laws always be as extensively accommodated to them as due regard and protection and essential interests of the nation may justify and permit. We ought to be as accommodating as possible, and an approach like strict scrutiny does that.
All right, we have time for a couple questions. Yes. Here we'll have a defense of Scalia. Scalia defending Scalia.
Yeah, I'm Gene Scalia. My brother Chris and I agreed that at least one of us would be at every panel in case anything was said that was not entirely respectful. And I knew that this panel was going to require special attention. The good news is I'm not going to prolong things all that much because I'm not even going to pretend to ask a question. But I did want to make a few points. And obviously I welcome your all's reactions. One is that the free exercise and establishment clauses present an area where two of my father's principal tools of construction were going to be harder to apply given where the court was. So to start with textualism, I'm not sure anybody actually quoted the religion clauses on this panel, but I came in late. Congress,
the moderator did.
Gene. God bless that man. This former Scalia clerk did.
Correct.
Congress shall make no law, right? Congress shall make no law. As I think a number of you touched on, there's a particularly strong case against incorporation when it comes to the religion clauses, in part for this reason, and also in part because, as I understand, part of what the founders may have been doing was actually protecting states' ability to establish religions. And so incorporation of the religion clauses made textualism hard, and it made originalism hard. Okay, so that's point one. Point two is that my father often would say he was only a faint-hearted originalist. And so, and again, especially when you look at the religion clauses and where we are today, it's especially difficult to imagine rolling back and saying, oh, you know what? Forget all this stuff. This is just about Congress's powers, because that's really the proper way to understand the First Amendment. And by the way, if you go back to the time of the founding, it's actually a little hard to imagine many circumstances in which Congress would have legitimately been in the business of doing a lot of the stuff that creates First Amendment free exercise cases today. The last point, and Professor Munoz touched on this, really important, is that a third aspect of my father's jurisprudence that's in play here is his belief in the so-called rule of laws. That was a law review article. Jeffrey Rosen tells this story in the book he's just published, that the Harvard Law Review refused to publish, even though my father had given that as the Holmes lecture at Harvard, and they had a practice of publishing the Holmes lecture. I was the editor at the Chicago Law Review. He came to me, and he wanted to publish it. He said, I want to publish it in the Federal Society Journal. And I said, well, publish it in my journal, man. And so, we published it. Ed, correct me if this is wrong. I think that is the first piece my father published in a law review as a justice. Certainly one of the first, because he published it in 1990. So he didn't publish a piece that was about textualism, that was about originalism. I'm sure he touched on those issues probably a fair amount, but it was about the rule of law. And certainly one of the things driving Smith was his dislike of balancing tests and that kind of thing. And that's part of the reason, too, that you got the decision you did. Last, I do think that he looked at the text of the Free Exercise Clause and arriving at the outcome he did in Smith. And you can see how, when you've got language talking about make no law prohibiting the free exercise of religion, how that's not on its face a right of accommodation. Sorry to take so much time, but I wanted to share this.
And they're fortunate that only 2 of the 9 Scalia children are here today.
Can I offer a note of agreement with Gene? I think the framing of the First Amendment as Congress shall make no law is really important, but I think one of the things it tells us is that that's an explanation for why we just don't have a lot of founding era case law under any of this, under speech, under religion, under press, under establishment, right? Because the early Congress wasn't doing much on any of these things to bump into people's rights, right? It really is after incorporation, when these things become rights against state and local governments, that any of this stuff has to get sussed out. And so then that does make the originalist job much harder, because it's just harder to go back and figure out. Like, think about what the United States government was like at the founding, and think of how unlikely and uncommon it was for that to bump into religion. It's hard to have a lot to go on for that. And I do think that is an interpretive problem for originalism with the First Amendment, with the first 8 amendments.
So on the Congress shall make no law bit, it's sort of interesting how that ended up in the Constitution. Madison, of course, had originally planned to have the section of rights that would apply against the federal government, and then the section that would apply against state governments, including things like religious exercise. He didn't win the day on being able to enforce some of those rights against states. So they added language like Congress shall make no law. One argument is just to make clear this is just a limit on the federal government. Does that mean, as Phil has argued, that this means Congress shall make no law, so we just can't have laws that are facially targeting religion? I mean, that's a textualist way you could interpret it. Keep in mind, we'd have to do that for speech, too. Like, that would be a radical change in our speech jurisprudence, because it's also Congress shall make no law with respect to the abridging of speech. And we don't do that. And there's arguments by scholars like Judd Campbell, who have said we should be careful about treating the language in the Bill of Rights as though those rights are creations of the text, when in fact, things like religious exercise are a long-standing, historically understood natural right that a lot of the framers understood applied not just to the federal government, but to state governments as well. And so the text is sort of operating as a placeholder of this right, the one we know exists. Keep in mind also the article that it exists in the First Amendment. It's referring to a pre-existing right. And that right, I would say, in response to some of Phil's historical research, included in it, the natural understanding of the natural law right was that it was bounded. It could be limited for regulations or laws aimed at the common good. Ed Meese, who did a lot of that work about prohibit, the textual understanding of prohibit, that I imagine was relevant for Justice Scalia, later said that there's other historical evidence that suggested that the word prohibit was probably more analogous to something like hinder, and that he hadn't done enough work on what that text meant. So I don't think it's crazy, the conclusion that Justice Scalia arrived at without the benefit of Michael McConnell's work or other work, but we have the benefit of it now.
Other questions? Yes, over here.
Hi, thank you so much for this wonderful panel. I'm an undergrad at Georgetown, really appreciate the opportunity. My question is about a lot of legislative enactments. Like there was a lot of discussion of RFRA, but in the founding era, many states also had things like blasphemy laws, laws that prohibited utterances against religion, in addition to their established churches, which were gradually disestablished. Do you think that those blasphemy laws and other enactments that we never really considered today as constitutionally permissible at all should inform how we interpret the religion clauses? And if not, how can that be squared with this return to originalism in the clauses?
Can I take the blasphemy laws? There's thank you for the question, which is a very nice one. So I'm not saying that you do this, but some people have been saying, look, there's these blasphemy laws in the states at the time of the founding, and the state can make blasphemy illegal. That suggests that the founders understood that the state had all sorts of jurisdiction over religion, and usually it's in the context, and look, see, the state can advance religion, and it should advance religion. It's too clever by half. Because, and there's if any law review, if any law students are watching this, there's a great law review article waiting to be written. If you actually go in and look at these blasphemy laws, you should look at why they were adopted and how they're defended. And they're adopted as keep the peace laws, that this will lead to a breach of the peace. That is, the blasphemy laws are adopted not saying that the state can say what is blasphemous, what goes against, what is profane, what is not sacred, but they're like a time, place, and manner restriction. Many members of the community would take this language as offensive, and it would cause a disturbance. That is, there is a civil reason for these laws. It does not, in fact, the fact that blasphemy laws are defended in civic terms, not religious terms, is actually revealing about how they thought the blasphemy laws could not be defended. They thought, we cannot say, the state cannot say, this is against God. So they actually reveal the exact opposite than what those people who are promoting these blasphemy laws for stronger governmental authority over religion. The truth of the matter, if you understand the history, is it makes the opposite point.
And just to go back to Gene Scalia's point, the First Amendment wouldn't have covered those early state laws at the time, right? So like the First Amendment before incorporation would have had nothing to say about those laws, right? If there were federal blasphemy laws, which to my knowledge there were not, but if there were, then I think that would be a complicated argument for originalism.
And one other thing I'll add is that when Madison introduced the Bill of Rights, in his speech introducing the Bill of Rights, because a number of states had their own sort of free exercise clauses, he said many of these states have not been living up to their constitutional ideals. And so those might be examples where the states were falling short of their own constitutional protections and that natural law, right? Depending on how blasphemy law was being understood or enforced in that particular state. This is an area where, unlike the Second Amendment, where there's like the longer history in English common law, America, the colonies, are doing something new. We're breaking from how religious exercise has been treated historically. We're trying to shift gears in a way that is difficult. It's an uphill battle. There's a lot of friction, but it is important and meaningful in the right direction to shift to. We shouldn't be surprised that there were some missteps along the way as we tried to turn the ship around and really protect religious exercise in a meaningful way that no other country had done before.
All right, with that, I think we will thank our remarkable group of scholars on our panel.
That was fun.
They were not picking up the call, so we made alternative arrangements. So please, it's awaiting us out in the hallway. And then we'll come back to hear remarks from Professor Robert George.
Main event. Am I hearing? It's not hearing? Okay. I hate to interrupt all the great conversations here, but we're about to move on to our main event. So if you could all please quiet yourselves, I would appreciate it. Yes, thank you, Tom. Thank you all. It's my great privilege to introduce our lunchtime speaker, Princeton professor Robert P. George. Among his countless achievements, Professor George is the McCormick Professor of Jurisprudence at Princeton and director of Princeton's James Madison Program in American Ideals and Institutions, a program that has a tremendous impact. He is also a non-resident senior fellow here at AEI and a longtime member of the board of directors of my institution, the Ethics and Public Policy Center. Justice Scalia was very fond of Professor George and greatly admired his scholarship. As we shall see, Professor George very much reciprocated the fondness and admiration. Robbie.
Well, let me begin by thanking my very dear friend, very dear old friend, Ed Whalen, for inviting me to participate in this event at which we honor the memory and the achievements of our great hero, Antonin Scalia. I dare say that all of us here are, in a certain sense, students of Justice Scalia. We learn from his precepts, his teachings, and perhaps even more from the example that he set for us. Justice Scalia had a reputation for brilliance, tenacity, and pugnacity. His reputation for these qualities was well earned. Those of us who were blessed to know him personally, and I know many of you clerked for him, some of you were related to him, but anyone who knew him personally knows that these qualities, brilliance, tenacity, pugnacity, were only part of the picture. Now, pugnacity and compassion are not often found together, but they were in Nino Scalia. He famously said, "I do not attack people, I attack ideas." And if you go back over the record, you'll find that what he said was absolutely true. He treated people, even when he disagreed with them, even when he challenged their positions and arguments, with respect. He paid those with whom he disagreed, whether colleagues on the court or people in public disputations, the courtesy of stating plainly and forcefully why he disagreed with them. He didn't just call them names, he didn't just dismiss them, he didn't just wave his hand. He paid people the respect when he disagreed of challenging them, giving them reasons, making arguments. And of course, he had an extraordinary gift for friendship. His long and deep friendship with his colleague, Justice Ruth Bader Ginsburg, is well known and much celebrated. It's the stuff of legends and movies. His profound disagreements with her on just about everything did not in the least impede his respect for her or his affection for her, or it must be said, hers for him. Many, many people in the room today could tell personal stories of Justice Scalia's friendship and kindness. I have many of my own. For example, when I was installed as McCormick Professor of Jurisprudence at Princeton, Nino was even happier about the honor that had come my way than I was. And let me tell you, I was pretty happy. But I was happier still that it made him so happy. Shortly after that, I founded the James Madison Program in American Ideals and Institutions at Princeton, and he immediately asked what could he do to help in advancing the new program's mission. He made the trip up to Princeton on several occasions to lecture and to meet with our undergraduate students. What's more, he invited James Madison Program undergraduate fellows to come to Washington to attend oral arguments at the Supreme Court as his personal guests, and to meet with him privately afterward to discuss the court and its work. A number of Nino's fellow justices soon got into the act, and visits to the court for oral arguments and meetings with justices are now a Madison program tradition, one carried on by Justices Alito, Thomas, Kagan, Gorsuch, Barrett, and Chief Justice Roberts. Now, what about Nino's compassion? I mentioned that a moment ago. What did I have in mind? Well, the heart of the man, the heart, was captured perfectly in a story told by Jeffrey Tucker after Nino died. Here is Jeffrey Tucker's telling, and I quote, "It was a spring afternoon some years ago, and Justice Scalia was attending church services sitting in a back pew, holding a prayer book in his hand. The Mass had ended, and most people had gone. He was still saying his prayers alone in that back pew. He finally got up and began to walk out. There were no reporters, nobody watching. There was only a woman who had been attending the same service. She had no idea who he was. I was a bystander, and I'm certain he didn't know that I was there. There was something a bit unusual about the woman. She had lashing sores on her face and hands. They were open sores. There was a disease, and not just physically. She behaved strangely, a troubled person that you might meet in large cities and quickly walk away from. A person to avoid and certainly never to touch. For whatever reason, she walked right up to Justice Scalia, who was alone. He took her hands, though they were full of sores. She leaned in to say something, and she began to weep. He held her face next to his, and she talked beneath her tears that were now streaming down her face and onto his suit. He didn't flinch. He didn't try to get away. He just held her while she spoke. This lasted for perhaps 5 minutes. He closed his eyes while she spoke, gripping her back with his hand. He didn't recoil. He stood there with conviction and love. There were no cameras and no other onlookers besides myself, and he had no idea I was there. Finally, she was finished. What he said comforted her, and she regained her composure. She pulled away, ready to go. He held her rough, sore-filled hands and had a few final words that I could not hear. He gave her some money, and then she walked away. And then he walked away across the green grass toward the Supreme Court building alone. He was probably preparing for an afternoon of work. I stood there in awe. Here we have one of Washington's most powerful men, a star by any standards. Cameras followed him all over. That kind of attention can get to you. In time, you might begin to believe that your life is a performance. Not in Justice Scalia's case. What I saw that day was a humble man, a compassionate man, a man who believed in the power of personal contact. This was the action of a man of true principle and character. In that action, he sought no credit for himself. He sought no attention. He was merely doing a humane and beautiful thing. Unquote. I was not there, I didn't witness it, but that is the Nino Scalia I knew. And for those of you who knew him, I'm sure that was the Nino Scalia you knew. Oh yes, he was pugnacious. Oh yes, he was tenacious. And he was certainly brilliant by any standard. But there was that deep compassion. Let me now share a few reflections on Justice Scalia's legal and judicial philosophy. In so doing, I hope to paint a picture of how he viewed his obligations as a judge under our constitutional system, his interpretations of concepts like the differing judicial and legislative roles, and his view on the question of natural law's role in constitutional interpretation under the American constitutional system. Justice Scalia preached the principle that the Constitution should be interpreted in a way that honors the text understood as it was by those whose ratification made it part of the fundamental law of the land, turned something from being into just somebody's idea into being positive law. That principle, far from widely accepted common sense, had been ignored or abandoned by jurists, scholars, and activists who sought to expand the authority of judges to invalidate as unconstitutional legislation or executive actions that they happen to regard as unwise, unjust, outdated, or for some other reason, undesirable. In our own time, this impulse has been mainly evident among political progressives. It is what gave us putative constitutional rights to abortion and to same-sex sexual activity in marriage, among other innovations. At earlier points in our national history, this same impulse drove the jurisprudence of laissez-faire economic conservatives, generating decisions such as Lochner against New York, a 1905 ruling that struck down a worker protection statute, limiting the number of hours employees could be required or permitted to work in industrial bakeries. For Scalia, judges who yield to the impulse to read into the Constitution rights or other principles not to be found in the text of the document or the logical presuppositions or implications of the text or the original understanding of its provisions, betray the rule of law and make a mockery of their oath of fidelity to the Constitution. To, quote, Lochnerize, unquote, as it has come to be known, whether in the cause of laissez-faire economics or liberal social ethics, is to deprive the American people of the right to govern themselves. For judges, Scalia held, on the pretext of enforcing constitutional guarantees, to substitute their own judgments of politics or morality for the contrary judgments of the elected representatives of the people is an assault upon the very Constitution in whose name they purport to be acting. Since various theories of constitutional interpretation, the living constitutionalism popular among progressives in the second half of the 20th century, or Ronald Dworkin's moral reading of the Constitution, have been advanced by jurists and legal scholars in efforts to justify the judicial usurpation of democratic legislative authority, it became necessary for Scalia and other defenders of the idea that the Constitution means what it says, that is, what the people who framed and ratified its provisions meant by the words they used, to give a name to their theory of constitutional interpretation. The name these defenders of constitutional integrity and the rule of law chose was originalism, marking the conviction that the original meaning or public understanding of constitutional provisions and principles should guide and govern judges in determining whether a law or policy ought to be upheld as constitutionally valid or declared to be unconstitutional. Now, as you know, I'm sure, even from panels that you've heard just in the last day and a half, there are many different schools of originalism, many different approaches to originalism. And nothing in originalism just as such precludes, far from it, the idea that judges are bound by the logical implications, what I called the logical presuppositions or logical entailments of the provisions of the Constitution that they are charged to interpret. Well, not only was Justice Scalia an originalist, indeed the leading originalist of his time, he was also a defender of the equal authority and responsibility of the three branches of government in matters of constitutional interpretation, a view that when fleshed out is generally known as departmentalism. In other words, Scalia sided with Abraham Lincoln and against Lincoln's nemesis, Supreme Court Chief Justice Roger Brooke Taney, on the question of whether the legislative and executive branches must always conform their conduct to the Supreme Court's interpretation of the Constitution. Taney, of course, said yes, and Lincoln said no, not always. The question arose whether Lincoln, as president, would consider himself bound by Taney's pro-slavery ruling in Dred Scott against Sanford, a ruling that struck down congressional restrictions on slavery in the federal territories, the U.S. territories, and held that blacks, even free blacks in free states, could not be citizens. In one of his last public appearances, in fact, it might have been his last public appearance, I'm not absolutely sure, but very, very near the end of his life, I had the honor of interviewing Justice Scalia before a large audience at the Union League in Philadelphia. The two of us sat on a stage under an enormous portrait of Abraham Lincoln. What happened in our conversation is indelibly burned into my memory. I asked him whether he agreed or disagreed with Lincoln's statement, and I pointed to the portrait, with Lincoln's statement rejecting judicial supremacy in his first inaugural address. You all recall, I'm sure, that the great emancipator, in discussing the Supreme Court's decision in Dred Scott, holding that Congress again lacks the power to restrict slavery in the territories and that Black Americans, even free blacks in free states, can't be citizens, said the following, and again I quote, "I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court. Nor do I deny that such decisions must be binding in any case upon the parties to the suit as to the object of that suit, while they are also entitled to very high respect and consideration in all parallel cases by all other departments of the government. And while it is obviously possible that such decisions may be erroneous in any given case, still the evil effect following it, being limited to the particular case, with the chance that it may be overruled and never become a precedent for other cases, can better be borne than could the evils of a different practice. At the same time," and here's Lincoln's punchline, "the candid citizen must confess that if the policies of the government on vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court the instant they are made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal," unquote. Shocking the audience, which contained many, many Philadelphia lawyers, Justice Scalia declared, "Of course I agree." Not just, "I agree," mind you, "Of course I agree." Now, there was a reason that the audience was shocked. It's virtually taken for granted, not only among lawyers and jurists, but also among the population more broadly, that Supreme Court rulings on constitutional questions bind the other branches of government not only with respect to their orders in the particular case, but also as to the general principle, the ratio decidendi, of the court's decision. When Nino was in law school, and certainly when I was in law school, that sort of judicial supremacy was simply assumed to be true. It wasn't argued for or treated as a live or legitimate question. If Lincoln's first inaugural was mentioned at all, even in the discussion of, say, Dred Scott, it was passed over quickly with no particular attention to his denial, his very explicit denial of the supremacy of the Supreme Court. But Nino not only questioned judicial supremacy, he explicitly, in front of that audience, very publicly, rejected it. He did not conflate the rule of law with the rule of lawyers, even those lawyers who have been elevated to the bench. Scalia rejected judicial supremacism for the best possible reasons, Lincoln's reasons, because it is in the end incompatible with the Republican principles of the Constitution itself. So for Scalia, as for Lincoln, a decision of the Supreme Court was the law of the case, binding on the parties involved, but not necessarily the law of the land, binding on the other branches of government as a general rule beyond the requirement that the executive enforce the order in a particular case. Now, Scalia, again like Lincoln, argued that it is generally advisable for the President and the Congress to accept a ruling of the Supreme Court in constitutional interpretation, even if they regard the ruling's contents as erroneous. A mistake was made. The decision came out the wrong way. But there are, according to Scalia, following Lincoln, limits. Indeed, as Justice Scalia observed in our conversation there at the Union League, it's certainly not the proper course of action where a Supreme Court ruling grossly usurps legislative authority. In other words, when the court effects a judicial power grab, thus violating the Constitution and undermining the very thing Lincoln fought the Civil War, accepting its horrific carnage to preserve, namely Republican government. It was at Gettysburg, right, that Lincoln explained why he was accepting war, why he didn't just let the South go. It's summed up in that prayer with which he ends the address, that this nation under God will have a new birth of freedom, and that government of the people, by the people, and for the people, shall not perish from the earth. Well, of course, all government is government of the people. All good government, even the government of a benign despot, is government for the people. A good monarch, even an all-powerful good monarch, rules in the interests of the community as a whole, of the people as a whole, not in his own personal interest or in the interest of his family or in the interest of his group or tribe or clan. What's distinctive about Republican government, what Republican government is government by the people. So that's why he fought the war. He feared that if the Union failed, there would be a collapse from republicanism into some form of autarky, and that the lesson would be taken henceforth and forevermore that people are simply incapable of governing themselves. Human beings just aren't capable of self-government. The American Republic failed for basically the same reasons that all previous republics had failed. And when those previous republics had failed, so often they had collapsed into the worst forms of tyranny. But it was this same consideration, this same concern, the preservation of Republican government, that caused Lincoln to take the position that he took in the first inaugural with respect to Dred Scott and the question of judicial supremacy. And Scalia was right there on board with him. When I asked him for examples, Justice Scalia cited Dred Scott itself, he cited Lochner, and he cited Roe versus Wade. Cases he held in which a majority of Supreme Court justices legislated from the bench, as we've come to say, invented rights found nowhere in the Constitution in an effort to impose on the nation the justices' preferred policy positions on highly controversial, morally charged issues. I believe that Justice Scalia's fierce resistance to any usurpation of legislative authority by courts was rooted in his acknowledgement, which I think is fundamentally correct, that positive law, human law, is a cultural object, a cultural artifact, albeit a cultural object or artifact created for moral purposes. This is a fact that generates a great deal of the confusion one encounters today in debates about the role of natural law and moral philosophy more generally in legal reasoning. Indeed, the seemingly perpetually vexed questions of American constitutional interpretation necessarily implicate the scope and limits of the power of judges to invalidate legislation under certain allegedly vague or abstract constitutional provisions. What my late teacher Ronald Dworkin referred to, picking up a cue from the jurist William J. Brennan, as the majestic generalities of the Constitution. Well, some constitutional theorists, Dworkin himself, for example, in his so-called moral reading of the Constitution, wish to defend an extraordinarily expansive role for the judge. They argue that the conscientious, morally responsible judge must bring judgments of moral and political philosophy to bear in a kind of wholesale way, not in a restricted way, but in a general way, in deciding hard cases. Or if there are restrictions, the restrictions don't have much bite to them. Others, such as the late Judge Robert Bork, a longtime friend and ally, of course, of Nino's, immensely feared such a role for the judge. Jurists and scholars of the Scalia and Bork stripe hold that the US Constitution does not give the judge such a role. They maintain that moral philosophy has little or no place in judging, at least in the American system. Now, it seems to me in both those cases, they might have gone a little bit too far for fear of yielding too much to the Warren Court or to the Dworkins or to the Larry Tribes, who would give a very expansive, almost sweeping role for judges to exercise their own independent moral judgment to invalidate legislation. Now, some people who are loyal to the tradition of natural law theorizing are tempted to suppose that the Dworkin position, with its sweeping authority to courts, despite their disagreements with Dworkin's substantive progressive commitments, is the framework that is most faithful to the natural law tradition, most in line with that tradition that begins with figures like Plato and Aristotle and Cicero and works its way up through medieval thinkers like Aquinas and all the way up to contemporary natural law theorists. But Scalia argued that this temptation should be resisted. While the role of the judge as law creator versus law interpreter reasonably varies from jurisdiction to jurisdiction in accordance with the authoritative determinations of each, that is to say, each jurisdiction's decisions about how it distributes powers and duties within its government, how it allocates them, for example, among an executive, a legislative, and a judicial branch. The ideas put forth by originalists of the Scalia stripe of a body of law that is properly and fully, or almost fully, analyzable in technical terms is fully compatible with classical understandings of natural law theory, at least where it is allowed that the constitutional meaning is to be discerned from the text, yes, from the structure, yes, from the original understanding, yes, but also from what is logically presupposed and what is logically entailed by the commitments made in the provisions of the text. And this, I think, is because natural law theory treats the role of the judge as itself fundamentally a matter of what Aquinas called determinatio. That is, not something to be deduced as in a syllogism or a derivation or a logical derivation, not something where you had a choice between what's morally wrong and morally right, but rather something that has to be chosen authoritatively by whoever in the system has the authority to make the choice, say the constitution makers or ratifiers, where you have to make a choice among reasonable, morally acceptable alternative ways of doing things, including allocating power, but where you can appeal to no moral principle to dictate the choice. So you have reasonable variation between nations, between traditions, between legislatures, constitutional conventions, and so forth. You could reasonably choose a parliamentary system. You could reasonably choose a separation of powers system with an independent president, a president who's independent of the legislative. Neither of those is ruled out from the perspective of general morality or abstract morality, but they are incompatible with each other. You've got to choose one or the other, or some third perhaps, but you've got to make a choice, and the choice is underdetermined, strictly speaking, by reason, and therefore we can judge to be underdetermined as a matter of natural law. It's got to be determined by whoever or whatever body has authority in the system to make those choices, to make those determinations, what Aquinas calls determinationes. So Aquinas argues that all good positive law is in some way derived from natural law, but the derivation is in two distinct ways. In one case, you have a direct derivation of a principle of positive law from a principle of natural law. So that the law should prohibit rape or murder is a direct translation from the natural law principles prohibiting those activities. But whether we should have a parliamentary system or a presidential system, how much power should be allocated to an executive as opposed to a legislative, how much legislative or quasi-legislative authority should courts enjoy, there is no natural law principle available for a direct derivation to a conclusion. So a choice has to be made among those options. That kind of choosing is what Aquinas calls determinatio. It might be that in system A, judges have virtually no legislative authority. But in system B, they've got a pretty substantial share of the legislative authority. It's not vested entirely in the legislative, as it's supposed to be under our Constitution, where Article 1 says all legislative powers herein granted shall be vested in a Congress of the United States. So, natural law theory treats the role of the judge, as I say, as itself fundamentally a matter of determinatio, not for direct translation from the natural law. It doesn't imagine that the judge enjoys or should enjoy, as a matter of natural law, a plenary authority, a general authority to substitute the judge's own understanding of the requirements of natural law for the contrary understanding of the legislator or constitution maker in deciding cases. So you see, on the natural law understanding, whoever makes the law, whoever has the authority, is given the authority to make the law, should make the law, the human positive law, the law of his community, in line with the natural law, with the principles of natural justice. But there's nothing in the natural law that confers on any particular actor or office in the system the authority to do that. The authority can be distributed differently, entirely reasonably, consistently with the natural law. That's what determinatio is. Not a direct translation. Murder is fundamentally unjust, therefore the law should prohibit murder. Rape is fundamentally unjust, therefore the law should prohibit rape. We need a fair system of political decision-making, but the natural law doesn't say it has to be a parliamentary system, or it has to be a presidential system, or judges should have no legislative authority, or judges should have a substantial share of legislative authority. On the contrary, for the sake of the rule of law, understood as ordinarily a necessary but not sufficient condition for a just system of government, the judge, like any other actor in the system, is morally required, that is to say, obliged or obligated as a matter of natural law to respect the limits of his or her own authority as those limits have been specified, either implicitly or explicitly, by the Constitution, whether written or unwritten. If the law of the system constrains the judge's law-creating power in the way that Justice Scalia believed the American constitutional system fundamentally does, then for the sake of the rule of law, considered as itself a fundamental principle of natural justice, Justice Scalia felt that he had to respect those constraints even where his own personal understanding of natural justice and natural law deviated from that of the legislators or constitution makers and ratifiers whose promulgated laws he, as a judge, was bound to interpret and faithfully apply. Famously, Justice Scalia was once confronted, I think it was at either our own Dominican House of Studies or one of the Dominican houses, confronted by a questioner who began his question by saying, "Now, Justice, I know you hate the natural law." And Justice Scalia, immediately before the guy could even continue with the question, exploded and said, "I love the natural law. I don't hate the natural law. I've got a view of what the natural law requires, and I've got a view of what the natural law requires of judges. And what the natural law requires of judges is that judges respect the constitutionally established limits of their authority." So here's what he said when he was less worked up. "Now, in my view," quoting Scalia now, "natural law does make its demand upon judges, but not the demand that they render judgments that contradict positive law. Where positive law places judges in the position of being the instrument of evil, the judge must recuse from the case, or, if there are many such cases, resign from the bench. Thus, he goes on, if I were a judge in Nazi Germany, charged with sending Jews and Poles to their death, I would be obliged to resign my office and perhaps lead a revolution. Unquote. Still, Justice Scalia's view leaves us with the question of whether the natural law itself, quite independently of what the Constitution may say, confers upon the judge, and this is really what the debate is all about, a sort of plenary authority, plenary power, general power to enforce it. And the answer to that question for Scalia is no. To the extent that judges are not given power under the Constitution to translate natural law principles into positive law, that power is neither one they enjoy nor one that they may themselves justly exercise. Indeed, for judges to arrogate such power to themselves in defiance of the Constitution, and this was the underlying reason for Nino's position, is not merely for them to exceed their authority under positive law, it is to violate the very natural law in whose name they purport to act. And the reason for that is the rule of law itself is a natural law principle. Respect for the rule of law is required as a matter of natural law. Even if one's goal is to do justice, if one tries to do justice in violation of the rule of law, one commits an injustice. One sins against natural justice, against natural law. Well, in my own judgment, Justice Scalia was correct in his call for judicial restraint in the absence of a genuine constitutional warrant for overturning duly enacted legislation. While I myself generally tended to agree with Justice Scalia in cases, there were certainly cases in which he and I came out differently, but of course he had a certain power that I don't have. His opinions on these matters really did matter. Mine were a professor's ideas. He had graduated from being professor, but he had graduated into a higher rank where his ideas really mattered. On occasions when I found myself disagreeing, sometimes it was just a disagreement about what the original understanding of the Constitution was, what the best account is of the publicly understood meaning of provisions or the words of provisions of the Constitution. Sometimes they were differences of opinion about what was logically presupposed or logically entailed by constitutional provisions. Where we agreed was in the basic idea that the proper interpretation of the Constitution was one in which we looked for meaning by looking at the text, the logical implications of the text or the logic of the text, the logic of the law, the structure of the text, and its original publicly understood meaning. And this is because the Constitution places primary authority for giving effect to natural law and to protecting natural rights in the institutions of democratic self-government, namely the legislative bodies, whether at the national level in our Congress or in the state legislatures. So this is not, strictly speaking, and shouldn't, I think, be presented as a debate between natural law theorists and legal positivists. This is a debate within the community of people who believe that there is a natural law, that there are natural rights, and that all of us as actors in the political system, from citizens just exercising their responsibilities of citizens, to presidents, and certainly to judges, all of us are required to live within the requirements of natural law and natural rights. The Constitution, Justice Scalia argued, does not give the courts authority to intervene in circumstances in which nothing in the text, its structure, logic, or original understanding dictates an answer to a dispute as to public policy. This is the problem that he had with Lochner. This is the problem that he had with Roe versus Wade. It's the problem that he had with Dred Scott. Now, I think we all know from our own experience that many a jurist, despite claiming to hold to this understanding, the Scalia understanding, when nominated to the bench and going through confirmation, yielded some sooner, some later to the temptation to legislate from the bench, to usurp the authority vested not in judges under our Constitution, but in the people acting through their elected representatives. But Justice Scalia did not yield. He was an imperfect human being just like the rest of us. He couldn't get everything right. He didn't get everything right, but he did not yield on the question of whether he was entitled as a judge to substitute his own opinions for those of the elected representatives of the people, absent a warrant in the text or logic or structure or original understanding of the Constitution. His strict and unyielding commitment to constitutional principle made him the virtual embodiment of constitutional fidelity and a fidelity to the rule of law. And that's, I think, why true constitutionalists, whether they agree with him or not on the outcomes of this or that case, true constitutionalists, people who believe in the Constitution and want to live by it, people who are committed to being faithful to the Constitution, continue to draw inspiration from Antonin Scalia. And so we must never fail to honor his memory as we do today. Thank you.
Thanks very much, Robbie, for that wonderful reflection. We will resume in 10 minutes with our next panel on administrative law. Thank you.
I guess if folks will settle in, we'll get started in just a couple of moments. Well, welcome to our next conversation. This panel is on administrative law. We thought we would focus on administrative law to see who the real hardcore people are who will come back for this. It is anytime you're speaking about Scalia and administrative law, it's impossible not to begin with his beginning to his speech on Chevron deference, a talk he gave in the late 1980s. It was published in the Duke Law Journal. He warned people at the outset. And I think I've heard Bill Galston quote these lines before too, actually, funny enough. Administrative law is not for sissies, so you should lean back, clutch the sides of your chairs, and steel yourselves for a pretty dull lecture. Now, maybe one of the greatest testaments to Scalia's greatness was the fact that he made administrative law so interesting. His approach to administrative law was part and parcel with his view of the separation of powers and the proper role of government and the proper role of a judge within that government. Now, he worked through these things not just in theory, but also in practice. So much of his career before he joined the Supreme Court was focused on administrative law. He chaired the Administrative Conference of the United States from 1972 to 74, and then later chaired the ABA's Administrative Law section. Here at AEI, after the Ford administration, he edited and wrote for Regulation magazine. Even more exciting than it sounds, actually. You can get it right next to Hollywood Reporter. But when you go back and read his essays in Regulation in the aftermath of the Ford administration and through the early years of the Reagan administration, some of the most entertaining and interesting things he ever wrote in Regulation magazine. He was general counsel for the White House Office of Technology Policy in the early 1970s, and then later, of course, he was the Justice Department's Office of Legal Counsel. And then he was appointed to the U.S. Court of Appeals for the D.C. Circuit, where he, for 4 years, could feast upon cases involving the Federal Energy Regulatory Commission and other agencies. But of course, it was in his time on the Supreme Court where he really made his mark and sort of laid the groundwork for decades of discussion around administration, administrative law, and the separation of powers. And so, of course, we have to have a discussion of that today. I'm glad to have that discussion with the two folks that are sitting with me here on stage. Aditya Bomzai, seated next to me, is a professor of law at the University of Virginia, where he teaches and writes on administrative law. And in fact, for the last decade, he's written some of the most important law review articles of our time on questions of administrative law, raising new questions and returning to timeless ones. His first major law review article raised significant questions about Chevron deference, really raising questions that the court would grapple with in Loper-Bright. More recently, Professor Bomzai has focused on the history of our administrative institutions, including the Federal Reserve and our financial regulators. He previously served in the Justice Department, both of the Office of Legal Counsel and the National Security Division. He clerked for Judge Jeffrey Sutton, and he clerked for Justice Scalia in 2007 to 2008. Seated next to him is Ronald Cass. Ron Cass is one of the most significant scholars of administrative law, period. His books, book chapters, and law review articles and essays are innumerable, and he's co-author of one of the most significant case books on administrative law. You know, I wrote that down in the bio, and then I remember that Aditya has also written a case book, which is great.
I'm happy to say.
Ron was the dean of the Boston University School of Law, and he served as vice chairman for the U.S. International Trade Commission. He and Justice Scalia were dear friends for many decades. In fact, Ron, as we were getting ready for this event, I was looking around, and I found an interview you gave a day or two after Justice Scalia died. And here's how you were quoted. I'll give you equal time to respond, by the way. Ron said, Nino was somebody who lived life at the gallop and it ended suddenly, in a way that's fitting, in a way that's what he would have wanted. There wasn't any long slowing down process or any slowing down at all. Harder for those who were left behind. So Ron, of course, was a very, very dear friend of Scalia, and I'm very lucky to be joined by both these folks on stage. Let me start with a very broad, big picture question. What attracted Justice Scalia to administrative law? Of all the things he could have focused on, especially in the aftermath of the Warren Court and during the Burger Court, he settled upon administrative law. Is there a central theme or principle to his approach to it? Aditya, maybe I'll start with you.
Thanks. Well, thanks, Adam. And before I answer, I just want to say thank you to you for the kind introduction, and also thanks so much to AEI and you for putting together this event to recognize and think about the legacy of one of, I believe, our truly great justices on the Supreme Court. So maybe we'll hear from Ron in a few moments what the real answer is, because I do not know what it was that prompted the justice to get into administrative law. And he cared deeply and passionately about this area. He was really into it. And so in preparing for this panel, I tried to learn some new things along the way. And one of the ways in which I tried to approach this was by asking our archivist at the University of Virginia to tell me how many times and what kind of course he taught as an administrative law professor before he went on to the Washington, D.C. jobs that you just listed. And from 1967 to 1971, which was his academic career before he starts in D.C., how many times do you think he taught administrative law? It's actually never. He actually did not teach administrative law before he came to be, in those positions that Adam listed. He taught conflict of laws, he taught contracts, he taught commercial transactions, and he taught German law. And I was looking for like a 5-syllable compound word from German law that would tell me where he got his administrative law perspective. And I don't have that to offer. I wish that I did. And so I'm just going to speculate a little bit here, which is that some of these classes, like contracts or commercial law, they are what might be described in the law school curriculum circa 1970 as real law classes. They're just not amenable to like multi-factor balancing tests. They're amenable to, we need to have some set rules of interpretation so that people can order their lives around these transactions that they've made. And who knows whether, part of what motivates Justice Scalia along the way is we'll apply those principles to the public law side of the line. So that's one thought. The second thought, and this actually cuts a little bit in the other direction, is that at this moment, people may or may not know this, but conflict of laws is a huge area of debate between the legal realists and the formalists. And in fact, if you think of like the 20th century, probably no area of law is most influenced by the legal realist than conflict of laws, where a number of formalist tests during the course of the mid-20th century are replaced by multi-factor approaches. And so that would have been another way in which he might have been introduced to these various ideas of formalism and functionalism. And then it goes on to these various jobs that you mentioned, Adam, a few moments ago, the Office of Legal Counsel. And of course there, when he's the head of the Office of Legal Counsel giving advice to the major parts of the Department of Justice and the White House in the latter parts of the Nixon administration, you can't help but be exposed to all the major topics in administrative law. And I'll just flag two of them. I found some little evidence that before he's ever a judge, he's thinking about these issues. And the first one is actually his first major article on issues, academic issues, while he's at the University of Virginia. Even though he's not teaching in administrative law, he's writing about administrative law. And so his first major article is called Sovereign Immunity and Non-Statutory Review of Federal Administrative Action, Some Conclusions from the Public Lands Cases. You can imagine with a title like that, it's going straight to the top of the New York Times bestseller list. But there is actually a connection, which is that this question about sovereign immunity that's addressed in the article, it ends up being an amendment to the Administrative Procedure Act in 1976, while he is the head of the Office of Legal Counsel, and he plays a role in writing this amendment and getting the amendment through Congress. The Administrative Procedure Act, one of the major administrative law statutes, not amended frequently since its first enactment in 1946. So he plays a role in this development of the Administrative Procedure Act. in this era. And then there's a case that comes up like about a decade later when he's on the Supreme Court. Bowen versus Massachusetts was still the major case addressing this question of sovereign immunity and the Administrative Procedure Act. He's in dissent in that case, and to just like tie it really quickly to current events, this is the case that addresses whether you go to federal court or the Court of Claims in order to bring certain types of claims that could be characterized as money damages or not. So he's there at the beginning writing articles about this issue in 1970. He's there when the amendment is made in 1976. He's there when the cases are decided in the 1980s. And today we still have to deal with some of the same issues. So that's one issue. And I'll close with just the second issue, which is a topic I'm sure we'll return to. And that is by the time we get to the end of the decade, 1979, I think it's fair to say he's actually like a relatively major figure in administrative law and public law generally, after having served as the Assistant Attorney General for the Office of Legal Counsel. And I found in the archives at the University of Virginia, there's a member of the Carter administration who writes him a letter and asks him, hey, we're thinking, or people are thinking about making the Department of Justice independent of the president. And this is public knowledge. I mean, there were, in fact, proposals in the 1970s to make the Department of Justice independent of the president. And he writes a letter back and says, I don't think that would be a good idea. And, it's actually not couched in constitutional language at the time. It's more of a, this would just not actually work in our system of government. The president needs a lawyer. The president needs to trust that lawyer. And obviously, we'll have more to talk about this because it's going to relate to the deep questions of the separation of powers that are at stake in cases like Morrison versus Olson. So, maybe I'll stop right there for present purposes. I think it's the government service, and I think that there might have been some of these other interests he had while teaching. Some of all that put together.
That's great. Thanks, Aditya. Ron?
Well, I will add that the notion of separating the Justice Department from the White House goes back a ways. The Kennedys were big on this. They thought that having the president's brother be the Attorney General would be the best way of keeping the two apart.
Yeah.
Although, as John F. Kennedy said at the time, Bobby really needed a starter job, having graduated law school fairly recently. For Nino, life is always complicated. It's not always a direct line. But administrative law, as exciting a field as it was when I was a law student, there were people who actually stayed awake through the entire class periodically. As exciting as it was known to be, it's about government. It's about the relationship of people to government, of the active parts of government with the courts, about one part of government with another, about the way the whole population interacts with the government, both directly and indirectly. There's so much in this that ought to be exciting. It took years of really hard work by academics to make it an uninteresting field to most students. And that I appreciate the work that my predecessors did on that because it made life easier for those of us who went into the field later. When I was studying at the University of Chicago, I had as my administrative law professor Kenneth Culp Davis. And Ken Davis had a book that was a treatise about the government, about administrative law. In that treatise, you could find every case that ever cited Ken Davis. And then he took the more extensive citations of him, and those cases made it into his casebook. And so it was like a series of mirrors, or a series of Matryoshka dolls. And when we had the first session in law school, the first session was a series of readings devoted to how important Ken Davis was. So you had that. And then at the end of his presentation of how important Ken Davis was, he asked the class, are there any questions? Now, it's hard to think of a question to ask at that point that isn't either really silly or really insulting. there were no questions. So Ken Davis began berating the class on being intellectually lazy not to have questions about after World War II, there were 12 questions from the class about exactly that same material. And after he went on long enough, one of my classmates, God bless him, raised his hand. Ken Davis called on him. He asked a question that showed that he had read ahead and that wove together a number of different parts of the casebook we had yet to reach. Ken Davis listened very carefully and said, "That's a stupid question. I'm not going to answer that question. Are there any other questions?" Needless to say, for the rest of the class, there were no other questions. But it was that sort of devotion to this interaction with students that got AdLaw the reputation it had as an exciting field in so many different schools. But I think from our standpoint, looking at this, after people like Nino Scalia and Steve Breyer and others have been on the court for years and years, attending to different questions, it's a very different field. Yeah. It's a much more exciting field. It's a field that really does let you look at the way different parts of government relate to one another and the way the relation among them also feeds into our ordinary day-to-day lives. And I will say, as a lawyer, I started when I got out of law school. After clerking, I went into law practice, something for which I was manifestly unsuited, and did that for fully 2 years before I took an offer to go into teaching and got a 40% pay cut to go with it. And then I did that until I got an offer to go into government and took another 40% pay cut to do that. And I realized after that, I was out of jobs I could take for which I could get a 40% pay cut. So at that point, I became a law school dean, which was a status cut. Only my parents thought I was actually running the law school. Faculty had other ideas. But it is, in fact, a wonderful field. It's a field that was perfectly suited to Nino. He had clear ideas about how he thought you should approach the law, and that had a lot to do with his view of how the government should be operating with respect to both what it could do and what it couldn't do. And I think we're all very fortunate that he spent time in those vineyards.
I'd throw one more thing in, just looking at his background. And in some ways, it feels like a long time ago, and in some ways, it feels very timely right now. When Justice Scalia was here in Washington in the 1970s, some of the biggest problems around government was just getting things done. Right? You have the cases from the 70s about, are we going to certify this nuclear reactor in Maryland, this nuclear reactor in New York? Big fights here in Washington about whether you're going to manage to build another bridge across the Potomac River. And it was those sorts of practical challenges in day-to-day governance, which we're dealing with today again in an era where it's very hard to build big things, that I've always got the sense that animated a lot of Scalia's interest in the first instance. His early articles, later in the 70s, he's writing about things like the Vermont Yankee case, about judicial micromanagement, DC Circuit micromanagement of the government getting things done. That's just my speculation. But Ron, another big picture question, you sort of teed things up with, why Scalia would be interested in administrative law. What's the through line through it? I mean, administrative law covers so many things. We'll touch on some of them: Chevron deference and non-delegation and process and structure. For Scalia, what was the through line?
Well, really, one of the motivating things for him throughout his career and through every different field is a real devotion to and respect for the rule of law. He was somebody who grew up in a world where there were rules. There was right and wrong. There was a way to behave and not to behave. There was a way to talk and not to talk. And even though he would tolerate somebody having a preposition at the end of a sentence, he wouldn't tolerate people splitting infinitives. And that shows good judgment. The only example of an infinitive that was split that people are willing to accept is obviously Star Trek. To boldly go where no man has gone before. Although people are still sorting out the different meanings that could have, which is why you don't split infinitives. But for Nino, the rule of law was really paramount in what drove him, and it actually does connect all the different parts of his legal career in government, in teaching, on the bench. All of those are ways in which he is trying to promote the rule of law, to have it have meaning, to have it have clarity, not to have it be something that was personal, where you made up what you thought was a good answer. You weren't free to make it up. You had to do what the law sort of channeled you to. And even though he really did more than almost any justice I can think of to change the direction of law, he did it through his devotion to what the rule of law was and how it ought to operate.
Aditya?
You know, I'll just add, like, for my own part, and perhaps this was what attracted, we never spoke about this, the justice to administrative law. It feels to me as though it's one of those areas of law where, as you put it, the practical really meets the abstract. And so there are some parts of public law, constitutional law, where it feels very abstract, no knock on the folks who engage in it, but quite abstract. Whereas there are other parts, and you're really dealing with, and those two are important, facts on the ground. Here, there's an area where the two meet. And so the ability to be clear, analytical, that's something that really can pay off in this area, and that might have been what attracted the justice to it. If I were to say, you know, what did the justice bring to these various areas of law, and we've touched upon this theme throughout the conference, I would say the interest in imposing some order, having rules in various areas, and this is both exciting to some and it's frustrating to others. And I think that is, you know, part of his legacy, the various ways in which he tried to come up with doctrines that could be applied across cases as opposed to turn on the facts of the case.
Interesting. Now, this morning in our panel on religion, the panelists spent a lot of time focusing on employment division versus Smith, an opinion that a lot of conservatives subsequently came to see as wrong. And of course, there was another case that Justice Scalia was involved. He didn't write the opinion, but he very much stood behind it. That came to be seen as wrong among so many conservative legal thinkers, and of course, that's Chevron deference. Justice Scalia, he wasn't on the court when Chevron was decided, but he wrote maybe the single best argument for the doctrine a few years later in that Duke Law Journal article I quoted at the very beginning. It came out in 1989, Judicial Deference to Administrative Agency Interpretations of the Law. Scalia had, I think, the best defense for Chevron, and he kept pressing that defense through much of his career, nearly all of his career, even as more and more doubts were raised around it. There's always been questions about whether he changed his mind or was recalibrating at the end. Maybe we'll get to that later. But first, let's just talk about his defense of Chevron. Aditya, we'll start with you. How should we understand Scalia's defense of Chevron? Why did he defend the notion of judges deferring to an agency's interpretation of the law?
Yeah, and so, you know, maybe this does actually pick up off of where I left the last answer, because I feel that in that Duke Law Journal article that you're mentioning, and as you said, the case is decided, Justice Scalia joins the court, and so he's an evangelist for this case that has already been decided. For those of you who don't know what Chevron is about, it had announced potentially a new rule of approaching statutory interpretation when an agency had previously weighed in on a meaning of the statute. And I say potentially because the author of Chevron himself would often say in later years, I didn't mean to do anything different in that case than the prior cases that had been decided. But the way in which it was written suggested that there was two steps to the court's analysis. First, the court has to determine whether some text is ambiguous, and then, if in fact it is ambiguous, defer to the agency's interpretation on legal questions. And I think what appealed to the justice about this was its simplicity and its rule-like basis. You know, it was something that was easy to articulate as a rule. And he had, and he expresses this in the Duke Law Journal article, some he had a distaste for what he saw as the multi-factor approach that preceded Chevron, where courts appeared to have to rely on just a whole bunch of factors for when the agency's interpretation would have weight. And what's interesting about that article is the tension, and this is part of what I was getting at with my earlier remarks, between what might be thought of as the formalism on the one hand and the precedent and or what did, for example, the Administrative Procedure Act require on the other. And I think he's a little bit dismissive in that article about these latter points. And so one of the ways in which I had thought about this area is, was there a logic to those pre-Chevron cases? But leaving that aside, at any rate, you fast forward a little bit in the Chevron era, and in various cases like United States versus Meade, 2001, Chevron becomes more of a multi-factor approach in and of itself. And this might be oversimplified. I'm sure it's oversimplified in various ways, but the court's rejection of Chevron in a way imposes a two-part test, just using different language by saying that courts must interpret on legal questions, don't defer to agency interpretations on those questions, but with respect to factual questions, there's deference. In some ways, that is a two-part test that Scalia advocated in the Duke Law Journal article. Yeah. So whether and which one of these approaches better matches what he thought of as the pure and best approach in the early days of Chevron, who knows? Yeah. But I think if we look at the arc of the cases, that probably explains how people made moves within the doctrine over the course of decades.
A moment ago you referred to the tension between legal interpretation and policy implementation. My ears perked up because a quote I brought with me that always struck me, and it's not from one of his famous writings. In 1983, he wrote the preface to a new journal at UVA, the Journal of Law and Politics. Does it still exist?
It does still exist, yeah.
And he said, it's really a remarkable little 3-paragraph note, but he says, resolving the tension between the rule of law and the will of the people, between law and politics, is the supreme task of our government system. We sometimes tend to forget that it is more a matter of resolving tensions than of drawing lines, for there is no clear demarcation between the two. And that's in 1983, a few years before Chevron. But that always struck me, and he goes on to refer to administrative agencies, kind of struck me as a good sort of foreshadowing of how he was thinking about what would become Chevron deference, trying to come up with a practical way to separate out these two things, without ever saying there is a clear and bright and easy line between the two. There might be a line there. It's not completely clear, and it's not completely easy. Or Ron, am I overreading that?
I don't think so. But for Nino, Chevron wasn't the same as it was for all of his colleagues. He really thought about it as separating out what courts should do from what agencies should do. And when agencies were acting in the part that they should do, which is actually applying the law to particular situations, the courts generally should be deferential to that. And when the question was, what did the law mean? What was sort of the abstract reading of the law? Nino was somebody who wasn't going to be deferential because he took that job very seriously and he had his ways of looking at it. He looked at the text of the law. He looked at what the text meant at the time it was adopted. He looked at what was reasonable when you put that text next to other parts of the same statute or other statutes that dealt with the same issue. Had he used the language of implementation versus interpretation, I think it would have been easier to understand, but it would have been easier to understand in Chevron itself. You have, a 29-page opinion that has 2 footnotes that seem to contradict each other within a page or so of one another, that use language that if you wanted to create a lot of conflict and controversy and confusion in the field, you couldn't have done a better job. But if you also look at what Nino was writing as a defender of Chevron, the article that you refer to, Adam, Nino says, if you believe that tools like looking at the text of a statute can do a good job of interpreting the meaning of the statute, and he says, as I do. You won't have many instances where you are unclear about how it can be applied. So that he goes on to say, the reason why he's a big fan of Chevron is because it lets the court do what the court ought to be doing based on the tools available to the court. And then if you have something that looks like you could apply it in a lot of different ways, then the answer is you can apply it in a lot of different ways. And the question of the court at that point isn't, what does the law say? But is your application reasonable? And reasonable includes, does it exceed your authority under the law? But if it doesn't, you can have many different ways of implementing it. And that's the reason why he was dissenting in the Brand X case.
Yeah.
And it's also the reason why Clarence Thomas, who authors that case, later on says, I was wrong in that, and changes.
Yeah, the Brand X case, for the uninitiated, that's the case where the Supreme Court was asked, if a court has authoritatively interpreted a statute, but said, here's our interpretation, the statute's ambiguous, here's our interpretation. And then later an agency says, well, if the statute's ambiguous under Chevron, we can just pick a reasonable interpretation and the court should defer to us. Well, should the courts then defer to that? Even if a court has interpreted the law, can the agency reinterpret it? And it was striking that for a lot of us reading the opinion at the time, Justice Thomas's opinion seemed right. It seemed just a straightforward application of Chevron. Statute's ambiguous, agency interprets it, court will defer if the interpretation is unreasonable. Justice Scalia, at the end of his dissent, he disagrees. He thinks this is madness. If a court has interpreted a law, that's the end of it. He says, according to today's opinion, the agency is free to take the action that the Supreme Court previously found unlawful. This is not only bizarre, it is probably unconstitutional. And then he goes on in his last lines to say, it is a sadness that the court should go so far out of its way to make bad law. I respectfully dissent. Now that's 2005, so still more than a decade before he passes away. But you do see in other cases, the one about our deference, which we're not gonna get into, where he's changing his mind about other things, and the constant question was he changing his mind about Chevron deference itself? But now I want to ask about something else. I want to talk, let's shift to structure. Aditya, I'm going to ask you about removal, agency independence, and then Ron, I'm going to ask you about delegation, if that's okay. Aditya, we touched yesterday a couple of times on Scalia's view of executive power, separation of powers, famously Morrison versus Olson. How did those themes play out in Justice Scalia's decisions on administrative agencies?
Yeah, so, Morrison versus Olson, Scalia writes a dissent. This is probably one of his more famous opinions, even though it's not a majority opinion. And a couple of things that I could say about that.
I think Scalia went on to say his Morrison versus Olson dissent, I think he told New York Magazine, it's around 2012, was his favorite opinion.
Oh, is that right?
I think so.
Okay, well, I didn't know
Don't quote
that.
me on that. Yeah.
But, before I turn to the opinion and its implications, just a moment, I thought the letter that I previously referenced at the tail end of the Carter administration, when they're contemplating things like an independent Department of Justice, well, that is in fact the moment at which a balance, what they perceive to be a balance is struck, and the Ethics in Government Act is enacted in 1978, which creates the independent counsel. And so, in a way, it doesn't make the Department of Justice wholly independent. In fact, the Carter administration, you can find an opinion by the Attorney General at the time, Griffin Bell, saying that would be unconstitutional. But they let the independent counsel go, and they say, they pass the Ethics in Government Act, which creates that entity. And as people in the room no doubt know, it leads through a sequence of events to the independent counsel in this one investigation, Alexia Morrison subpoenaing the Assistant Attorney General, Ted Olson, at the time, and that tees up this litigation that makes it to the Supreme Court as Morrison versus Olson. And I think that one little nugget that's interesting to me and that I learned through looking into the case is that, in fact, the justice had written about the issues of removal before Morrison. And so if one reads Morrison has fantastic lines and rhetoric, some of his most famous quips, such as, it takes an Ipsy-Dixit, this wolf comes as a wolf, or he who lives by the Ipsy-Dixit dies by the Ipsy-Dixit. Those types of lines that are referring to the independent counsel statute and Humphrey's executors cabining of Myers and Morrison's then cabining of Humphrey's executor. And it doesn't have much of a discussion of the history, but it turns out that the justice and others around the time were quite familiar with it. And so he had written an article in 1985. It's called Historical Anomalies in Administrative Law, where he's talking about these various debates that occurred over the removal issue over the course of centuries. And then subsequent to Morrison versus Olson, there's a famous article called Originalism, the Lesser Evil, in which he talks about Myers and its use of history over time. And that's the article with which I associate the term faint-hearted originalism. He uses that term there to say, well, this is my perspective on what the right view is of the removal issue, but conceivably there would come cases where I would engage in faint-hearted originalism. And to your point, you had asked about the Federal Reserve, right?
I was going to ask, but if you want to jump into it, let's hear about the Federal Reserve.
Yeah, I knew this was coming. So there are, I wonder, and we will see, because, I just cannot know what Justice Scalia would have done in a situation like this. We don't want to put words in his mouth, and we can't speak about that with any confidence. But there's some breadcrumbs in a case like Morrison versus Olson, where there's both a vision of how removal and the president's control of the executive branch has to work as a first best matter. And then there are some, perhaps pragmatic considerations that lead him to say, well, I accept this precedent. And the precedent that comes to mind is the Perkins case, which is about inferior officers. And Chief Justice Taft had also accepted it in Myers versus the United States. So exactly how all of that is going to play out in the new set of problems that are being confronted by new sets of people, who knows? But it's some combination, I think, of people approach cases with, these are the first principles, this is what I would think is the right way to approach things as an original matter, but then potentially here are the ways in which I'm willing to compromise or make gestures in a different direction that might be perceived as faint-hearted. And whether that's done through, cabining certain precedents, or it's done through doctrines like severability, I can't quite predict, and I actually have no idea what the justice would have done.
I mean, as we've seen over the last 2 days, with Justice Scalia and executive power, he had a clear sense of the constitutional line between what had to stay with the president and what could be done by government elsewhere. He wasn't around for these, obviously he's not around for the current debates around the FTC, but over the last years of his life, the Supreme Court was hearing cases about other agencies, their forms of independence. And I think I would be stunned if Justice Scalia didn't wind up on the unitary executive side of most of the cases we're hearing now. Federal Reserve's more complicated. But now, when you look at non-delegation, you might look at it and say that's almost just the flip side of the other coin. Debates about the unitary executive are saying even if a president signs a law that makes an agency independent, it doesn't matter. The executive has to have the executive power. The president can't just be allowed to give it away. Well, you look at the non-delegation doctrine. Can Congress just write laws so broadly that they're effectively delegating away their legislative power to agencies? Sure, Congress made that law, but shouldn't the courts keep the legislative power in the legislature? That's one way to look at it. But Justice Scalia, through his whole career, was skeptical of a judicially enforceable non-delegation doctrine. Right? He was writing, well, one more thing, he was writing, again, when he was here at AEI in our old building, he was writing essays. One was called the Note on the Benzene Case, even more exciting than it sounds again, and where he pours real cold water on calls for a judicially enforceable non-delegation doctrine. And then in a case like American Trucking, the Whitman case, he writes the court's opinion saying the rule for the non-delegation doctrine is the intelligible principle doctrine. It's not the tightest limit, to say the least, on Congress handing over a lot of power to administrative agencies. But Scalia had no real appetite, it seemed, for a stronger version of the non-delegation doctrine. Am I right about that? And if so, Ron, why?
Not entirely. Let me start three different pieces here. So first of all, the note on the benzene doctrine, the article in Regulation Magazine when Nino was here at ALI, it has a lot of quibbles about a non-delegation doctrine, but it also says that you actually need a judicially enforced non-delegation doctrine. Otherwise, and he says, warts and knobs and all, but he says otherwise you can't maintain the separation among the powers of government that are handed out by the Constitution to different parts of the government. You have the power of legislation, which is given in Article 1, Section 1 to the Congress. You have the power of the executive, which in Article 2, Section 1 is given to the president. And you have the power of the judiciary, which in Article 3, Section 1 is given to the courts that have to be set up a certain way. And everything in the Constitution, it has to go a certain way. It's not just that Congress has the power to pass laws. They have to be done a certain way. You have to have agreement among the two houses of Congress, which are composed differently, of people elected in different ways, or at that point selected for the Senate in different ways at different times for different terms, representing different constituencies. And you have the ability of the president to veto it. To get a law passed was supposed to be difficult. We talk a lot about gridlock as if that's a bad thing. That was the good news, not the bad news. And so when Nino was looking at questions like the non-delegation doctrine as a professor, he's reluctant to embrace it, but he does embrace it. He says, we need something like that, however bad it is. When he's on the Supreme Court, he's much more reluctant to have a doctrine that turns very largely on matters of degree as to which judges are not going to be the best people to figure out where the practical differences are being made. You talked about the Morrison and Olson case, and Aditya talked about that. And it is a case that he starts out by saying, power. This is what the case is about. It's about Congress trying to take power away from the president. And here's how they do it. They do it through setting up a mechanism to actually have people outside the executive's control policing how the executive branch works. So when Nino is looking at that, and you talk about what he says in the Whitman case, he really is very reluctant to have a doctrine like that. But what he does have is a bunch of other things that are substitutes for that. So he insists that any power that's exercised by a part of government has to be exercised in a way that's consistent with what the Constitution says that part of government does. So you look at the Mistretta case, where he talks about Congress having created a junior varsity legislature.
The Mistretta case is the case, it's a non-delegation challenge to the sentencing guidelines.
Yes.
You have the Sentencing Commission, that's writing the rules for sentencing. And then he says...
He says it's like having, because the Sentencing Commission isn't applying those rules. It's just creating rules. And while Nino was a big fan of rules, he wasn't a fan of having a lot of different legislatures. There was one Congress set up to do things one way and to make it difficult. And he says in the opinion about the Sentencing Commission, he says it may be a good idea. It may be something that really works well and improves the law. But it isn't consistent with the separation of powers in the Constitution. And however good an idea it is, however well it might work, it's not one we can accept. And that really does scale back to his view of the rule of law, to what it has to be, to doing things in a certain order with certain rules. So while he's against having a non-delegation doctrine, he's in favor of lots of things that limit the delegation. I just want to get back to one thing you said there.
Sure.
It may seem on the surface like you don't have to worry about if Congress is willing to delegate its power to somebody else. Who's to be concerned about that? You know, Congress ought to be the ones zealously guarding their own power. The problem is, as a member of Congress, you never vote to give something to an agency out of the goodness of your heart. You get something out of it. As a result of giving it to the agency, you're off the hook for a lot of things that'll be controversial decisions. You can say, I wouldn't have done that, but the agency did that. And at the same time, you can have your influence over the agency. You put your people on the agency. You mentioned I served on a nominally independent agency.
Yes.
And when I was going through the confirmation process, one of the senators said to me, now, Mr. Cass, hypothetically, if you have a case before you at the commission and you get a call from the president telling you how he wants you to decide that, what would you do? And so I said, well, I would listen respectfully, and I would tell him that I appreciated his input. I would put it on the public record that I got some ideas about the case, and then I would decide it the way I thought was appropriate under the law. And the senator said, very nice, very, very good answer. Now, what would you do if a member of the Senate Finance Committee calls you up? And I said, well, I do the same thing. And he looked at me like I was the dumbest person he'd ever met. He said, son, you're going to be on an independent agency. And that means independent of the president. There is no independent agency set up to be independent of and uninfluenced by the Congress.
Yeah. Aditya, anything you want to add on non-delegation?
No, not really. I mean, I think that, again, we see the justice's interest in rules playing out in this area. And so he's very skeptical and concerned about the idea that whether there is a non-delegation challenge could be a matter of degree as opposed to something that can be judged on a class-wide basis. And you know, it is interesting to see how this doctrine develops. We've obviously seen further development since the justice left the court. There was the Gundy case from 2019, but then the Consumers Research, the FCC case from a year ago. And you know, those seem to perhaps point in slightly different directions for where the court will go. And if we're trying to think now 10 years after the justice's passing, which vision has prevailed? You know, has he prevailed on, or is his vision of the law still dominant in various areas? At this point, you might say it still is, because that kind of more or less robust application of the non-delegation doctrine remains in place.
Well, let's stay on this for a little bit, and let's just speculate. In the last few years, you've had interesting opinions from Justice Thomas and Justice Gorsuch and lower court judges, and a wave of scholarship debating the non-delegation doctrine again and thinking about ways that it might be reframed, recalibrated, looking back at old cases and saying, well, actually, there was more there, maybe. I'm not asking what would Justice Scalia say in a case, but how might he think about these debates now? Ron, I'm curious, how would he go about thinking about the non-delegation arguments that Justice Thomas and Gorsuch and others are sort of offering and debating and thinking about?
Well, in part, what he would be doing is, I think, what the court is actually doing itself. They have a lot of doctrines that sort of are mini versions of a non-delegation doctrine. You look at the major questions doctrine, which is really two doctrines. One doctrine is a major question clear statement doctrine, that we need to have a clear statement of authority being given to different agencies if we're going to read that into the law, particularly if you have an agency that has been operating for decades and never thought it had this particular power and said it didn't have the power, and then decides suddenly it has it. Which we saw with the FDA, we saw it with the FCC, we've seen it with a number of different agencies. The major questions doctrine said if you're going to exercise a big authority, we're not going to read it just out of a thin slice of what the law says. I mean, this is the elephants and mouse holes doctrine really is the clearest statement of what the concern is.
Yeah.
You're not going to take something small. When the FDA says it has the authority to regulate tobacco, to regulate the use of tobacco, nicotine as a dangerous drug, and tobacco as a drug delivery device, 50 years after the passage of the Federal Food, Drug, and Cosmetics Act. The same year that act is passed in 1938, you have subsidies being created for the tobacco industry. Do you think Congress meant to regulate tobacco with one hand and subsidize it with the other hand? And so a lot of the tools that Nina would have brought to bear don't have to be called a non-delegation doctrine, but can have a lot of the same effect.
Adichie, you want to jump in on this?
You know, on non-delegation itself, I probably don't have too much to add.
Yeah.
But if we, I don't know if you plan to talk about, might well be the justice's most cited opinion is Lujan in the Article 3
on standing
area. So that just strikes me as something that conceivably you had.
We'll touch on. I will say, when I was in law school, I got to take a class from Justice Scalia and the late Professor John Baker on standing and the separation of powers, where you really got to see from the ground up why this seemingly esoteric doctrine of standing, which is to say you can't bring a lawsuit in federal court unless you can show that you're actually injured and that your injury is caused by the person you're suing, and that it's the kind of injury the court is in a position to actually relieve and remedy. So I love the subject, and as you said, it is one of Justice Scalia's most consequential decisions. Say a few words about it.
Well, so this is another one of those areas that it turns out that Lujan, the opinion that you referenced, was decided in 1992. And this ends up being one of the most cited opinions in public law, largely because, as you can imagine, in almost any case, somebody could raise a standing issue. And this is the place you turn to figure out what the test is for standing. It's the case that synthesizes some earlier cases and comes up with a three-part test, which everybody can rattle off: the injury in fact, the connection, redressability, and that ends up being the modern test for Article 3 standing. Well, it turns out that the justice, he'd written an article in 1983 that previewed a lot of the same themes that are in Lujan. It's called the doctrine of standing as an essential element of the separation of powers.
Yeah.
And so you might have more to say on this topic than I do.
Well, I don't mean to preempt you.
Of your class, but reading that article, it's interesting how it connects this idea with just foundational cases that you might learn about in a federal courts class, like Hayburn's case, and the whole question that's the backdrop against which this case is being decided is that here we have officials, Article 3 judges, who have life tenure, who have undiminishable salary. Surely there are some limits to what Congress can give them as authority. There must be something that they cannot be allowed to do by statute, and standing is associated with this deeper principle about American constitutional law. And I guess what I would say, just again to bring it up to like the present day, which is interesting, is that to my mind, both Lujan and that earlier article, they strike me as articles that are working within the doctrine, that take a messy pre-existing doctrine and tries to synthesize and bring it up to speed and say, here's the test. We've used phrases, we pointed in different directions in the past. Here's how to approach this question. And that does then lead, and people still grapple with this to this day, to the question whether, okay, well, this is the test based on that doctrine from the 70s and 80s. Is that baked into Article 3? Yeah. And so I'm thinking of, there was a concurrence or series of concurrences written by a judge on the 11th Circuit, Kevin Newsom, over the last few years, and he's grappling with the question of, does the text or the history of Article 3 lead to this requirement of standing? And so that's something we still live with and think about to this day. And the other interesting angle here, I feel, is that living within the doctrine, the doctrinal approach, which Lujan takes, circa 1991, kind of bakes into place the vision of what's an injury that the courts had in the 1970s and 80s. Yeah. And so whatever they'd accepted up to that point, Lujan has this feel of thus far and no further. Yeah. And so, I think that leads to questions about, well, what is that the first best approach? And the justice was famous for thinking things up from the ground up. And these are old problems, but also new problems. And so it's left to us to try to figure out how all these pieces fit together.
Yeah, I would just add to that and reiterate a couple of things you said. Some of the things I really do enjoy about that decision, the Lujan decision, is, first of all, as you said, he's ostensibly summarizing decades of messy Supreme Court precedent. It's like he's saying, as we've said all along, but of course he has a way of boiling it down into something he says in that opinion. The irreducible constitutional minimum of standing is this. So he brings it all together. Second, as you said, there are interesting debates now about whether it's right in principle, and Judge Newsom's concurrence exemplifies that. But also kind of like Chevron, the standing doctrine, Lujan, certainly hasn't always been applied the way Justice Scalia might have thought. I remember an opinion from about 10 years ago from Judge Kavanaugh when he was still on the DC Circuit, a concurring opinion in a messy standing case. He said something like, we seem to be making standing a lot harder than it should be. And 10, 20 or more years after Lujan, as these cases get more and more esoteric, sometimes it does start to feel like the framework is starting to kind of collapse under its accumulated weight. Ron, were you going to jump in on this, or
I was just going to say,
and then we're going to open the floor to audience questions.
Just going to say, when Nino and I taught a class on separation of power, one of the huge parts of the class was standing, and Nino always liked starting that class with an excerpt from de Tocqueville's Travels in America of courts in America from courts in France. And what de Tocqueville says is that in America, the courts simply resolve cases. And they don't have the authority to really bind people over time, particularly outside the Supreme Court. And what is really important is that all they're doing is deciding how the law applies in that case. It doesn't bind anybody in the future. No, people may go back in other cases, and a body of law may build up with a view of what the law is. Yeah. But the important thing is they're there only to resolve the case, not to oversee the legislature, not to oversee the big decisions. Yeah. And I think that view is very much why standing mattered so much to Nino, because it played in with the notion of constitutional separation of powers and the rule of law more broadly.
Yeah, I hate to be like an immoderate moderator and keep jumping in, but just to add to that, there's a lot in that part of Tocqueville that reads a lot like Lujan, where, to your point, he says, the courts are trusted with an enormous political power and they're in America, and they're only entrusted with that because courts can only receive cases, they don't create them. They're only deciding particular cases, not like abstract theoretical disputes, but a real world thing. And then there's the famous line, right, that even in the 1830s in America, there's scarcely an issue that doesn't sooner or later become a lawsuit.
Yep.
Sooner or later, those were the days. Now it's just sooner. But it's very, I've always wondered if surely Scalia had read and reread that part of Tocqueville, because it's not cited in Lujan, but it's so similar.
I thought it was just de Tocqueville channeling what Nino would later say.
Any questions from the audience, please? Right, you guys know the drill by now. Raise your hand, and a microphone will find John McGinnis.
To talk or ask questions about how one might look at administrative law as seeing Justice Scalia's methodological commitments working themselves pure. In some sense, of course, Chevron, they find a text, and that's what kills his substantive ideas. More generally, he's very focused on trying to understand the Administrative Procedure Act as a text and constraint, which judges had not done. But it's interesting also that the way he does it, to go back to maybe our discussions this morning, is not by looking at the APA with a dictionary. Famously, when he looks at no law to apply, you can't understand that by looking at what no law to apply means separately, but only looking at it in the context of the common law. And what's happened, in fact, I think his legacy in understanding the APA is actually called APA originalism. It's not called APA textualism. And that may even point to the kind of reconciliation of his textualism and originalism. In other words, the APA is a way of understanding that, well, they're very consonant, and that they need to be made consonant, and that they all have to understand the text in context and historical context. And so it's a real window into the power of his thought, even to kill his darling, Chevron, and in its progression over time as people have taken it up to work itself pure.
Yeah, I mean, I have a lot of sympathy for that. So if the question was a yes/no one, yes, I think that's right. And there are parts of the Chevron opinion that deal with doctrine, and then there are parts of it that have this more political philosophy style reasoning of, our courts or agencies better suited to do X, Y, or Z in general, and how courts don't have they don't have a political constituency. And you might think of that as being the more doctrinal or text-based, to the extent there's any discussion of the text in Chevron itself, versus the more policy-based part, and the more doctrinal or text-based aspects have become more dominant over time on our current court. But it still leaves, and I think your question was anticipating this issue. It still leaves this question of how to understand the text in context. And I came armed with a quote as well, Adam, which I've not deployed until this moment. But it's from one of the justice's articles when he was a law professor at the University of Chicago, and it's late 1970s, 1980s. It's the article about Vermont Yankee.
Yeah.
And Vermont Yankee is kind of the DC Circuit. You are ignoring the text of the APA style opinion, and the justice, in this pretty technical area, has an article, and then he has this set of lines which just I thought were really interesting because they made me think about where he would be in another 10 or 15 years. This is from like the late 1970s, 1980s. So this is a quote. He says, "I do not mean to denigrate the philosophy of judicial restraint and of strict judicial adherence to statutory text, which the court's opinion in Vermont Yankee displays. It's a philosophy that I share. One must be realistic, however, about what it achieves and about how far one wishes to carry it." So that's in the article. And I think what he's trying to say in that paragraph is that the text has to be read against the history, and these are terms of art that, as you say, in the no law to apply area, that we have to grapple with from that perspective.
Ron, can I ask you a related question? Just Aditya's answer brings this to my mind. In the late 1980s, you had interesting debates among conservative legal scholars, conservative judges, Easterbrook, Silberman, Scalia, about interpreting laws and whether or not or how to use legislative history. And it seems to me that Chevron deference kind of made that debate a moot point, right? If a statute is ambiguous, defer to the agency. You don't have to get into legislative history. Of course I wish Scalia were here now, but one of the things I would have loved to see him work through is, in the absence of Chevron deference, how, if at all, should courts grapple with legislative history? He had that famous line, right, that legislative history is like looking across the room and picking out your friends. That's definitely a bad way to use legislative history. Maybe there's only bad ways to use legislative history. But it seems now judges are going to have to re-engage that debate one way or another. And I'm curious how you think Scalia might have gone about thinking through that kind of question in this era.
Well, one of the things that comes up periodically is people saying he didn't like legislative history when it came to statutes. He uses it when it comes to the Constitution. The problem in the statutory domain for Nino was largely that legislative history wasn't only a history of how the statute came to be. It was also what people wanted judges to refer to when they interpreted. There's much legislative history that is written for the judges. It's not really part of you can't find a lot of members of Congress who can tell you what is in all the reports that are written, not all of which are available to the members of Congress when they're voting. And almost none of which has been read by most members of Congress when they're voting. In the Constitution-making process, the debates that were there were central to a lot of the outcome. And it's trying to parse what the language means is helped by actually knowing what people were talking about when they were actively writing the Constitution. So it's not staffers who wrote something cobbled together from people who filed things with the staffers to help them get to a point they wanted to get to. It's a completely different process. Yeah. And I don't think that Nino would be in favor of now turning to legislative history for statutes the way he was opposing that before.
Yeah. Can I say one thing, which is, it's only loosely related to our administrative law panel, but it's a little anecdote. And when we think about the legacy of Justice Scalia, he obviously was a titan in administrative law and wrote groundbreaking opinions that we read today will probably be read decades from now. But in candor, in honesty, time passes and there are newer opinions, and it's only natural in an introductory administrative law class when you're signing. I reflected on this year because I used to assign his case, Whitman versus American Trucking Associations, every year until this year. And when the FCC Consumers Research case was decided, I thought, why, I ought to assign that, and there's only so much space in a curriculum. So those cases, they drop off from time to time. But as John McGinnis's question was suggesting, there were a deeper set of principles that were associated with Justice Scalia and that he articulated, and those are timeless in a way, and they are so closely linked with him that I think we'll remember them 100-odd years from now. Yeah. And having said that, there have been questions from the audience throughout the afternoon and the morning that asked, well, how do we know that these were principles he was committed to? And this is my anecdote, which is that the year that I was clerking, there was a case. And it turns out there was a case on which, and I don't say this to toot my own horn or to toot the horns of my co-clerks or anything like that, but it's a case on which the justice and us had very different instincts. And I remember this one so well because the oral argument ends, and as you heard from some of the other law clerks yesterday, we all got into his office afterwards and we discussed the cases, and we went for hours on this one case, which is not a super famous case, but it makes it into the case book, so it's a case. And we just went for hours, and the hours included him berating us at some points, like, I should never have hired you for. Like, what was I thinking when we got here? And so the whole discussion is called at some point, and we all leave, and we come back the next day, and my co-clerk gets a phone call, and the call is from the justice, and the justice says, Brian, you were right. We'll do things your way on this case. And so I do think that he was one of those people where this methodology really mattered, and he could be moved in cases based on appeals to, obviously not just appeals about policy matters or things of that nature, but appeals that within your methodology, within your approach, this is the most consistent way to approach this issue. And that was my own personal experience with it. And again, I don't say it to somehow like show that we were particularly powerful as law clerks. We were not, but rather that's what he wanted from us, the ability to argue on his terms. And there were times, and I think it's sort of moving and powerful to reflect on the fact that he was willing to make those adjustments.
That's great, Aditya. Ron, we'll give you the last word. Any words in closing?
I will say one thing which ties in with Aditya's last story there. Nino was somebody who was committed to principles. He was deeply committed to them, and he took them seriously. And you could argue matters of principle with him. He wasn't very easily moved on principle. He wasn't easily moved on anything. But if you talked about the application of the principles, he wasn't somebody who would just say, this is the way it applies, that was the end of the story. You could have an argument about it day after day after day. There were very few things I disagreed with Nino about. But the things we disagreed about, we talked about for decades. And I won't say either one of us ever convinced the other on those things. But he was both firmly committed to his views and open to discussion at the same time. And that combination is rare indeed.
Well, that's great. And just one last observation from me. We've been talking about this article from the Duke Law Journal on judicial interpretation, or judicial deference. And that came out in the same, basically 1-year window as the other papers we've talked about, his paper, The Rule of Law is the Law of Rules, Originalism, the Lesser Evil. Another one was called Assorted Canards of Statutory Interpretation. There might have been one other. It's really incredible when you go back and you read these, and I think most of them were speeches, and maybe he had given them a few times before he finally committed them all to writing, but this is just 2 years after he joins the court. And it was, in hindsight, just amazing that he put together these essays that are completely readable. They're not, with all due respect to modern scholars, they are not 80-page treatises, 180-page treatises. They are 15, 30 pages that just really crystallize the core of what Scalia would sort of elaborate over the course of his career. So if you aren't familiar with those essays, I really encourage you to look them up. And if you're interested in Scalia the writer, I have good news. That will be our next panel. So we'll take a 15-minute break and return, but please join me in thanking Ron and Aditya.
you all. We are ready to finish off this wonderful symposium with our last panel on Justice Scalia, the writer. I'm delighted to be here with two of my friends, Chris Scalia immediately to my left and Judge Jeffrey Sutton further to the left. Judge Sutton is, as I mentioned before, is the Chief Judge of the U.S. Court of Appeals for the Sixth Circuit, where he served since 2003. Chris is, among other things, a senior fellow here at AEI. Jeff and Chris share the harrowing experience of working with me as co-editors of volumes of Justice Scalia's work. Chris and I co-edited Scalia Speaks, Reflections on Law, Faith, and Life Well Lived, a New York Times best-selling collection of Justice Scalia's speeches. We also produced a smaller volume, On Faith, Lessons from an American Believer, which presents Justice Scalia's views on the law of religion and his own thoughts on faith. And Jeff Sutton and I produced the Essential Scalia on the Constitution, the courts, and the rule of law, which I'm pleased to say has been praised widely, as my friend Jack Goldsmith put it, as an extraordinary collection of Justice Scalia's legal writings, the best introduction to his legal thought. Now, Jeff and Chris Scalia are also accomplished writers in their own right. On top of, I believe, well over 1,000 opinions, Jeff has written 2 books, at least 2, 51 Imperfect Solutions, States in the Making of American Constitutional Law, and Who Decides, States as Laboratories of Constitutional Experimentation. Chris's many writings include his recent book, 13 Novels Conservatives Will Love, but Probably Haven't Read. Now, I've heard a lot about what a great writer Justice Scalia is, and I just want to make clear to everyone that I think praise for his ability extends across the ideological spectrum. Elena Kagan kindly wrote a foreword to the Essential Scalia, and I'm going to read an excerpt from that foreword. No one has ever written quite like Nino, and no one ever will. He was a master of the aphorism, the analogy, the metaphor, the aside. His prose was simply ingenious, clever and pungent, pithy and sharp, plain-spoken, yet utterly original. But the style was not for the sake of style. It was always in the service of ideas. For all Nino's stylistic flair, the real strength of his writing, especially when he concurred or dissented, lay in its passionate yet disciplined engagement with ideas. Nino laid out cogently, logically, with analytic rigor and precision, and at times with the elegance of a mathematical proof, deep and provocative understandings of the way the law should work. It's possible that Nino wrote so well because he thought so well. We're going to start off in this panel by presenting some of our favorite writings from Justice Scalia and then explore deeper questions about just how and why it is that he wrote so well. So Chris, let me start with you. Maybe you could tell me 1 or 2 of your favorite opinions or passages, whether from the law or from his other writings.
Well, I'm going to thank you, Ed, for that wonderful introduction. Thank you all for being here. Thank you to EPPC and AEI for organizing this. And thank you to Chick-fil-A. I'll start by quoting somebody who is has some conservative opinions, but I don't think is generally considered an arch conservative like my father. And that's the literary scholar and legal scholar Stanley Fish. He wrote a book a while ago, about 10 years ago, called How to Write a Sentence. And in the introduction, he identifies a few sentences he really likes. And one of the ones he picked was from Lee v. Weissman, my father's dissent in that case. I think Jeff and Ed both know that well. And just, he's setting up the context here. My father quoted something Frank Easterbrook said in an earlier decision regarding this matter. And my father builds off of Frank Easterbrook's observation and writes, "Interior decorating is a rock-hard science compared to psychology practiced by amateurs." And Stanley Fish devotes 2 paragraphs explaining why he likes that sentence. This sentence is itself a rock thrown at Scalia's fellow justices in the majority. It is a projectile that picks up speed with every word. The acceleration is an effect of the two past participles compared and practiced. Their economy does not allow for a pause or a taking of a breath, and the sentence hurtles toward what is both its semantic and real-life destination, the amateurs who are sitting next to Scalia as he spits it out. The pleasure I take in the sentence has nothing to do with the case or with the merits of either the majority's or the dissent's arguments. It is the pleasure of appreciating a technical achievement. Here, the athletic analogy might be to target shooting. In this case, Scalia's ability to load, aim, and get off a shot before his victims knew what was happening. I carry that sentence around with me as others might carry a precious gem or a fine Swiss watch. I pull it out and look at it. I pull it out and invite others, who are sometimes reluctant, to look at it. I put it under a microscope and examine its innermost workings. I'm sure that there was no overstatement or exaggeration there.
I have to interrupt you there, Chris.
Go for it.
You had told me about this just before this session, and I had never heard that before. And I'll just say that Justice Scalia, as Danielle Sassoon mentioned before, let his clerks acknowledge their role in one case each term, and mine was Lee versus Weissman. So very gratifying to hear that praise.
Yep. Do you want to talk about the origins of that sentence?
Well, I'll just say that it would be very recognizable in the draft that was presented to the justice, but he sharpened it.
Yeah, great. I am not a lawyer, though I did stay at a Holiday Inn Express. I read, I'll talk more about my interest in his opinions later, but one of my favorites is not an especially significant case, but I loved his dissent in PGA Tour v. Martin from 2001. The context of that case was that the PGA determined that a golfer who had a disability was unable to walk between holes and wanted to use a cart. The PGA ruled, well, you can't use a cart. Walking is an important part of the game, so you're not going to be able to compete. And he sued under the Americans with Disabilities Act, and the Supreme Court ruled that walking, basically, they had to let him use a cart, and walking wasn't such an important part of the game that they couldn't make that concession for him under the ADA. My father's entire dissent is very entertaining. When this case came out, I was a grad student in English literature, so I especially appreciated the last paragraph because he dropped literary allusion after literary allusion. So I'll just read that one paragraph out loud, but the whole opinion is wonderful. He writes, "Complaints about this case are not," quoting the majority, "properly directed to Congress. They are properly directed to this court's Kafkaesque," it's one, "determination that professional sports organizations and the fields they rent for their exhibitions are places of public accommodation to the competing athletes, and the athletes themselves customers of the organization that pays them. It's Alice in Wonderland, too, determination that there are such things as judicially determinable essential and non-essential rules of a made-up game, and it's Animal Farm, 3, determination that fairness and the ADA mean that everyone gets to play by individualized rules, which will assure that no one's lack of ability, or at least no one's lack of ability so pronounced that it amounts to a disability, will be a handicap. The year was 2001, and, quote, everybody was finally equal. That last one's a real tricky one. That's a Kurt Vonnegut short story, Harrison Bergeron. And when I read that, I said, did Dad read Kurt Vonnegut? And so afterwards, I asked him, you read Kurt Vonnegut? And he said, oh, yeah, sure, great story, great story. And I don't know if he actually read it or a clerk drew his attention to it, but it was a great way to end that dissent. And then very quickly, one more I've always enjoyed because it shows his range as a writer. This Scalia Speaks, available at fine Amazon sites everywhere, includes a number of eulogies and tributes he wrote for friends. And one of them was for a former colleague of his at UVA Law School named Emerson Spees, who passed away in 1991. So my father wrote just a beautiful homage to him which was full of lyrical passages he didn't really have the opportunity to write in any of his decisions. So I will just read a couple of paragraphs here. This is describing where they lived in Charlottesville. And I have to say, I also like this passage because it's beautiful, and it was a really dark time for my family because I hadn't been born yet. So that they were able to find such beauty in those dark times was really wonderful. He wrote, "We were very lucky to have ended up in Westlea, not least because it gave us frequent occasion to go over and visit Emerson and his children in their cottage on the shore of Westlea Lake. In those days, before the hurricane that silted it up, the lake was well stocked with eating-sized bass, and I remember very fondly taking my family over for a congenial hamburger dinner and spending the twilight hour chatting with Emerson while casting from the patio into the water. Emerson spent a lot of time with his family, as he later did with Julia and his new family. In those days, the venue of his domesticity was not only the Westlea cottage, but also the big house at the end of Rugby Road. There, those who are fortunate enough to have experienced it will recall another aspect of Emerson's life, Emerson, the azalea grower. I suppose there are more impressive displays of azaleas somewhere, perhaps in the Arboretum in Washington, but I have never enjoyed anything as much as a spring party Emerson used to throw for the faculty, when we would stroll through several acres of resplendent azaleas, gin and tonics in hand, taking only slightly more pleasure in the flowers than we did in Emerson's childlike delight in having produced them." I'll stop there.
Great, Jeff?
Okay, well, first of all, Ed, it's great to be with you and to be with Chris. I've particularly enjoyed getting to know Chris. You should read his books and his articles, essays. They're really terrific. I don't think I've told you this story. I was up in New Hampshire and giving a joint appearance with Justice Souter, and we were talking before the event, and we were talking about Justice Scalia, and he said something about, the justice would send me some of Chris's stuff, and he was so proud of it. And, and Justice Souter read a lot of your stuff, and he said, I think Chris might be as good as the justice. So we'll see. There's still time. But anyway, even Justice Souter was complimenting your work just a few years ago. So I don't think there is one great writing. To me, that's the amazing lesson and remarkable example to me as a judge. I don't think there's a Scalia opinion out there, majority or dissent, where at some point in the opinion you're just going to stop and say, wow, that is just a great way to put that point. That's just such a nice way to synthesize it. And so that to me is the amazing thing about Justice Scalia. He did it in the big cases, the small cases. And for lower court judges, that's just such an amazing example. I mean, we get, I probably write 70, 75 opinions a year, and you just kind of have them on your shoulder there saying, okay, don't let this go too early. Make sure you're really giving it your all. And I really think that's his amazing legacy, is great a phrase maker as he was. So the case I'll mention kind of illustrates the point. It is a run-of-the-mill case called Kiles versus Whitley from 1995. It's a criminal case. I can just tell you, federal judges do this kind of case 10 times before lunch every day. I mean, we just get so many of these cases. And I think one of the challenges of being a federal judge is to keep getting the same case and making sure you're stopping, you're looking at the record, and you're trying to figure out what really happened here. It's really easy in those cases that, and this is a good example. This case mattered only to the parties. That's all it mattered to. And he put a lot of energy into it. The gist of the case, it's called a Brady Law issue, was whether the police had not handed some evidence over to the defendant that might have helped the defendant in the trial. The response of the state was not that they shouldn't have turned it over. The response of the state was it couldn't possibly have made a difference because there were 4 eyewitnesses that saw his face. So that's how the case is presented. Scalia's in dissent. It's Justice Souter writing the majority. In the very opening paragraph, Scalia says, quote, "The court's verdict would be reversed if there were somewhere further to appeal." I love that line. Must have frustrated him that at least in that instance, they were the only ones. Then he described the majority's theory as Kiles, this is the defendant, was, quote, "a victim of a frame-up by the police informer and evil genius, Beanie." I love that, evil genius Beanie. And then towards the end, this is the part that has always stuck with me. He says, "The court's objection
is that the 4 eyewitnesses could identify the assailant, quote, only by his face and did not see his height and build. Scalia's response, but, quote, facial features are the primary means by which human beings recognize one another. That is why police departments distribute mugshots of wanted felons rather than Ivy League type posture pictures. It is why bank robbers wear stockings over their faces instead of a poncho. And it is why a criminal defense lawyer who seeks to destroy an identifying witness by asking, "You admit that you only saw the killer's face," will be laughed out of the courtroom. I mean, I just don't understand how you could read those words and not have joined that dissent. So, I mean, you know, he was, well, we'll get into the whys and lessons we can learn. But anyway, those are, I'll just give you 2, if I just give 2 other examples, but this is purely in the phrase making. You know, he said there's a problem. This is a dormant commerce clause case. It doesn't matter, but the point of the theory, but his point was there's got to be a problem with a theory when the test is, quote, whether a particular line is longer than a particular rock is heavy. Hard to listen to that and not think there's a problem here. We heard earlier he captured the major questions doctrine. I really think it's a statutory interpretation doctrine as elephants in mouse holes, which is just so doubly terrific, right? You know, elephants, how could they fit into mouse holes? Oh, and they're scared of mice anyway. I mean, it just doesn't get any better than that. And, you know, some people think, Brian Garner included, that we should now have a canon called elephants in mouse holes. In other words, the language is so good, we've got to name a canon after it. Now, the reason this isn't going to work is we only do Latin for canons, and I don't know if the Latin for elephants in mouse holes will work. But anyway, you could go on and on.
I'll offer a couple of my own. I'm going to jump to the opinion that I think was the first clear sign of Justice Scalia's greatness. That's been referred to a lot during the symposium. This was his dissent. In 1988, his second full year on the court, solo dissent in Morrison versus Olson. And there are a couple passages here that I think just capture his genius. Again, I think at least one of them has been referred to, but just to put it in context, he's talking about separation of powers. And it says, frequently an issue of this sort, a separation of powers issue, will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf. And so you could just see, you know, he sets it up. You could sort of imagine him studying these sheep to see, are you a sheep or not? And then this wolf comes as a wolf. The second passage there, he's addressing the argument by Chief Justice Rehnquist that the independent counsel statute is constitutionally permissible because the president, through the attorney general, still retains some control over the independent counsel. And he says, I can't refrain from pointing out that the court greatly exaggerates the extent of that presidential control. Most important among these controls, the court asserts, is the attorney general's power to remove the counsel for good cause. This is somewhat like referring to shackles as an effective means of locomotion. Limiting removal power to good cause is an impediment to, not an effective grant of presidential control. And I just remember when I first read that, this clicked for me. I mean, this image, this isn't excess verbiage. This is illustrating exactly what it wants you to understand, which is the baseline for presidential control, just like the baseline for free movement, is not being shackled. And to cite the shackles in your support gets everything backwards. The other passage I want to mention has also come up too, but I think the full passage, well, more of it warrants quoting. This is his concurring opinion in a case called Lamb's Chapel v. Center Mauritius Free School District. And this is a case in which the court ruled that the Establishment Clause had not been violated, but Justice Scalia wrote separately to object that the court had not yet abandoned the three-element Lemon test from a case called Lemon v. Kurtzman in 1971. Like some ghoul in a late-night horror movie that repeatedly sits up in his grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence once again, frightening the little children and school attorneys of Santa Mauritius Union Free School District. Over the years, no fewer than 5 of the currently sitting justices have, in their own opinions, personally driven pencils through the creature's heart. The secret of the Lemon's test survival, I think, is that it is so easy to kill. It's there to scare us and our audience when we wish it to do so, but we can command it to return to the tomb at will. Such a docile and useful monster is worth keeping around, at least in a somnolent state. One never knows when one might need him. Okay, let's talk about what made him such a great writer. I invite you to, Chris, what's your read on this?
Well, all the examples you guys gave are examples of figurative language. He was incredibly gifted with that, which you wouldn't expect from a judge. No offense, but obviously
too late for that.
He was obviously also bringing in plenty of precedent and citations and doing all of the work you expect from lawyers, but he just had such a very creative mind that could conjure up these images, these analogies, and these metaphors that are incredibly memorable and are not only memorable, but drive his point home very effectively. And I'm struck also, he was like that in conversation too. Not necessarily with the metaphor, with the figurative language, but with the ability to just come up with counterexamples too. Jeff, in the opinion you read, he did that. He was just very good at being able to identify holes in an argument by identifying cases where some of the examples or some similarities hold, but there are enough differences to undermine the argument or the principle you're trying to make. And that's a logical ability more than a writing ability, but he's obviously able to write it so effectively, often through that figurative language. So that's less that's more of an overarching method rather than what made him who he was.
He loved language too, I think. I mean,
Yeah.
he had studied Latin. He was, I think, conversant, at least somewhat, in French and Italian. And he was just very attentive to words and appreciated their nuances, and I think really savored using words properly.
He had 2 parents that were teachers. One was a professor of Romance languages. His mom was an elementary school teacher. He was the only child.
And he had 2 aunts who were teachers as well, who he spent a lot of time with too. So he got a lot of attention from teachers.
I mean, I think there's 2 features of it, and one is a little depressing if you're trying to become a great writer and scholar, and the other is gratifying. I do think there's a little bit to brilliant people maybe are born and not necessarily made, even though we can all get a lot smarter. I don't think writers are born. I think writers are made. And one of the things that I found interesting when I was working with Ed on the Essential Scalia was reading his early scholarship in the 70s and some of his DC Circuit opinions. And his brilliance is there. It's very evident, just so good at inverting an argument and seeing the other side to it. Just reasoning skills. But I have to say, some of the scholarship, you can't blame a professor for writing like a professor, but it was very dense quite often. It was administrative law, so that might have been part of it. But even the DC Circuit opinions, I don't think are as accessible. So I do think there was quite a bit of growth when he gets on the court. And I think he was advantaged in the way journalists are advantaged. I mean, journalists have deadlines. They've just got to keep cranking this stuff out. And I can tell you as a judge, we have deadlines too. I mean, theirs are the end of June, ours are throughout the year. We work full-time, they work part-time. But at all events, the point is you have to keep writing. And if I'd never heard him say this, but it had to affect him. He was the first Italian-American on the court. He didn't want to be the last Italian-American on the court. There were a lot of derogatory things said about Italian-Americans in the 70s and 80s. He was going to prove that completely absurd, and he did. So I think he was motivated, and I think once he saw, I'm sure Morrison versus Olson must have been a bit of a revelation to him to realize, wow, these opinions get read in law schools. He realizes his audience isn't just his 8 other colleagues, it's scholars and then it's students. And I think that he drove him. I mean, I remember clerking for him thinking, how could this guy keep going back to the well? I mean, the well was never empty. There was always a new phrase there. And I think it's the way great journalists and other great writers, the more you keep doing it, the easier it gets. And I think he always said it was hard, but I do think it got easier for him, and I do think he kept getting better and better. So that last part, I think, is really great if you're a young lawyer, law student, that I do think there's a little bit of just pure sweat.
Yeah.
And that will make a difference.
Yeah, definitely. He viewed writing as hard work. It commanded his complete attention. He, I think, liked to quote Dorothy Parker. He said he didn't enjoy writing. He enjoyed having written. I can still see him hunched over the word processor. Should we still call them word processors? I don't know. Struggling to figure out exactly what he wanted to say, and then when he got it, it'd be an aha moment. He was actually an early adopter of the word processor. I think even at the DC Circuit, he began typing his own opinions, and I wonder if that helped him, edit and re-edit. I think you get a lot better that way. But there was an awful lot of just plain old hard work that went into it.
He liked to tell the story of a writing professor he had at Georgetown. He made a big deal about being able to remember the guy's name. He had that much of an impact. His name was Professor Orr. He's a Canadian professor at Georgetown, and he assigned an essay every week. And the first couple of assignments, my dad got B-minuses on, and he wasn't used to that. So he hunkered down for the rest of the semester, and every week he worked harder and harder and was nervously writing these papers. And it showed him that, as he put it, to write well takes time and sweat, and he really learned it from that class, and it's a lesson he took along with him. I always appreciated him. He told that story in public too, but he shared it with me in private, and I really appreciated that, because at the time I was complaining to him about teaching freshman composition and how difficult it was, and he shared that story with me, both I think it meant a lot to him on a few levels. One, as a former student, that made a big impression. And as a writer, it made a big impression. But also when he was a professor, it made a big impression on him too, just the importance of really teaching writing. He explained in one of the speeches in Scalia Speaks that, I'm trying, Ed, we're going to sell these books.
Chris's mother is the royalty earner. We aren't, so.
So I regret that contract. When he was teaching legal writing, he really did wonder if he was getting the students too late at that point. I think he would agree you can teach great writing, but maybe it's better coming as an undergrad. But still, he recognized that it was really important to get the principles of time and sweat down to those law students as well.
I think he had one other, lawyers, let's face it, aren't always that interesting or fun or funny. I mean, they're just not. A lot of them are nerdy. What can you say? And judges, you might say, are worse. And he had a great sense of humor. I mean, this is why Justice Ginsburg loved him.
Yeah.
I mean, So, I mean, I bet in the Scalia home, one night you're watching A Man for All Seasons, and the next night it's My Cousin Vinny. I mean, that just says it all. I mean, he was fluent in both, and he saw humor in situations, and humor works. What can you say? And I think this is where, you know, I don't think he started out doing this. It was interesting. I think it was Adam was making the point about that rush of articles in his first few years. And I think Adam, the reason he was writing was he was disciplining himself. He's trying to figure out, how am I doing this? I've got to figure out a consistent way to do this. But I think it's pretty soon after that he really goes on the speaking circuit. I think he's realizing, I'm sure our year was not a great year for him with Lee versus Weissman and Casey, and realizing that he wasn't going to win these battles with the court as it was, and he had to get out and speak, and writing wasn't going to be the only thing. Well, the thing that's really valuable about speaking is you hear the words, you hear how people respond to points, and so you suddenly realize, wow, that really hit, that really landed. And I really think that started to affect his voice as a writer, as he realized the power of speaking. And I mean, because it's really astonishing how much he spoke.
Well, it's interesting to ponder that relationship between his speeches and his writing. And one thing that was fascinating to me is he always cared how the written word sounded when spoken. I recall one time where he called up Justice Thomas and said, "Clarence, you got to hear this," and read a passage from something he had drafted. And when he got something just right, he would say, "It sings." There's that musical quality to it. Now, I don't know whether he learned in rhetoric in high school that language is more memorable when it has a certain rhythm to it, or you know, whether his theatrical background explained this, but his love of music generally. But he had this keen interest in how the written words sounded. And I think that I thought that was what made him such a great speechwriter. He always knew, you know, where to land the joke. He seemed to have found speech writing very easy. I found some, you know, handwritten speeches, you know, in the files. But you know, I think it's most of us when we write don't think about how does this sound when read.
Yeah.
And maybe Jeff, for you, some of your opinions that you do.
I don't read mine aloud. I mean, I work on him a lot, though. I mean, he did teach people to be obsessive about it, so I definitely fit in that category, but I haven't generated the same fruits that he did. I will say a point, though, about writing, thinking, and how I think the writing, in some ways, came first with his influence, and how much of an impact he had on American law. And I really feel like I'm just a perfect case study of this. As I mentioned in one of the earlier panel yesterday, I was not hired by Justice Scalia. I was hired by Justice Powell. The good news is that allows me to say I picked Scalia, he didn't pick me, which I enjoy lording over Ed. He would have taken a clerkship from anybody. I'm for Scalia here. But here's the more important point, which might surprise you. I graduated from Ohio State in 1990. We did not have a Fed Soc. I was much more interested in sports than politics. I could barely have defined originalism and textualism. There was only one thing I knew about Justice Scalia. Well, there were two things. One is I loved reading his opinions in law school. And two, I was a fan of Robert Bork, I will say. I really had been an admirer of his and thought he was poorly treated. But again, I was apolitical, really did not have a theory of interpretation. And so when I learned that people that worked for a retired justice could sign on with an active justice's chambers, it was just an easy choice for me, but it was had nothing to do with methods of interpretation, nothing to do with politics. It was just like, oh, if I could spend a year with this guy, I could learn how to write. Like it was so intentional and focused on that because I just admired it. And before law school, I'd been interested in writing and had been working on it. And I'm just thinking, how could it get any better than to spend a year like figuring out what the secret to this guy's writing is? Well, I did improve as a writer. I never quite figured the secret out, but I did improve. But the real next step, which I think is why I'm like so many other lawyers of my generation and coming after, is if you're reading all this stuff, it did affect me. Like I'm I'm now as thoroughgoing an originalist and textualist as there is. I mean, you're going to have a hard time finding an opinion I've written for the Sixth Circuit which doesn't follow the Scalia approach. So the writing actually came first for me because I just so enjoyed it. I like humor, and I think I stand for a lot of people out there. I think there are a lot of students out there that said, "This is fun. Who is this guy? Anyone that can write like this, it's worth trying to think, why are they thinking like this?" And someone who's trying to persuade you, you kind of got them at that point. Once they want to know why you think the way you think, you're in a really good place to persuade someone. And I really think this writing panel comes last. I don't wonder if it's first on his influence. Obviously, he was a great thinker. Writing is thinking and so forth. It's like separating substance and procedure. You can't really do it. But he had both. And if you have both and you can write, the people are going to learn how it is you think. And when they learn how it is you think, that's a great way to influence people.
Well, I'd like to build on that, because that, of course, is one of the points that Justice Kagan made.
Was there anything left to build on?
I think Justice Scalia says in one of the speeches that sloppy thinkers are going to be sloppy writers.
A careless, sloppy writer has a careless, sloppy mind.
Yeah, and for him, I mean, look, there are some judges, justices, one gets the impression that they decide what the result, where they want to get, and then they just, plow a path to that. For Justice Scalia, the process of writing was a process of thinking through his ideas. He's trying to figure out, in the way he would say, does this write? Does this W-R-I-T-E? Can I write this in a way that coheres? And sometimes he'd come back and say that the intuition he had about what the right result is doesn't write. And of course, he would then have to figure out what he got wrong and what the proper path is. But it really is, there's a tight connection between writing and thinking, where you should always be thinking while you're writing. And if you're not, your writing isn't going to be very good.
Over the past couple of days, there have been several references to one of the books he wrote with Brian Gardner, Reading the Law. He wrote another one, Making Your Case, and they devote a couple of pages there to how to become a good writer. And it's interesting. Some of it's pretty obvious. Cultivate precise, grammatically accurate English, develop an appealing prose style, acquire a broad vocabulary. And they make clear that's not going to be easy. Those are lifelong projects, but those are fun projects. And they're fun in part because they mean that you need to read a lot of good prose. And they go on, lawyers tend to be bad writers because their profession condemns them to a diet of bad reading material. The very highest they go up to the literary ladder, so to speak, is judicial opinions, which are widely read not, heaven knows, because they are well-written, nor even because they are necessarily well-reasoned, but because they are authoritative. My mom was the real reader in that couple, still is. But my dad had his favorites, and he, writers he would recommend again and again. He loved Burke. He loved Reflections on the Revolution in France. He loved Newman, Chesterton, Lewis. He quoted screw-taped letters a lot in speeches. He would read Tom Clancy during the summer. He liked Tom Wolfe, though not his endings. And of course, he loved Shakespeare. What always struck me about my dad as a reader was how long these things stuck with him. I had just read Brighton Rock by Graham Greene, and I asked if he had read it, and he had, but it must have been like 40 years before. But he remembered the ending so well. It's a really disturbing, haunting ending, and he just remembered it, and we talked about that ending. So that what he read and what he loved really stuck with him. And I suspect he liked Dante, not just because the Italian connection, but of course, Canto 8 of Purgatorio, when Dante sees Nino Visconti, who is a friend and a judge, in Purgatory. And Dante says, "Noble Judge Nino, what delight was mine when I saw you were not among the damned." So that's good. But he understood that to write well, you needed to have writers you admired, looked up to, emulated, not rip off, but take what you admire from them and apply to your own work.
Well, let me toss out a couple of questions here, and then we'll open things up for audience questions. Jeff, Justice Kagan says that she's written many of her opinions while imagining a miniature Nino sitting on her right shoulder. What does the miniature Nino tell you?
I mean, I think the problem with judicial writing is it's just so cliche-ridden. And so I think as I'm going through drafts, that's the real challenge. And, you know, and the justice was so good at being original, turning a phrase, and even just a new word. I mean, just something to show there's a real human being and not a computer behind this opinion. So I guess the other thing, I wish I had time to read my opinions aloud. I don't do that much, but I do spend a lot of time with them, and so I really do edit. I mean, to me, I'm sure that was his secret, without ever having asked him, that it's all in the editing. You know, you got to get a first draft down, but the editing is key, and you just got to keep coming back to it. I'll just say two other things that I think are effective. You know, he's not thought of. Your first instinct is not to say Justice Scalia, the great listener, because he had such strong opinions and he was so quick to express them. It was easy to think he wasn't listening. He was. I mean, I think that's what's really powerful about both his majorities and dissents. If there was something on the other side that was good, you're not going to see a Scalia opinion that ignores it. I mean, he really was hearing what was being said, and I think that's actually the power of it. He's actually taking on the key point and addressing it. And the only other thing I'll say, I was saying how he influenced students. I think the way he's had a huge impact on lower court judges, which really can shape the law, is that, you know, we've got this huge caseload, and sometimes doctrine is a little messy, and he was so good at synthesizing doctrine. So even when, you know, Chevron was on the rise, I mean, someone yesterday said he made Chevron, and what they meant by that was he gave it a doctrinal underpinning. At the same time, he ultimately made it irrelevant with his textualism victories. I would say the same thing about implied rights of actions. I mean, he's trying to synthesize some areas of law the judges and justices are struggling with, and along comes this opinion, whether a majority or not, that says, I think this is what's going on. That's both a writing and a thinking skill, and it's so powerful if that's where the lower court, I mean, we're just trying to get our job done. We're not the final decision makers, and I think that also has had just a huge impact on his really, you know, dominating the debate.
Chris, when and how did you first discover your father's writing?
Well, I think I was aware that he wrote for most of my life, but when it really got my attention was the opinion I mentioned before, PGA case, PGA v. Martin, and in 2001, and I think it was because I'll get a little personal here. I was going to grad school in Madison, Wisconsin. It was after the 2000 election that he was not a popular person in Madison at that time, even though Ralph Nader technically won the Isthmus. People were still upset about Bush v. Gore. And so I felt myself kind of in the position of having to be his spokesman sometimes. So, and I was also, I think the literature I was studying at the time, especially some of the 18th century literature, Samuel Johnson in particular, just for his voice and his reasonableness reminded me of my father's approach. And I don't think my father read much or any Samuel, well, the dictionary he cites a number of times, but I don't know if he read much other work by Samuel Johnson. But I was just, I don't know, recognized some connections there and then grew more interested in my father's writing and then became more interested in his process and talked to him more about it. through grad school and when I became a professor. And I asked him once, is writing easy, to go to your earlier point? And he said, no, it's hard as hell. And that was a great relief to me. But of course, I already knew that was probably going to be his answer, just because I came home when I was out visiting. When I was visiting my parents, I'd come home late at night, and I'd see him through the window at his word processor late at night working. And that wasn't every night, but it was pretty often. So I knew, kind of in the same pose you were describing. And I just developed a great appreciation for his writing and his combination of logic, sharp logic, great humor, and just, simple stylistic things I taught my students all the time. Very sentence structure. So that's why the ends of his paragraph and his zingers are so effective, because you get these long sentences with citations and parentheses, and then you get these zingers at the end that are just very, the voice is very different, the tone is very different and striking and memorable as a result.
Well, why don't we open things up to questions, if anyone has any, in the back there?
Hi, Joshua Katz, AEI. So two of you mentioned Brian Garner, but you didn't say anything about the relationship between him and the justice. Here are two men, both, I think, grammatically like-minded, but politically perhaps not entirely aligned, both of whom worked magic separately and together. So how did that work between the two of them? Who taught what to whom, who influenced whom, and how?
Jeff, do you have any insights on that?
Well, I mean, in Brian's words, they were fellow snoots. That people really cared about language, grammar, et cetera. And I think, I think initially it was really a good relationship, because I think the justice appreciated what Brian was doing. I think Brian got a lot out of affiliating with the justice, particularly with these two books. The areas of expertise of the two books are really a little more the justice than Brian Garner, but interpretation does involve grammar, language, et cetera. So I think that made some sense as a partnership. I do think certainly at the beginning they enjoyed each other's company.
They liked, to build on what you were saying, they liked talking about language. They had great conversations about that. Brian talks about conversations about the word Nimrod, for example, and how the meaning of that word has changed. And those are the kinds of conversations my dad loved. I've been given credit for bringing them together, and I'll happily accept it. Brian wrote Dad something about. I guess it must have been about one of his editions of Garner's English Usage, and my dad hadn't heard of Brian Garner before, but I was teaching an essay by David Foster Wallace, a review of that book that praised the book effusively. So I told my dad that, you should meet this guy. He's really good, and that's where Wallace is the one who came up with that word snoot to describe. Basically, language mavens. But the work on those books, some of the memories of my dad working really hard on writing. One summer in particular, I think it was a deadline for reading law, and I was at our beach house on the Outer Banks, my parents' beach house. I was mooching off them for a week or two, and my dad didn't leave the house. He was just working. He was just in his little study there, calling. I don't know if he was calling clerks or calling Brian. He was on the phone a lot, discussing draft changes and things like that. So it was a really difficult project, but absolutely worth it. I mean, everybody here has called it a treatise, which I don't know if that's what they had in mind when they were starting it. People elevating to that level, but it's great.
Yes, sir. Let's wait for the mic.
Thank you for this. Much is said. We've heard a lot about the relationship with Justice Thomas. I was wondering what could you tell us or share with us about the impact of their writing relationship. We understand that sometimes during the drafting of an opinion, they call each other and say, what do you think about this? How does this ring or sing to you?
Yeah.
Is there any additional insight you can give us as to how that might have helped iron sharpen iron?
Well, Jeff and I would have, whatever knowledge we would have would be from Justice Thomas's first term, when we were with Justice Scalia. I mean, I think they really didn't know each other before Justice Thomas came on the court, but I think they formed a pretty fast friendship. And they were often a lonely duo there, so it's not surprising that they would find comfort in talking with each other.
I think Justice Scalia was thrilled when Justice Thomas came on the court because he really perceived him as the only other person that was thinking about originalism and textualism. And so I can't think of an instance where they were trading wordsmithing ideas. What I can say is they talked a lot that year. And so, I think it was actually really valuable for both of them. Put yourself in Justice Thomas's shoes, not an easy confirmation hearing. And Justice Scalia is welcoming with open arms. And in the other direction, Justice Scalia is saying, wow, I've got a fellow traveler here. And so pretty quickly they hit it off. And they both have a good sense of humor. I don't know who would be the one to laugh first. Justice Thomas has a deeper laugh.
Justice Thomas has a world-class laugh. I mean, it's, Anyone else? Well, thank you all. That concludes our symposium.
Thank you. Thank you, Ed.